I always wanted to serve on a jury.
I'm really super excited to be here, so I really appreciate you having me. I'm looking forward to it.
Creating this whole trial, Daddy.
I want to give a big shout out to the 13th Juror podcast and Brandi.
Yeah, I applaud you guys. Keep doing what you're doing.
That every time you run into Phil Barber, you should reach for it.
And then I just looked to the jury, and it's sort of like, look.
I was in the eye of the storm, and you guys were watching the storm.
Hey, if you're bored of work, come pop in and say, hey, we'll have some coffee.
You are a ray of sunshine, and I love what you've done with your YouTube channel.
Hi! I am having so many issues. So many issues. Let's see. I don't know if I can't tell if it's even live or not. I keep having this thing that comes up and says that, that StreamYard is thinking and stuff. So whatever, we're just going to go with it. If you can see me, hi. If not, maybe I'll be here at some point. I don't know. Hi. But hello. We're off to a good Friday. It's Friday. It's Friday. It's Friday. You can see me. Hi, my friends. Hi, my friends. I am excited. We are going to get right into it because we have today. I finished the podcast yesterday. I finished it. So I am going to try to get us caught up today. That's the plan. We're going to see how quickly we can go. I would like to get us caught up as much as we can today, since I don't have the podcast to work on today. I finished it last night. So we're going to try to get caught up today. I had some errands to run this morning. I stopped and got me a McDonald's coffee. So we are ready. What else do you need in life other than a McDonald's coffee? So we're going to start off with yesterday's stuff. Let me get it. Share screen. Entire screen. Share audio. Here we go. So we're going to start off. We're going to jump right into it, y'all. I am excited. We're going to see how much we can get caught up. Yesterday we listened at 1.5 speed because they talk so slow. So we'll start there today. If any of it gets too fast, then we'll go from there. Okay, here we go. Here we go. Here we go. Oh, of course, we start off with paper rustling, shuffling. Thank you. Oh, before we even get started, let me tell you, speaking of the podcast, I am so excited about the next episode because I heard back from the engineer with all of the tech stream experience. I heard back from him and I had a conversation with him, and I'm going to put a lot of the chaos that's happened since then on the next episode, and I'm going to try to get that in there too. If I can, it might be the episode after that, but I'm going to go over all of that stuff. But I am so excited about that one. So excited.
Yesterday I had brought
I
up
love
that
hearing
an
from smart
anonymous
people.
reporter had come up to the 9th floor and spoken with the deputy who's there at the desk with some sort of information. This morning, 5 minutes ago, I was provided a letter from a law firm in West Palm Beach dated yesterday. It says that it was sent to the state and the defense. Did you each get a copy, State?
Yes. I did, and I responded late last evening, Your Honor, and a copy of Your Honor's chambers as well as the thing. Yes.
Oh, I don't have those responses.
He just said thank you for sending it. I said
Yeah, this is yesterday.
I realized I was looking at the wrong email.
I thanked him. I told him it was worthy of calling it to the court's attention and that I was confident Your Honor would probably conduct a hearing as a result.
That's what I'm doing. Do you want to be heard on this, State?
No.
Defense? Do you want to be heard on this?
Yes. I'd like the court to question the jurors individually. I don't know Like the lawyer said, whether or not the potential juror heard it, I have every confidence the court can do it delicately and first find out if which juror, if any, was exposed to that, and then find out if they heard anything that had any impact at all on the perception of the case, and that was extrajudicial in the sense that it was a reference to something that had not been introduced in the court.
All jurors or just male jurors?
Judge, I would suggest respectfully all the jurors, and I
Even though the letter says it was a male juror?
yes, because that's what this anonymous source said. But I think to be safe, to the extent there was some jurors in this location, there's limited places to go for lunch around here, Judge, so potential that there could have been other jurors there as well. And rather than run the risk of not knowing, I think a simple inquiry by Your Honor would put that to rest.
State.
And Judge, I would just recommend that maybe we ask the group these general questions, and if anybody says that they've heard anything or seen any news or anything talking, then we can talk to them individually, because these people may not have had any information. And then we'll spend time doing an individual on it.
The concern with that is, in my experience, respectfully, any juror that was exposed to that may be very anxious about acknowledging it.
All right, thank you. I'll bring them in individually to ask about that. Of course, we've already discussed Dr. Quintel when we came back from a recess. He was approached by a reporter in the hallway while he was in the middle of testifying, but on a recess, asked if he could be, the reporter asked if he could ask questions of Dr. Quintel. Dr. Quintel said no, and the reporter gave him a card. That's my understanding from Dr. Quintel.
Yes, sir.
Anybody want to be heard on that?
Did not take it.
You want to be heard on that?
I'm sorry, I just wanted to add that Dr.
All right, do you want to be heard on it, though?
No.
No.
After hours yesterday, I was contacted by Judicial Security and notified that a witness who testified and had not been released from subpoena, and again, this is second or third hand, and it's my understanding both parties have been made aware of this, was being interviewed by a news channel reporter in the hallway outside of the courtroom. When deputies were locking up, someone told them that this was going on. I don't think the deputies actually saw it, but it was reported to them.
And Judge, I spoke to a witness, and there was a discussion with the media, but nothing was talked about with what was going on in the trial or testimony or anything like that. And I've spoken with the witness and asked them not to do that anymore before the trial's over.
This is the first I've heard of that, Your Honor. I want to know who the witness was.
The reason I didn't speak in specifics is this is all hearsay within hearsay within hearsay.
I understand.
It was reported that it was Eva Benefield gave an interview to a reporter from News Channel 8.
Give me a moment, Your Honor, please. I believe she's under state subpoena.
Yes.
And did the state request that she remain available under the subpoena?
Yes.
Hold on, I have to see something real quick, because he talks at normal speed, and I just need to see how he sounds in normal speed for a moment.
Okay. I think perhaps a hearing may be
All right.
And the state would not be opposed to a hearing. I can represent that this particular witness did not speak about anything that was prohibited by the rule of sequestration. No one said to this witness, you're not allowed to talk to anybody about the case, just your testimony and the witnesses in this trial going on right now. So.
All right. Go ahead.
So.
I want to hear.
Compounded, but to the extent we're doing housekeeping things now, we also have an issue, Your Honor, with an impeachment witness to Stephanie Murphy.
Yep, nope, can't take it.
Specifically Faith Brown,
Nope.
who was representing Miss Benefield during the
So much better.
proceedings. She was not on our witness list, but given the testimony of Miss Murphy, we are going to have her outside this afternoon, and the board may want to conduct a Richardson hearing as to that. So just for planning purposes.
All right. You understand that Faith Brown may be called as a witness?
Yes.
All right. I wasn't going to get too involved in the Richardson hearing yet. It needs to be done, obviously, and I've got a note for that. All right. So on the Eva Benefield potential interview with someone at News Channel 8, you're not asking for any relief. I don't know what relief you're going to ask for, but if you're asking for some relief, I'll let you get started.
Well, the relief I would ask for initially is that she obviously be barred from being called as potential. secondarily, to the extent the court admonished her about doing exactly that which she did, I've observed thus far the court's general admonishment that it gives to witnesses. I'm assuming Ms. Benefield received it as well. Is she in the courtroom, by the way? Ms. Benefield?
Here she is, yes.
Yeah, I'd like to have a step out.
All right, ma'am, if you please remove yourself from the courtroom.
Remove yourself at once. Sounded much more dramatic.
I'm not looking to hurt her, but given her disregard of the court's admonition, I think precluding her from being called as a rebuttal witness at a minimum would be appropriate. Whether or not the court feels any further sanctions are appropriate as a result of her disregard of the court's warning, I defer to you all.
Did you want to be heard at all?
Judge, I would just dispute that she violated exactly the court's order. And if she does testify, she will testify consistently with what she has already testified to in a deposition. So counsel will know if that changes, but we know what she's going to say because she said things already in the deposition. So I don't think any potential harm has come from this.
Rebuttal? All right. Whenever we talk about having a hearing, my assumption at the beginning of that was that it was going to be evidentiary and people were going to call witnesses and present evidence. Here's what the court knows. Someone told a court deputy that they observed Eva Benefield giving an interview to News Channel 8 reporter in the hallway outside of courtroom A after court had concluded for the day. At this point, I have no facts or evidence before me. I've got hearsay within hearsay as to something that happened. Yeah, so I don't.
I'll call it.
Well, I gave you that opportunity. That's what I'm saying is that if everybody wanted a hearing, then
All right, well, I took it for granted that the court would.
I'm not going to assume this is true.
Yeah, so court likes, I'll be happy to call him and we'll have a brief hearing.
It's up to you. All right, can you call Ms. Benefield back in? State, just looking at the list, you have 3 witnesses left?
Yes.
All right. Do we expect to finish today with the state's case? Come on in, ma'am.
Do we know which deputy reported the matter? No. Or any of the deputies in the courtroom that saw the conversation like yesterday afternoon? Do we know which deputy it was?
As I said, it was reported to me that some unidentified person told the deputy.
Okay, so give us 1 moment.
Are you the one that they told? Okay, right here. Mr. Taylor. Apparently it was reported to Deputy Racky.
I have a moment with the deputy.
Of course, State, you want to be present?
Step into our office.
Oh, I hate that they have to call her in like that.
Ms. Benefield, I'll remind you that you are under oath. Can you scoot a little bit closer to that microphone and just answer the questions in a loud, clear voice?
Good morning.
You appeared yesterday and testified before Judge White in this case, did you not?
I appeared on Tuesday and testified.
Tuesday. Time flies. At the end of your testimony, do you recall Judge White instructing you about having contact with anyone because you were to remain under subpoena? Do you recall that?
I recall.
Okay. And you were here today because the state requested that you remain as a potential rebuttal witness.
Correct.
Now, what did you think Judge White's directions to you meant?
Well, I was told I wasn't allowed to speak on any of the witnesses in my testimony while in the courtroom.
So, I'm sorry, did you finish?
I'm finished.
Did you realize that when you decided to have a conversation with the reporter?
Yes, sir.
All right. Tell us, if you would. I'm just trying to get an explanation. Tell us, if you would, what you were thinking that...
Objection.
Overruled.
As for what you said.
What you were thinking that you felt allowed you to do exactly that which Judge White cautioned you not to.
I was caught off guard in the hallway when I was under extreme emotional distress after being here, hearing different testimonies about my father's murder. And when I spoke to the reporter, I made sure not to talk about any of the testimonies or anything that happened in the courtroom or my testimony.
What did you discuss with the reporter?
Just how I felt about the situation and who my dad's character was as I saw him.
When you say about the situation, you mean about the case, the trial?
Not about the trial.
What situation were you referring to?
My emotional state?
You post on social media?
I do.
TikTok?
Yes.
Any others?
No.
Following your testimony here last Tuesday, did you make any posts?
I did.
Tell us, how many?
3.
3. And tell us one at a time. Were all 3 of them on Tuesday afternoon, Tuesday evening?
1 was on Tuesday.
And when were the other 2?
Yesterday.
Okay. And tell us, as to the first post, what was it about?
I said that I testified.
Okay. And did you have anything to say about your testifying?
I talked about it being on live television,
And what else?
that somebody back home was watching.
I assume you have copies on your phone?
I do.
You have your phone with you here today?
I do not. Not on me.
And where is it?
It's over in the benches.
In the bushes?
In the benches.
In the benches here in the courtroom?
In the bushes.
With the court's permission, may she retrieve it so we can see exactly what it was that she posted?
Judge, I'm going to object if he knows clearly they have to post. So
Well, I don't know.
it's an invasion of her privacy.
Not if it's on social media, but we started off talking about just speaking with some reporter, and now we're talking about a social media post. If you've seen it, and if she's violating the rules, let's just get it out.
Okay. I'm trying to find that out.
So now it's a fishing expedition. If you know a violation, let's talk about it. If not, let's just get moving. We got a jury waiting.
I understand that, Judge. How do I know? Like, she's told us she posted 3 things. How do I know what it's about? What if one of them involved discussions that were inappropriate? How am I to know that? I've been a little preoccupied, and I don't do social media.
Sir, if you have specific evidence, let's talk about it. If not, you have a team. You've got 3 people in court right behind you. I don't know. Maybe they can look it up. But let's focus on what we know about, as opposed to digging into speculation.
I have no further questions.
No questions.
No.
Ms. Benefield, when you had this conversation with the reporter in the hallway, were there any other witnesses around?
Yes. I'm sorry. Let me re-answer that question. None that testified. I think.
Okay, so you're saying there were people standing around,
There were people
but
around.
none of the witnesses in this case?
No, sir. Not that I remember.
Did you talk specifically about the questions that were asked of you or the testimony you've given?
No, sir.
All right. Do you have any follow-up questions to my questions?
No, sir.
Do you have any follow-up questions to my questions? All right, Ms. Benefield, you can step back out. Did you want to call any other witnesses?
No, sir.
State? All right.
Dang. I feel bad for
Ms.
her.
Benefield's out the courtroom. Go ahead, sir. Do you have any argument? You want to seek any relief? You want to argue in support of any relief?
Yeah, I think she violated the court's admonition that the court routinely gives to the witnesses, and as a result, again, I have no personal interest in seeing the young woman suffer, but I do think violation of the court's admonition is sufficient to strike her as a potential rebuttal witness.
Judge, I think you asked her the relevant questions. I think the questions you asked her are the admonitions that you gave her as a witness, and she did not break any of those.
Final thoughts? I'm certainly distressed that, let me say first, the media policy for the 12th Circuit prohibits the media from conducting interviews inside of the courthouse. It is my understanding that our media and public relations person met this morning, or was going to meet this morning with the media to go over the administrative order again, because certainly I think the media is and should be aware of that administrative order and comply with it. The specific incident that we're talking about after hours yesterday, the facts that are in front of me are not that Ms. Benefield spoke about her testimony or the questions asked. But I also have not heard from the reporter, and I have not seen any tape or footage. At this point, I'm going to reserve on the request, and I'll make a decision. If and when she's called again, I'll make a decision at that point. You just have to remind me if we get there.
I'm satisfied, Your Honor. Thank you.
All right, next.
Not all of them. There's a chunk of them.
I don't care about the order. Just start bringing in the jurors one at a time, please.
Judges, Ms. Benefield.
Lego Law, hello. I am not. I will be
Yes.
out of town tomorrow.
But I'm going to give her an admonition. But just, if you tell him to just hold up for a second.
I'm going to try to catch it up. I'm going to try to do.
I'm reserving on whether she can be recalled or not, but I think an admonition at this point is appropriate.
I'm trying to catch up on everything today. We'll see how far we can make it.
Testimony knowing that she may be recalled.
Hello, Mermaid
Yes, Under
Mary.
Marcy's. Sorry. No, hold on.
I keep hearing that today's is obviously big, but I haven't watched
Ma'am,
it
the court has
because
ruled at this point that I'm reserving ruling on whether you're going to be allowed to be recalled as a witness or not in this case. I don't know if that's going to happen or not. I'll make that ruling down the road. But I want to admonish you about the instructions that I've given and the importance of those. They matter and they need to be followed. Do you understand? Yes, sir. All right, ma'am, you can retake your seat. All right.
I want to try to make it through today.
No.
We made it through a full day plus some, like a day and a half in 4 hours yesterday. So I'm hoping that we can catch up today because we're skipping breaks and sidebars and listening at 1.5 speed and skipping all the paper shuffling. Oops.
Provided a letter from a law firm representing a reporter who indicated that during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing you out to find out, did that happen to you? Have you received any information outside of these 4 walls?
No, I didn't go to the restaurant. I was in the car and here in this building.
All right. State, do you have any questions?
No, thank you.
Defense?
No, sir.
All right, thank you, sir. Good morning, ma'am. Just grab that first chair. And could you please remind me which juror number you were?
15.
15. All right, ma'am. The reason I bring about jurors individually is that this morning I was provided a letter from a law firm in West Palm Beach that claims to represent a news reporter. And the news reporter anonymously has stated that during the lunch break yesterday, the reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm bringing everybody out to talk about, have you seen any news coverage? Have you heard people discussing the case? Received anything outside of this room?
No, sir. I go home at lunch.
State, do you have any questions?
No, sir.
Defense?
No, sir.
Thank you, ma'am. Good morning. Just have a seat right there. And could you do me a favor and remind me of your juror number?
20.
Ma'am, the reason I'm calling out the jurors individually is because this morning I received an email, a letter from a law firm in West Palm Beach who claims to represent a reporter. And the reporter has anonymously stated that during the lunch break yesterday, the news reporter walked to a restaurant near the courthouse for lunch. Inside, there was a large screen television playing coverage and commentary of the trial. Additionally, 2 individuals in the restaurant were discussing a witness's testimony. The conversation occurred within earshot of a man who the news reporter recognized to be a juror in the case. So I'm asking everybody, are you familiar with that? Has that happened to you? Have you received any information outside of these 4 walls?
No, I have not.
State, any questions? Defense?
No, sir.
Thank you, ma'am.
she does look mad, doesn't she?
Have a seat right there. That's fine. Could you remind me of your juror number?
Original 42.
42. Thank you. All right, ma'am. The reason I'm calling out the jurors individually is because this morning I was given a letter from a law firm in West Palm Beach who claims to represent an anonymous reporter.
Okay, so can I skip this? We just go through all, is he just going in and asking all of this? Is there anything, for those of you who have seen it, can I skip this part? Or at least skip forward a little bit? He's just asking all of them the same thing?
The deputy has informed me that somebody in the audience was at the same restaurant, and again, this is hearsay within hearsay.
Oh, Dinah, I see what you said that now.
Would confirm that the juror asked for the television to be turned off? Yes, sir. Does anybody want me to find out who that is and have them brought forward? State?
Give me just a moment. No, Your Honor.
All right. So is there anything else we need to take up before we get started with today's case?
Not from the state.
Not from the defense.
Oops. So the one guy says it's him,
To
and it's a nothing
confirm
burger.
about the case or began your deliberations. No one's talked with anybody outside of the jury about this case, and no one has done any research on the people, places, things, or legal topics we've heard anything about.
Yes, sir. No,
All right,
sir.
everybody says no.
Sergeant Brian Keelis.
Oh yeah, Jules. Jules is in there. She's so sweet.
When I'm presiding over the case, as the deputy said, just make yourself comfortable in that chair, get about 12 to 15 inches from the microphone. It does adjust up, down, left, right. There you go. And if you speak in a loud, clear voice, just fine. If we hear you breathing, you're too close.
Good morning.
Good morning.
Please state your name and spell your first and last name.
Brian Keelis, Brianquiles.
Where do you work?
Manatee County Sheriff's Office.
How long have you worked?
Brian.
About 19 and a half years.
What is your current position with them?
I'm the supervisor of the Technical Services Unit.
And you're, I don't know if I said this, you're a sergeant?
Yes.
Okay. And what is the Technical Services Unit?
It's a unit that gets involved in the technical aspects of criminal investigations. One of the responsibilities is downloading data from cell phones and analyzing that data.
Okay. And prior to your current position, what positions did you have at the Sheriff's Office?
Several. I started on the road, moved over to a cops unit, eventually moved over to the Special Investigations Division as an undercover detective for a couple of years. After that, there was a position involved in, again, technical aspects of investigations. It just wasn't called the Technical Services Unit at the time. And that's until I did that position for a number of years until I was promoted, and eventually the Technical Services Unit started, and that's when I started supervising that unit.
And what training and education do you have to do your current position?
I've had probably over around 800 hours of various technical training, some related to cell phones, some related to technical surveillance, but roughly 800 hours of total training.
Okay. And I want to talk about specifically cell phones and how you deal with those. So how much training would you say you've had in cell phones and analyzing cell phones?
It's probably a third of that 800, so around 250, 260, something like that.
Okay. When you do what I call a forensic examination of a phone, what do you do? Just briefly.
It's really a case-by-case basis. There's each phone is somewhat of a research project. There's so many variables, but ultimately that phone will get plugged into a forensic workstation. Software would be used to be able to download or extract that data from that cell phone, and that same forensic workstation will use software to be able to decode or parse that data to be able to review it.
When you download, I call it dump, a cell phone, when you dump the information from a cell phone, is it voluminous?
Yeah, it can be. Yes, it's quite a bit.
Okay. And is it easy to interpret without help?
No, you definitely need a certain expertise to be able to look at it. You need software to make it a little bit more of a convenience to be able to look at it, but definitely need some assistance to be able to do it.
And do you have programs, software that helps you with that?
Yes.
What are the names of the ones you use?
Our main state program is Cellbrite. It helps us extract the data. If it needs to bypass encryption and bypass locks, it'll help us do that as well. There's other programs that we use, Gray Shift, excuse me, as well, to be able to unlock the data and extract it. We have toolkits that I like to refer to of data or of software to be able to use.
And give me a general idea of how many phones you've done this with.
Me personally, hundreds.
That's your five.
I want to say the unit as a whole has steadily done 200 to 300 leading up to about 2002, and that has increased probably closer to about 500 devices for this year alone, I'm pretty sure.
Okay, so the unit 500 devices for this year.
Yes.
And when you use software like Cellbrite or Gray Shift, does it allow you to put whatever data you want, for instance, pick out what you want and put it in an easily readable form?
You can filter the reports that the software displays, and if you only want it to include messages, you can create a report with just those messages, sure.
So for instance, on just your average cell phone, if you did a cell phone dump, you would get messages like text messages?
Yes.
And emails?
Yes.
Internet searches?
Yes.
And all different things that would be on your phone?
If those data transactions exist on the phone, you will typically get those. Yes.
Okay. So this software allows you to pare that down to what you want?
Yes.
In the instant case where you asked to do extractions on two phones?
Yes.
Okay. And I'm going to show you what's been previously entered into evidence as States Exhibit 11 and 12. You can take a look at both of those.
Oops.
Examinations on, one of them belonging to Doug Benefield, the other one belonging to Ashley Benefield.
Okay. And is that the evidence tag that's on there, do you recognize that?
Yes.
And does it have your information on it?
Yes, it does.
Okay. So did you go through the process that you just explained with both of these phones?
There were differences in the process, but they ultimately we were able to get a path to data and produce a report for that data.
Okay. And which one were you able to extract first?
Doug's phone, we were able to extract first.
Okay. And then were you able to extract data from Ashley's phone?
We were able to eventually. It did take quite some time.
Okay. Why did it take quite some time?
That phone, it was passcoded, or it had a PIN code. I want to say it was a 6-digit PIN code, and the software, it took a long time to actually bypass that encryption or that PIN.
Okay. So if you don't have the passcode or a way to get into the phone, your system can do that?
Yes. It varies in length of how long it could take to bypass, but yes, the system allows for that.
Okay. And you called one of those, Doug's phone and one of those, Ashley's phone. When you do extractions of the data, do you get information about identifying who owns the phone?
Yes.
And can you just explain what that is?
A lot of the times, especially with iPhones, you'll have an Apple ID that could be associated with the person that owns the phone. In the contact information, it'll have the owner's information, so it's pretty easily identify who that phone belongs to, especially with iPhones.
Okay, and the one phone, I'm not sure if it's 11 or 12, but you said was Doug's phone.
12.
12. Did that have identifying information?
Yes.
Okay. That identified it as Doug's phone?
Correct.
And then for Ashley's phone, same question?
Yes.
Okay. Did you prepare a spreadsheet for this case?
I did.
And
Oh, I love a
what is on the
spreadsheet.
It was communication between Ashley and Doug extracted from Ashley's phone from September 20th of 2020 until September 27th of 2020.
Okay. And when you say communication, what do you mean?
In that particular report, it was mainly text messaging back and forth. There were a few phone calls and I want to say at least one email, but mostly text messages.
Okay. And did you said you prepared the spreadsheet from Ashley's phone. Did you also look at the information from Doug's phone to compare that information was on his phone as well?
Yes.
Okay. And was it?
Yes.
Okay. I'm going to show you what's been marked as State's Exhibit 98. You can tell me if you recognize that.
I do.
And what is it?
This is the CD containing the Excel spreadsheet that we just talked about.
Okay. And when you said there's communications between the two, if there were any attachments to those communications, would they also be in your spreadsheet?
Yes, they would. Yes.
Okay. And you've looked at this?
Yes.
Yes. And is it accurate based on the spreadsheet that you created?
Yes.
State management evidence states 98.
Any objection to State's Exhibit 98?
No.
Received.
So I'm going to publish the spreadsheet now. If we could turn down the lights and potentially, it's a little difficult to read, potentially shut the blinds. Okay, so I know this is very small, at least from where I'm sitting. I don't know if I have handed you an exact copy, a hard copy, so I don't know what is easier for you to read. I know that print is very small as well.
Sorry, Mrs. Dunn. Can you approach for just a minute?
Sure.
Oh, yes, let's approach and shuffle papers and sidebar.
The one behind you.
I'm going to attempt to read the one in front.
Okay, because I can try and make this a little bigger once we get through what we're looking at. So I have a laser pointer for you that are where that image or picture or video came from.
It depends on each attachment. There could be metadata there that the attachment could have been from a screenshot. It could have been from the actual phone, taken with the actual phone. So it's just, again, case-by-case basis.
Okay, so there is a video on this phone that, and I just want to draw your attention to it, that shows some people at a restaurant. Do you know which one I'm talking about?
No.
Let me...
Shuffle
5.
papers.
Can you tell from what you're looking at where that video came from? Or do you recall from your investigation before where that video came from?
Based on what I'm looking at, it's an attachment from a text message from Doug Benefield to Ms. Benefield.
Okay. And when you looked at Doug Benefield's phone, could
Weed
you tell whether
whacker.
this movie was taken on his phone or sent to his phone?
I don't have a recollection of the actual metadata of the video itself on either phone. This is just looking at it from the attachment perspective, not the specific video itself.
Okay. If we could approach Judge.
Weed whacker. Karen. You look hot.
Try and make this a little
If it
bigger.
sounds like that, we're skipping it all.
All right. So the first column just has the number of the entry, correct?
Correct.
Okay. And the second column is what?
It's just the type of entry it is.
And give me a couple of examples of the type of entry that it is into the phone.
In this timeline, it's labeled as an instant message. If it was a phone call, you would see phone call. If it was an email, you would see email.
Okay. And what does instant message mean? Is that a text?
It's a text.
Okay. And then the third column is what?
It's the direction of that transaction. It's specifically dealing with messages, whether it's incoming or outgoing.
Okay. So that would be incoming or outgoing from Ashley Benefield's phone.
Correct.
All right. And then the next column?
It's whether or not that data transaction has an attachment.
Okay. And then the next column?
It's the date.
And the next?
It says time, but it also has the date and the time in the correct time code and time zone.
Okay. You said correct time zone. Can you explain that real quick?
So if you see UTC -4, UTC is what's considered standard time for world clocks. The time.
Okay, we can skip all this. We know this. We've been through enough
I'll
trials. We know
that on
this.
my- And that says UTC if it's easier for you to see.
I can see it fine here. The party is the
Field's phone.
correct.
Okay. And the next.
Of a text message. Sometimes it'll be empty depending on the nature of it.
We know this.
The
We're
source
experts.
Is just the software's way of saying if it was the attachment is the actual file itself.
We know
Metadata,
this.
Where that flames.
Okay.
Let's get to the good
first
stuff.
message
Here we
is
go.
what? If you could just explain to us what that is.
First message, here we go.
Number 1 is listed as a message. It's an incoming message with an attachment, and it appears there's no body to it. In other words, there's no actually text string. It's just the actual attachment itself.
And who is it from and who is it to?
It's from Doug to, I'm just going to say the name that's on the actual.
That's fine.
It says Ashley Christina.
Okay. And is this the attachment?
Yes.
Okay, and if you could just read for the record what that says?
It says, am I now trying to win the favor and approval of men or of God? Or am I seeking to please someone? If I were still trying to be popular with men, I would not be a bondservant of Christ.
Okay. And then the next message is what?
Number 2 appears to be an outgoing message. It's from Ashley Christina to Doug Benefield.
Okay. And how much later than the first message is that?
About 2 hours, it appears.
Okay, and so from Ashley to Doug, and what is it?
The description says loved an image.
Okay, so she loved the image from before.
Correct. That's more of an action than actual writing something out.
Okay.
Yes.
She didn't type loved image.
No.
The phone is saying that she hit some button.
Correct.
To love the image. All right. And then the next message is from right about the same time, and that says what?
Same time, that says good morning. There's another little icon after it, but it just didn't come out on here.
Okay. And then if you could just continue to read.
The next message, number 4?
Right, next message. If you could just say what time, to and from, and what the message is.
So the next message, sent around the same time, 10:36 a.m. It's from Doug to Ashley Christina. It says good morning with a few emojis. And the next message after that, appears to be an attachment, and that's at 11:43 from Doug to Ashley Christina.
And what is the message right after that? Oh, I just went too far. Right after the attachment, I'm sorry.
Right after the attachment?
Yes.
It would be number 6. It's a message at 9:20, 11:43 from Doug to Ashley, and it says run baby run with a few emojis.
Okay. And so now I'll just play the attachment. Okay, so Doug says run baby run to Ashley, and then what does she do?
That would be number 7. It's a instant message right after. It's at 12:16, and it just says laughed at a movie.
Okay. And if you can just keep reading.
Number 8 would be an outgoing message. It's from Ashley to Doug. It's on the same date at 12:16 p.m. It's just a few emojis. They appear to be laughing emojis.
And you don't have to mention the times right now until it switches a large timestamp, so go ahead.
The next would be an incoming message from Doug to Ashley asking ready to rock and roll. The next is from Ashley to Doug. Give me a few LOL, trying to round up the cats. It's like trying to teach a ballet to squirrels. The next is an incoming message from Doug to Ashley, says ha with exclamation points. The next is...
And we've established that it's all either from Doug to Ashley or Ashley to Doug.
Correct.
So if you can just say who's speaking and then the message from this point.
Number 12 from Doug. He says, that's funny. After that, it's from Doug. It says he's liked, give me a few. It's basically liking a previous text message and it just repeats.
Okay.
The next is an outgoing from Ashley. It says, OMG, I'm exhausted, LOL. The next is also from Ashley. You can come over now.
Now, I didn't ask you about the color coding on this, but what do the colors mean?
It was just to make it easier to read which one was outgoing, and on all the outgoings, which is Ashley's phone, are Ashley's phone, and the incoming is the other color.
And so the outgoings are what color?
The outgoings are the blue-gray.
Okay.
Yeah.
Or
I'm sorry, blue-gray. The outgoing is the orange.
the orange. Okay. So if Ashley's speaking, it's orange. If Doug's speaking, it's gray.
Correct.
Okay. So I believe we ended at OMG, I'm exhausted, LOL. Go ahead.
I believe I had stated the outgoing message. You can come over now. Number 16 from Doug. Hot. Need to video the rodeo. Okay, headed that way. From Ashley, she responds. She liked what he had said earlier and just repeats. Incoming from Doug. I'm walking around to back. The response, I could let you in the front, or which, and then adds to that, whichever. He responds, okay, front good. She responds with a thumbs up. He responds, me and XS boxes arrived. She responds, LOL. He responds with a message that includes an attachment without a body. Then there's a call log, which is number 26. It's an outgoing call log to Doug for, I believe, 11 seconds.
Okay. And then let me scroll down on here. After the phone call, what happens? Oh, let me back up just a second. What time was that phone call?
Same date, 9/27/24 in the evening.
And then at 8:58 in the evening, that next entry, what is it?
It is a message from Doug. It says, good night, sweetie, theta waves, with a couple emojis. I'll be done by 1 tomorrow and plan on joining the party.
So all of these are like very calm and
then there's an outgoing, and then again, another action
normal.
of just loving that that previous text message. And then there was a response at 9:23 that says good night with a couple emojis. Ha, you sure you want to come hang out with the slum? ? And 9:23 he responds, yep, be smeshin' at the slummin'. 9:24 there was again an action of laughed at the previous message.
Okay, so that was at 9:24 p.m. and it looks like the next entry is at 7:36 a.m.
Correct.
And what is that?
That is believed to be an attachment without a body. It's a long string of characters, JPEG image.
And that came from Doug or to Doug?
That was from Doug.
And I'm going to display the attachment. You don't have to read all of this, but what is this?
Just another Bible verse.
Yeah, because it kind of goes to state of mind.
So after the Bible verse, what is the next thing that happens?
She appears that she loves the image and then responds with good morning. He responds back with good morning with several emojis, and hours later responds with or says headed that way in about 30 minutes.
So that's approximately 3 hours later. He says headed that way in about 30 minutes.
Correct.
Okay, go ahead.
There's a response from Ashley that says, oh, hey, wow, you done for the day? Don't rush because of us. We're out for a walk now. Not in a rush to get started today, LOL. We'll have to round up the cats when we get home anyway. There's a response from Doug, oh, nice, a little breezy, which helps. Getting early start so can finish up early to come over and be with y'all and play W. Emerson, typically shorthand for with. Emerson, free y'all up some. Just ping when good to head over. And Ashley responds with a like of that previous message. And then responds with will do, and also adds in a new text message, want to grab a can opener at Publix on your way over, ? LOL. I of course packed the one we had. He responds, ha, too funny. Yep, we'll get one. She responds, thank you, trying to get the cats, LOL. And after that, there's an incoming message, appears to be an attachment as well. And that was it.
Go ahead. Some of these attachments don't open on this computer. Can you explain kind of why that is?
I think that one of the previous videos that you had, sometimes it's a codec issue. The files are actually not necessarily embedded in the actual spreadsheet itself, but I can take the same file and bring it over to another computer, and it might open. It just depends. It depends on the computer how it's set up to open that particular file.
Okay. So after the attachment, I'm trying to slide this back over. Let's see. Let me try to open this. Okay, so this is one that will not open. So I slid it back over. If you could tell us again, starting at 46, I believe it is.
Well, after that attachment, it's 45.
Or 45, sorry.
And it's an incoming, says from Doug, in the crazy loop at gay, G-A-Y-E. And it's probably a misspelling because he corrected himself and put gate in the next message. There is a call log that has 0 seconds to it at 3:17, and then an incoming message walking around back, and then...
So the walking around back is approximately what time?
3 o'clock in the afternoon, or 3:21.
The next message is approximately what time?
9 o'clock at night.
And that message is?
Good night. And she responds at 9:22 with good night and looks like a sleeping emoji.
And the next communication?
The next would be an incoming message from Doug to Ashley, appears to be an attachment, some type of JPEG image.
And you don't have to read this, but what is it?
It's another Bible verse. I believe we're on, after that attachment, we're on 52.
Yes.
It is an incoming message from Doug. It says good morning with some emojis. Hope you slept okay. She responded at 9:28. Loved the image, or loved an image, and also an additional good morning. Doug then emphasized the good morning, just another action that he took on a previous message. And the next communication was at 11 o'clock a.m. with a wave emoji, looks like. And at 11:22, he responds again with how's morning. She responds with also a wave emoji at 11:26, then says, good, the scramble to get all the loose ends tied up, LOL. He responds, no kidding, I'm done. Around 1, we'll head that way. Been going since like 3 a.m., LOL. She responds, OMG, 3, why is that? He responds, just to get work done so can pack. Love mornings all quiet. She responds, okay then. He responds, Spark is best friend, LOL. She laughed, another action for that message. And another response from Doug, finished up here, yay, headed that way.
And what time was that?
That was at 1 o'clock in the afternoon, 1:17.
Okay. And then after that?
At 1:19, she says, oh, take your time, no rush in, not in a rush today. And at 1:20, a response, LOL, with emoji, think we all are getting pooped from the efforts. She responds with liked a previous message and it just repeats. There is also a laughed at LOL, again, laughing at a previous message. Then another message at 1:36 says, can you think of anything we need at Lowe's or anywhere? Then there's actual call log at 1:42 that lasts about 49 seconds. And that was from Doug to Ashley. And then at 3:30, there's a message from Doug, headed that way in a few minutes. I'd nothing need. And a message from Ashley, already, we are just out for a walk, still can't think of anything needed at the moment. There's an action liked already, and the message repeats from a previous message. Doing front gate, I'm assuming circle, that's CIRCL, and a call log from Doug to Ashley with 0 seconds. Incoming from Doug, I'm here, and it looks like another call log for about 20 seconds.
And that's about, I'm sorry to interrupt, that's about what time?
That was at 3:56 in the afternoon.
Okay. And the next message is at about what time?
9:26 p.m. It's a message from Ashley Christina to Doug. It says goodnight with an emoji. And then after that, Doug responds, good night, precious girls. And after that, Ashley, again, an action of loving that previous response. And the next several messages appear to be related to attachments.
Okay. So the next attachment I'll put up. Who were these attachments sent from?
These were from Doug to Ashley Christina.
Even with this at 1.5 speed,
this.
this goes so, oops.
So
Stop pressing buttons,
I'm
Brandi.
not getting the lines correctly. I think it's line 87 maybe? At 9:29:35.
9:29:35 is line 86.
Okay.
And that's another action of loving an image.
Okay. And there's one more attachment, I believe. Possibly one more after that. 2. Series of responses from Ashley. Can you tell me what those are?
It's the previous action that we've referenced where she physically takes it. It's not word that she's typing. It's just physically within the operating system of iOS allows you to take an action on an image. In this case, she loved 1, 2, 3, 4, 5, 6.
Okay.
6 images.
Okay. Let me get it back centered again. Message. What is that?
That's at 9:31 at night. She responds, "All these are sweet. Thank you." And he responds with an action that he loved the previous message, and then responds with y'all rock my world with a heart emoji. And she responds again with an action of loving that previous message, and with it's a very small emoji, hard to tell what it is after the action.
And then what's the next entry?
The next is an instant is a message with an attachment, and that's from Doug to Ashley at 6:47 in the morning.
I'm going to pull up the attachment. And again, what is that?
Appears to be another Bible verse.
And if you can continue.
So after, there's a message from Doug, says good morning with emojis, and then also an additional message at 9:28 that says got an email from Stephanie after she talked to Faith. Since order to mediate, we'll meet for 1 hour tomorrow to stop court next week. You dismissed injunction. We sign joint stipulation to dismiss dissolutions and hold until Moreland signs. Order for report. As soon as she signs order, we file dismissal, and we're done. Looks like praying hands emoji and a heart. And then there's an additional message after that. And we have joint session with Dr. Q Friday to wrap up our adventure in Florida, FL, and leave with understanding of double knots and red-blue inversion. After that, there's an action by Ashley Christina that said love an image. And it continues with a good morning. And there's an emphasis by Doug of good morning. Ashley Christina responds, oh, okay, I'll reach out to Faith to follow up on all the above with a thumbs up. Doug takes an action and liking that previous image, and then says, and we're done. Again, praying hands emoji, and also responds, and all in first 10 days of Jewish New Year, LOL. It continues with an action of laughed at the previous message, and then at 9:57, Doug responds, you gotta laugh, September 18th was first day of Jewish New Year, 3 years to date of your Odyssey starting day of ballet launch, Rosh Hashanah, the first of the Jewish days of all. We can call our Odyssey the days of all, LOL. At 10:13, there's an incoming message, says from Doug, so perfect outside, looks like a sun emoji. Ashley responds with an action for those previous messages, which just repeats, and then writes, oh yay, we should do Selby today. He responds, oh yes.
What is Selby?
Multiple M's and yum. She responds with a few emojis. He emphasized the emojis, and then adds, Stephanie just sent Faith joint dismissal of everything except injunction, which Faith has to do, just one pager, and also responds, what time thinking Selby? Ashley Christina responds with the action of liking it, and then says, maybe 1:30ish, I'll text you when we're headed that way with a thumbs up. He responds, or Doug responds, okay, I can come pick you up too. Then adds more time with my baby. Then adds mediation tomorrow by Zoom 10:30 and be quick. Ashley responds with the action of liking that. Then added, sorry, just looking at my phone. You don't need to drive all the back to LWR to get us if you are already downtown. But if you want to, that's fine. Just let me know either way. Doug responds, I'm at apartment. Adds, so pretty, enjoying pool area, finally to work, LOL. The next message is an attachment with no body.
From Doug.
That is from Doug to Ashley Christina.
And I'll pull up the attachment.
That's a pretty pool area.
I don't know why I just closed that.
Feet pics.
And what number were we on?
132, that was the attachment.
Thank you. Okay. So after the attachment, what's the next communication?
It's a message from Doug to Ashley Christina. I'll just head your way at 1:30.
Feet fondlers.
Ashley Christina responds, ha, nice, okay, just getting our things together now. Maybe head over in like 10 minutes. 10 MIN. Doug responds, okay. And then after that appears to be an email from Doug to Ashley.
Okay. And after that?
After that is incoming message from Doug. Do you want to get together tonight or in the morning before mediation and unify the instructions for Faith and Stephanie? Think we are going to need to keep involved until this is done or will drag out. She responds, ha, okay, thumbs up. He responds, thumbs up. Prefer tonight, maybe run over Pandera or in AM, question mark. And she responds, sure, can do Panera tonight.
Okay, so I want to back up a little bit. We were talking about the entry that was the email before that. Does it have the content of the email in this spreadsheet?
Appears there's quite a bit of metadata involved, but the actual content from what I'm looking at is
So all of this is like,
Does it say
everything's
names associated with the metadata?
all of this is like, all of this communication seems like everything's going fine. They're like, have resolutions on things and everything is them working stuff out and et cetera, et cetera.
There's an email address of Stephanie Murphy. It's got at murphylawsarasota.com. There's an email address related to Doug Benefield. And there's, I believe those are the two names that I see that are associated.
Okay. So we left off at sure can do Panera tonight.
Yes. And it adds 8 question mark. She responds with a thumbs up. And that was at 7:27 p.m. And she responds with at 9:55 p.m. with a good night and a sleeping emoji. And he responds also with a good night with another emoji. He adds sweet dreams and then also sends an attachment. Correction, the sweet dreams was the last one at 9:56 p.m. The attachment I just referenced was actually 7 o'clock in the morning the next day.
Okay, so the next day I'm clicking on an attachment. And what is that?
It looks up here, a Bible verse.
And what are the messages after that?
All right, so attachment. After that, there's a good morning with a few emojis. If you want, you can come over here for Zoom. And adds, we can grab bagel in CHI. It's 10 a.m. BT, and by the way, BTW is for short. And then there's a phone call at 9 o'clock, 9:07 with no seconds. There's a 151. It says there's an incoming message with no body. And then after that, there's an incoming message with an attachment. It appears to be related to connection to a Zoom meeting, possibly. And then
I'm going to click on that attachment to see if it will come up. It's one of those that will not come up, so go ahead.
The next, after that, appears to be an ID number and a password typically associated with Zoom meetings, and then a phone call with no seconds. And then 9:38, it continues, where Ashley Christina loved an image, then liked the message, it's 10 a.m. by the way, and then added, ha, oh man, okay, thanks for the heads up. He responded by liking that, and then added, set up here if easier for you. And she responded, that's okay, I guess I should brush my hair and change out my PJs. LOL, I think I can just do it from my phone. He responds, LOL, you can. She liked LOL, you can, and then added quick and easy, LOL.
And what was the time difference between the like of LOL you can and the quick and easy? Approximately.
About 15, 20 minutes.
Okay. And then what was the next entry after the quick and easy?
So it was another action by Doug for that quick and easy, and then added, so nice to experience quick and easy, finally, LOL. Then adds, smashing good. Then adds, PS, you looked great for just rolling out of couch, LOL, and added an emoji. He added, I'm working on brief, head over soon as get to stopping point like 1. She responds with the action of loving the previous message, or one of the previous messages, so nice to experience quick and easy. Laughed at also the PS, looking great comment. And then added, ha, thanks, figured I should put a clean shirt on even if I had PJs on the bottom half, LOL. She adds, and okay, just let me know as you're finishing up. He adds, just to ponder while I finish up, thinking about getting all the cars up here, and I thought was to ship the Cherokee up there by transport, which is $900, and either tow my truck or tow to your Jetta. The U-Haul plus the car trailer is about $1,000. That's for the biggest truck, which gives us plenty of room. The option is another pod and tow one of the cars behind my truck. Overall, price about the same. U-Haul, more flexibility, like taking things straight to storage. She responds, okay, things to think about. Maybe best to have you drive the U-Haul and tow your truck behind. Mom and cats will go in the Jeep, and I'll drive with Emerson in my car. She added, LOL, the Beverly Hill. He added, LOL, the Beverly Hillbillies, coming from them slums. Forget about cat courier requirements, LOL. She laughed at the Beverly Hillbillies comment, added LOL, then added, I believe, several cat emojis. He laughed at the emojis, then added, headed over shortly, brain approaching short circuit. She added, okay, well, give me a bit longer, finishing up mom's closets now so I can get the cats locked up. He added, he liked the previous message, and then there was a outgoing phone call to Doug for 38 seconds. Outgoing message from Christina says, headed that way. He responds, or he took the action of liking it. Added, we done good, LOL. We have Dr. Q at 10:30. Good night, with an emoji.
Okay, so the liked headed that way was at what time?
That was at 2 o'clock in the afternoon.
And then the good night was at what time?
It's at 8:27.
Okay.
At night. It's about 2 of them, apologize.
And then after the good night?
After good night, there's an outgoing, indeed, LOL, good night, from Ashley. And then after that, there's an attachment at 5:45 in the morning from Doug.
Okay. And I'll click on the attachment. What is that?
Another Bible verse.
And the next entry?
Appears to be another attachment roughly 15 minutes later.
Okay. And if you could read what this says?
Live a life filled with love. Another Bible verse, Ephesians 5:2. Okay. At 9:26, there's a message from Doug that says, good morning. Minute later, there's an action of loving an image. Second loving a minute image. And he responds with, Dr. Q's at 10:30. Do you want a CHI? Question mark.
I think that's chai.
Chai. At 9:27, there's a response from Christina that says, good morning. There's a repeated response, previous message. Dr. Q is at 10:30. Do you want a chai? And then bagel, he added to it. She responds, that's okay, thank you. If I do that this early in the day, I'll be done for the day, LOL, but thank you. He added, he liked that message. And the next appears to be an attachment from Doug related to possibly a YouTube video. And that was at 9:56 a.m.
And it's another one that won't open. And then the next entry.
It's at 10:40, 35 a.m. From Doug, are you able to make Dr. Q okay? She responds, yes, LOL, be in a minute. He responds, no rush, he's still not out, LOL. She responds, I know, LOL, waiting for mom to come out so we can swap. There's a message without just a rectangular square there. And then after that, there's 10:42:35. There's an LOL from Doug. There's a phone call. It's
Now the LOL was at 10:42 a.m. and then what's the next entry?
correct. 10:42 a.m. was the LOL, and then the next is at 5:39 p.m., which is a phone call from Doug, and with 0 seconds. Then adds after the phone call, I be here, and then another phone call for 15 seconds at 5:40 p.m. Then,
Your Honor, not to tax Sergeant Keyless because he's been reading for a while, but it's a little tough to follow. I wonder if he could give us the number of the message, so it would be much easier to follow.
that's fair.
And I don't know why, but I think your numbers may be off. You're,
Off different from this.
they might be. Can you look?
IB here is, well, we're not using the numbers that are built into Excel. I want to say
Okay.
the numbers are an actual column. So technically IB
I'll
here,
move this over. That's what you're looking at.
correct. IB
Okay.
here would be 212.
If he gives you that number, are you okay with that?
Can you show him?
Like on yours, 214. Just 214. These numbers here, and that's what he's saying. There's numbers on the Excel spreadsheet. They're showing that's what was confusing. Okay.
Problem.
Thank you. The next chart.
Of course.
So it is an attachment, a JPEG. And that was at 6:43 a.m.
And that is on the next day,
Correct.
correct? 9/26?
Correct.
And I pulled up the attachment. What is that?
That's like a Bible verse.
And then you can continue from there.
All right, so moving forward, 217 is from Doug with a good morning. 218, she loves the image. And 219, she responds also with a good morning. 220, Doug sends ready to start with a thumbs up. 221 is a call log from Doug with 0 seconds. 222, there's a message from Ashley Christina. Okay, I'll text you in a bit with an emoji. I can't tell what it is. Pretty small. Next record is 223. Just one of those action messages, liked a previous message, and it repeats. 224, want to come pick me up, and we can go get the truck.
And that's from Ashley.
And that's from Ashley.
Okay.
And Doug responds, sure, with 225, sure, headed that way. So at 226, I be here, and that's at 12:41 p.m. And then 227 is all the way at 9 o'clock in the evening, and it's from Doug, and it's a good night, sweet dreams. Then at 228, 9:23, Ashley responds with the action of loving the previous message, and also responds with a good night. 2:30, there's another attachment at 6:42 from Doug to Ashley.
I'll pull up the attachment. What is that?
It's a Bible verse. After the attachment at 2:31, Doug sends good morning. 2:32, she responds, loved an image. And 2:33 with a good morning. 2:34, he responds with looks like a strong fist up emoji. And 2:35, there's also an incoming from Doug with just a little rectangle. 2:36, she responds with LOL. 2:37, he responds, what y'all working on? And that's at 1 o'clock in the afternoon. 2:38, about 15 minutes later, she responds, last cram, LOL, using big boxes and getting the last loose stuff packed up and ready. And also responds on 2:39, how's it going over there? Making progress? He responds at 2:40, number 240, at 1:18 in the afternoon. Loose stuff should be a chapter in our book, LOL. Got everything out and in garage ready to throw on truck except couch, aka bed. Pretty much emptied. Taking Sully to get his shots, then to doggy spa to get groomed and stay until ready to go. 2:41, he adds, I'll come there after drop him off at 3. 2:42, she responds with the action of laughing at a previous message, and it just repeats. Another action of liking a previous message, then adds, 2:44 adds, great, could you run by Lowe's before you come over and grab a few large and mediums? 2:45, he responds, sure, I need a few too, which is at 1 o'clock in the afternoon. At 2:35, number 246, which is at 2:35 in the afternoon, it's just a like by her, sure, I need a few, which just repeated from earlier, and then adds, just to be safe, let's do 10 of each just for the last bits here. 2:48 from Doug, he likes the previous message and adds, and 2:49, okay, let me know anything else if think of. 2:50, she responds, tape. 2:51, and also adds LOL. 2:52, he responds, ha, K. 2:53, just finished vet, headed to spa, LOL. 2:54, she laughed at that previous message. 2:55, he says, headed there. 2:56, she responds, okay. The next line, 2:57, I'm here out front. She responds, okay, 1 minute.
Now, when he says, I'm here out front, and she responds, okay, 1 minute, about what time is that during the day?
That's about 3:54 in the afternoon.
Okay, and the next message is at about what time?
3:55 in the afternoon.
And the next after that?
After that, it's 5 o'clock in the afternoon.
So there's an hour and several minutes in between these two?
Correct.
Okay, so after okay, 1 minute, what is said?
Then 2:59, about to head back from Doug, and then the message after that appears to be an attachment at 5:11 in the afternoon.
And I'm clicking on the attachment for the record.
It appears to be
Go ahead, I'm sorry.
it appears to be maybe the U-Haul truck that they're loading up.
And that was sent from Doug?
That was 5:11. Yeah, that was incoming. Yes, from Doug to Ashley.
Oh, Georgia,
And
welcome.
then the next message?
The next is from Doug, and this is number 261. Everything in except couch and 10 medium boxes and 2 cab, LOL. 262, she laughed at the image. 263, she responds, ha, OMG. 264, he responds with trucker on the way, and that's at 5:32 p.m.
At 5:32 p.m., was that the last communication between these two?
I believe so, yes.
Thank you. Judge, can we approach just a moment?
Yes.
Before.
Approach. We get to skip the approaching. All right.
Finish up with this witness's direct. So I'm going to excuse you in the back. It should take about 10 minutes. Telephone, I'll get you back. Talking about answer, and it's my understanding is maybe online. You're not to watch your.
Rehearing the issue, I had a chance to research it. We were obviously working.
If you've got case law Contrary to what people may think, I want to make the right decision. So if you've got case law, I want to hear it.
Thanks, sir. I actually just sent one to the printer because I didn't know if you'd rather have it, but it's called Lumark. I don't know. Lumarquv. It's 44 Southern 2nd. I'm sorry, Southern 3rd, 171.
He said contrary to what people might think.
171. There's a yellow flag, but it's for a different reason. This case was.
Sorry, are you looking it up electronically, or would you like a hard copy?
No, I'll take a copy if you have one.
Oh. Give me 1 second, sir. Sorry.
Oh, that's all right. Is that the only one you've got? No, you can have it.
One at a time. I can do it, Judge.
So they're arguing over a video admissibility.
Judge, they revoked my copy in favor of the court.
Favor of the court.
We're not going to do anything until you get a copy.
It should come any second.
Of course, I can't blame their decision, Your Honor.
Oh my goodness. Hey, Jules.
Referring to is on the second page. It's a short case, luckily. Where my reading of it is there were text messages and photographs, which I think videos and photographs are treated the same in most case law. That's my understanding, my feeling. But that there were images and text messages that could not be authenticated by an ex-wife on the defendant's phone. And the trial court did not allow them into evidence. The third ECA here said the court erred. The images and text messages were found on the defendant's cellular phone.
Can you slow down just a little bit for the court reporter?
The images and text messages were found on the defendant's cellular phone, seized pursuant to a search of the defendant's home through a warrant shortly after the alleged incident. This fact was testified by the state's forensic expert and is sufficient to authenticate the exhibits. Here, those phones have been in evidence since the day before. The contents of them were admitted with a trial exhibit today and not objected to. The only thing is this one video was objected to this attachment. And the state would argue based on this case that we have established this phone was properly searched, properly downloaded, and the material was found on the defendant's phone, the video. On the defendant's phone, and therefore the state argument should be admitted.
All right. Mr. Taylor?
Just 1 second, Your Honor.
He's got to shuffle papers. Oops.
That authentication of evidence merely requires a finding that the evidence is what it purports to be. Well, that's the exact issue, sir. Sergeant Kilas cannot do that. He can only say this is a video that was on the phone. He can't say it's a true and accurate reproduction of what took place on that morning. He doesn't know, for example, who was there that might not have appeared in the video, what the motivation was that brought them there. He wouldn't be able to say whether it was under coercive circumstances. I don't think he qualifies to be able to lay that right in. And the second reason why I don't think this case is not applicable is, in this case, they held that it was admissible because it constitutes evidence of motive. Judge, this is a second-degree murder case. As the court knows, motive in second-degree murder is not an element. There is no obligation that murder be proven. I don't think they can lay the necessary predicate for it.
State rebuttal.
Just that I think defense counsel's arguments go to the weight, not the admissibility. I think this case stands for the fact that we've entered, without objection, cell phones that contain this video, and then now without objection, the trial exhibit with the attachments and the CD. The objection was just to one after, which I think is also an issue, but I think we don't have to get there. But I think this case stands for the fact that once we laid the predicate, that this was a properly searched phone, and that the data on it was properly removed, and the detective testified that everything was in order, then we laid the predicate for the contents of the attachments to also be admissible based on this case that I can't say the first name of.
What was the date and time of this particular message?
The message was, I don't know that you can read the small print on that, but there's a copy, but it is, if you're wondering if it was before the Panera conversation or after.
I want to know the day and time that this attachment was sent.
It was sent 9/20 of 2020 at 6:40 p.m.
What number are you referring to?
Oh, 25.
And the Excel spreadsheet, which is the data dump from the defendant's cell phone, shows it's in blue. So it's from
the defendant's phone. So it's from the defendant's phone to, I'm sorry, from
correct.
the
It's from
phone to the defendant's phone.
right. It's from Doug Benefield's phone
Yes.
to Ashley Benefield's phone.
Yes.
All right. Any further argument? Because I wanted to ask that question specifically.
No, sir.
Anything else?
No,
All right. No objection or no judge?
I thought you said, do I have any further
Anything
argument?
else? And you said no?
I don't. No, Judge, sorry. Yeah.
Okay. Well, as I said, if there's case law out there that is contrary to a prior ruling, I think it needs to be brought to my attention. And what State versus Lumarque, Lumarque, 44 Southern 3rd, 171, at 172 to 173, Florida 3rd DCA 2010 states pretty unequivocally, the images and text messages found on the defendant's cell phone seized pursuant to a search of the defendant's home through a warrant, which it wasn't here. It's my understanding, the testimony that I heard was that they were provided to law enforcement shortly after the alleged incident. This fact, testified by the state's forensic expert, is sufficient to authenticate these exhibits. So the issue is authentication, and that's where I had initially sustained, because obviously there was going to be no witness, this Keyless. Sorry.
He says keyless entry, that's how to remember it. It helps me.
Keyless certainly could not authenticate the video. Just to be clear, I'm not sure, I think it's on the record, that it's going to be a video of the defendant and her mother that's taken by a third party. I outlined it pretty in depth in my order denying the stand your ground. And like I said, certainly the technical services unit couldn't authenticate it, saying that it's the traditional way, that it's a fair and accurate depiction of the events of that day. So then I had mentioned at the bench, perhaps the state could lay the silent witness predicate. However, I don't find that the silent witness predicate was sufficiently laid by the detective Keyless. However, apparently, according to this case, it is authenticated by the fact that it was found on the defendant's cell phone that was seized shortly after the incident. And at this point, it's been sufficiently testified to by the state's witnesses and the forensics expert that he did find this video on there. In fact, in addressing the defense arguments, the 3rd DCA goes on to say, regardless of how these images and text messages might have found their way onto the defendant's cell phone, the state has presented sufficient evidence at this stage. Certainly, they met the admissibility that these exhibits constitute evidence of motive. As we've discussed, motive is not an element. But the state has made the argument in the past and makes today that the entry of these items is not for the truth of the matter asserted, but to show the relationship and interactions between the parties in the days leading up to the homicide and the normal texts and banter and communication of a married couple that is in the middle of a divorce. So for those reasons, I will reverse my prior decision, and the video would be admissible under this case. So we did that specifically so you could finish with your direct, and the ruling is made so that it's available on cross. I know we talked about different options, but I'm glad we did it that way because I think it makes a lot more sense.
So we can recall him and play it, and then we'll attend to it.
Correct. So with the
Okay, so they're going to let this video in.
the jury left, he was on the stand. Right, so I'm just going to put him back on the...
All right, let's get to it. Get to it. Ain't nothing to it but to do it.
So did you speak to anyone about your testimony or their... Sorry, y'all can sit.
Bring the jury.
Witness O sent by Doug to Ashley.
Okay.
Correct?
Oh gosh, I love speed
You don't have the
trialing.
sheet in front of you.
No.
Sorry.
Thank you. Line 25 is an attachment from Doug to Ashley Christina.
Okay, I'm going to play that attachment at this time.
All right, so this is the video. Whoa.
I don't even know what it's doing. I think it's giving you clues that I gotta guess. Get real?
Second word.
Real?
Working mother, not a working mother.
Working mother, not a working mother?
Not a working mother. Better than a.
Some. Oh no, it's running out of time. House. Real house. White. Oh, housewife. Oh, real house. Oh.
Okay, thank you. I have no further questions.
Cross. And Mr. Taylor, do you want the screen or do you want the lights back up?
I'm going to use the screen.
Yes, sir. We'll leave it as is.
Do you want your name?
Good morning, Sergeant Keeler.
Good morning.
I want to make sure that we can establish the contours of your testimony. From the technical services unit, you're capable and authorized to extract this information from the cell phones of both Doug Benefield and Ashley Benefield.
Yes.
You don't know the context about the messages. You just are able to read what's printed.
I can read what's printed from the extraction, yes.
Right. But, for example, there were quite a few Bible verses. you wouldn't be able to necessarily tell us that Doug Benefield's a very religious guy. You just can tell us, here's the Bible verses that he posted.
Yes, I could tell you that he sent a Bible verse.
Okay. And you can't tell us the reason that either party may have had for sending a particular text. You can only tell us this is what the text says.
Correct.
You can't tell us whether the text is true or false. You can only tell us what the text says.
Correct.
You can't tell us if the text is genuine or motivated by fear. You can only tell us what it says.
Correct.
I'd like to pass you what we've marked as Defendant's Exhibit 3 and ask you if you can identify it.
I would object to the on the scope.
Okay, I don't know.
Come here, Brett.
Yes, go ahead. Approach. Let me just zoom through this. Gosh, how long do they approach?
You've heard anything about it? All right, thank you. Keyless. Let anyone discuss the case with you.
Gosh, this is... Oh, they're going to lunch. Okay. Dang, we're going to catch up in no time, y'all. We're an hour and 16 minutes into this, and we're already halfway through yesterday.
The lunch break, and before we bring Deputy Keyless, or Detective Keyless back in, we had left off a bench conference with the defendant seeking to admit and then question Detective Keyless on Defendant's Exhibit 3, which I will describe as, and it's been told to me that these are from Ashley Benefield's phone, and the printout is from Cellbrite, which the detective testified is one of the software packages that they use to extract and organize data and then put it in a readable format. I will note that in looking closer at Defendant's Exhibit 3, the report, the Cellbrite report, has a start time of August 29, 2016, and a last activity of April 19, 2017, and lists 319 attachments. However, Defendant's Exhibit 3 only encompasses August 29, 2016 through December 3rd, 2016, and the page numbers are not sequential. That is, it's page numbers 1, 786, 222, I'm sorry, 222, 2,222, 2,224, 2,233, 2,237, 2,240, 2,263, 2,264, and 2,266, although I'm assuming that's just because that's the relevant portions that the defense wants to get into. Certainly state, I'm sure you have these as well, and
yeah.
May...
Well, I guess one of the issues, Judge, is that we aren't being shown anything from the defense until Mr. Taylor's at the podium, and we have to ask. So I don't know what they're using because they've never filed a discovery in this case. The only thing they filed is a defense exhibit list, which had the 391 things on it. I have something called WhatsApp AB text, but they're not all the same. They're some of the same. And so I don't know what's in that exhibit because we've never seen it more than a few seconds before we had to give it over to Your Honor. And I think we're kind of being sandbagged here because this continues to happen. What happened yesterday with Ms. Murphy, those were items never turned over. May I approach? You don't mind. Thank you.
You've raised a much more fundamental issue. There was no defendant's exhibit, witness list and exhibit list pursuant to the rule?
No, there's a defendant's witness list that was filed on June 21st. There's then something called a defendant exhibit list, which does not cite any rule. It's not listed as a discovery. It was also filed on June 21st. So there's no there's never been a formal discovery filed in the case. And we didn't receive any of the names of the witnesses or the 391 items we got about a month before trial. And in those items are things that aren't clear of how to even deal with them. And I know that's hard to describe, but there's emails. There's a million IAs that would never be admissible. There's a lot of things.
A million?
IA report, internal affairs reports from the sheriff's office, things like this. So I did my best to go through it, but because we're not being shown it until he's standing at the podium with it already marked, I don't know what any of this is. And it feels a little bit like trial by ambush, which certainly under the rules, much of this should have come to us way earlier than it did. But if Your Honor checks the court file, which I have thoroughly, there's never been a formal discovery filed by the defense, and the original witness lists were filed in the late June.
That probably would have liked to have addressed that well before trial. Could have also filed a motion to compel after the, the defense has 15 days. So, all right, please.
they attended a deposition of Sergeant Keyless where we had the specific text messages that the court has seen. They were clearly aware of them. We responded. What we received in our discovery, among other things, was what we refer to as a phone dump, D-U-M-P. Thousands of documents. We have to go through that, searching for what we believe is anything relevant that may impact the trial of the case. Our response was to send that phone dump back and put the state on notice that anything in what they provided to us was fair game, that they should do the same, search it. We treated them no differently, Judge White, than they treated us. It's not realistic, and I understand why we received the phone dump like that. It's not realistic to require them to go through such a massive amount of data and single out specifically what they intend to use, because I know the court well knows this is a fluid process, and as the trial date approaches and it's finally carved in stone and it actually begins to happen, then the attention begins to turn to the nuances.
Okay, so wait. So they used part of the discovery that the prosecution turned over, and the prosecution is saying it's a discovery violation because they didn't tell them which parts they're using? Am I understanding this right?
Of all of the subtleties that comprise a trial of the case. We did the same. We did not know specifically what we needed. But at the deposition, I clearly presented these to Sergeant Keyless, and he acknowledged that they were part of what came out of this extraction through the Bright Line program.
My final thoughts? I'm considering this somewhat of a Richardson hearing. Go ahead.
Judge, I think, Your Honor, well, familiar with the rules of discovery, but the defense obligation is different than the state's obligation. The state's obligation is to turn over everything in the possession of the state. The defense obligation, as it says directly from the rule, is any tangible papers or objects that the defendant intends to use.
Can you slow down a little, please?
I keep forgetting. Any tangible papers or objects that the defendant intends to use in the hearing or trial. It's disingenuous for this defense team to say they're using 391 items, many of which are inadmissible at trial. So, and obviously they didn't follow the dates. We're trying to move this trial. We do not want this case to be continued. We're continuing on the best we can. But now we've come to the point where there are things being offered for evidence that have never been provided to the state, that I can't even find at the same copy in what they provided. They never provided this, anything that looks like this. So that's the problem that we're having. And the obligations are different, as Your Honor knows. And I think that they have not, in this situation, that's part of the problem the state's having, that we feel like we're a little behind the eight ball because their obligations are not the same.
All right, thank you both. So certainly the obligations under the Florida Rules of Criminal Procedure are different for the state and the defense. The state is required to list all information or witnesses that are relevant or material being calculated to lead to the discovery of admissible evidence. They've got to categorize witnesses A, B, and C, provide defendant statements and substance of statements. The defense requirements are different. The defense requirements would be turning over or identifying those witnesses that are expected to be called at any hearing or trial, and disclosing any documents that are expected to be used at any hearing or trial or introduced at any hearing or trial. It sounds to me like the defense got the phone dump and provided it to the state. Certainly, I think the defense is required to notify the state what portions of that evidence that they intend to use at any trial or hearing. But I'm not going to find that there was a willful violation of the discovery rules because it sounds like the defense provided, I haven't heard specifically, it may not be in the format that we're looking at, but according to the defense, they provided the dump from Cellbrite.
Well, and also, Judge, here's a copy of Sergeant Keyless's deposition of May 31st of last year, and these exhibits, proposed exhibits, are attached in his deposition.
All right.
Judge, can I just clarify real quick? The defense did not provide us a phone dump. We provided it to them. They listed it and said it's in our possession. So they did not provide us a phone dump.
Okay, so you already had it.
And they never specifically stated this document from the phone dump will be used in trial.
All right. I do think the defense, you have that obligation, though, under the rules to identify witnesses and tangible objects, documents, things that you intend to use. It's very specific in that regard. So I'm not going to find a willful violation because this has been in the state's possession. But defense, you need to let the state know what you intend to use at trial or hearing, and that also includes your list of witnesses, which I understand has already been done. I don't think I have enough information in front of me to determine whether it's trivial or substantial or willful or inadvertent. Well, the willful or inadvertent I think I can find because the state had all of this. I'm just going to require defense from here on out. You need to identify the exhibits that you intend to use at trial or hearing. All right, so.
If we could just request that be done before we're in the middle of examining it.
And copies need to be shown to the state prior to showing them to a witness.
Of course.
All right, so let's get going on what we were talking about, that being Defense Exhibit 3. And we had an objection. So go ahead as the proponent. The objection's already on the record. Go ahead as the proponent.
Yes. The court wants to take up now the admissibility as it relates to specific instances.
Of Exhibit 3.
Yes. Okay, so we think the predicate has been established by virtue of the 9/11 call and the testimony that was offered by Mr. Sand, especially including the spontaneous, excited utterances of Ms. Benefield that can be heard in the background, that my husband attacked me and I shot him. Now, as the court well knows, I provided Your Honor on May 16th, 2024, with a memorandum use of discovery depositions as substantive evidence of criminal trial. I also had previously filed on July 10th of 2024 a defense request for clarification of court's amended omnibus order. And without beating it to death a second time, I cited the court to Smith versus State, where the defendant was awarded a new trial because the court's refusal to allow various witnesses other than the defendant to testify about specific acts of violence allegedly committed by the victim. The Florida Supreme Court held that specific act testimony of third parties may be admissible as corroborative evidence if it is first shown that the defendant knew about the very same act of violence. So I know that the court is familiar with that, but in addition, I have for the court the following opinion. The Smith case is a pretty good evaluation of this issue, Judge. It's a first district case, September 4th of 1992 at 606 Southern 2nd, 641. It said as follows. Consequently, if there is the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. So I think clearly Mr. Sand and the 9/11 call qualifies, and I'll tell the court specifically why. In the matter, Your Honor, of Henry versus State, which is a second district court of appeal decision found at 290 Southern 2nd, page 73, goes back to February of 1974, Your Honor. What was particularly interesting about this case was the second DCA reversed and remanded for a new trial because the trial court refused to allow the defendant to introduce specific acts of violence. And this is what the court said. The necessary predicate for the admissibility of either the dangerous character or individual violent acts of the victim is some evidence of an act on his part which would reasonably suggest the need for self-defense. They cite several cases, and then they say the following in that same footnote. That prerequisite was satisfied here by evidence that Barrow, the victim, thrust his hand into his pocket, whether for a car key or, as Henry, the defendant, said he thought for a pistol, immediately before the defendant shot him. I have to say, Judge White, respectfully, if thrusting one's hand into the pocket is enough to satisfy sufficient evidence so that it's resolved in favor of the defendant when it relates to specific act evidence, a 9/11 call capturing an hysterical Ashley Benefield saying and witness repeating, "My husband attacked me and I shot him," clearly beats the pants off of thrusting a hand into a pocket. So I think we've established the predicate, respectfully, Your Honor.
Do you have a copy of that case?
Absolutely.
Can I get the citation again?
And I might remind the court, in addition to that, Ms. Benefield had the scratches on her side and the swollen eye. Here is the Henry case, Judge. May I?
Yes. 290 Southern 2nd, 73.
And I have one as well. I don't know if I'm thinking about it now. I'm reading.
Oh my gosh, the paper shuffling.
I haven't read it yet. You can if you want, but I'll probably let them go first. All right, go ahead, State.
Judge, to be honest, we are still going through what they're trying to introduce because this is missing pages from the exhibit that they were talking about. So I can't even speak to exactly what's in that. So I apologize if I get it wrong, what they're trying to introduce. First, Judge, there has to be an overt act, yes, regardless of how that's proven. I believe once that is proven, other acts of violence can come in to show that the defendant's apprehension was valid at the time she had to use self-defense. The only way we know that any of these things added to her apprehension is if she says it did. And the case that I just handed up, the Britton case, is an example of that, where there were prior acts of violence, but because they were so attenuated, they were, I believe, 4 years before, and I will read, it's a highlighted portion on page 2 of the case. With respect to the excluded evidence, however, the trial judge found that the unfair prejudicial effect of the evidence substantially outweighed its probative value, considering the prior incidences' remoteness in time, the lack of connection of intent and the crime charge, and the speculative nature of any real connection whatsoever as far as any apprehension in Britton's mind. I do believe that even if the 911 call substantiates some sort of an overt act, which I still believe the defense has to put that in, but even if it does make an overt act, that these items that the defense is trying to introduce are still not admissible because we have not been informed by the defendant or otherwise that any of these things that the defense is trying to get into went into her apprehension and caused her fear and caused her to react the way she did. Additionally, at least from what I can tell from what I think is in the exhibit, I don't believe there are any acts of violence even spoken about in the exhibit. There's language, there's defendant saying to think of you with anybody else makes me crazy. I don't know that those are acts of violence. All of these cases talk about acts or threats of violence, and I don't find that there are any threats in any of this, or there are certainly no acts that are described in this that have happened. So I would say it doesn't meet that requirement anyway as a prior act of violence. And even if it did, I think we have to have some evidence that this, being so many years ago, played into the defendant's decision to use deadly force. So if you would object, I'm going to respond.
Sir?
We expect to call to testify a domestic violence expert. That domestic violence expert is going to educate the jury, in fact, he should educate all of us, about how domestic abuse is cumulative. It builds and it creates this overwhelming anxiety. As the court knows, this entire case revolves around a 4-year relationship. This is the beginning of the insight that Ms. Benefield gains that ultimately and very shortly thereafter leads to her leaving Doug Benefield. And the court may recall, because I shared a letter with the court, that Ms. Benefield left Mr. Benefield when she left him, describing and explaining how she feared for her safety and that of her child being with him, that he was controlling, that he did the following acts, from shooting the gun to punching the dog. The domestic violence expert is going to say all of these things remain in an abused person's mind, so that on the day of the incident, September 27, 2020, despite the fact that it was at the end of a 4-year relationship, that is why the reaction of Ms. Benefield was appropriate or was not unreasonable given all of this prior history. And that's also why the case law that I provided, Your Honor, says domestic violence expert testimony should be admissible for exactly that reason. So here's what's happening, Judge White. The state just introduced 363 text messages and played a video. Why did they do that? They did that to show, because it's the central theme of their case, look how well they got along. In the week prior to the shooting, smiley faces, they're having lunch at the restaurant, everybody looks happy. The domestic violence expert's going to confirm what Dr. Broder told us and what Dr. Quintal told us, is that in the face of an abusive relationship, getting along and going along is always the best course of action that these women embrace, especially when a child is involved, because it is the safest manner to keep the beast at bay. I believe those were Dr. Broder's exact words, keep the beast at bay. So here is the beginning, where she looks at these messages and she doesn't quite realize the significance of them. But shortly thereafter, once he starts firing the gun into the ceiling and putting it against his head, punching holes in the drywall, punching the dog unconscious, now it's beginning to dawn on her, oh, the guy that I married is not the guy that I thought he was. And now you begin to enter that mentality of abuse. And you begin to develop a survival instinct for it. So that's why you employ to get along, go along. You do not want to do anything to antagonize the abuser for fear of reprisal. And Dr. Quintal told us exactly that. That Ms. Benefield's concern, and the court may recall it was the state that asked this question. Dr. Quintal was Ashley Benefield concerned about the release of the Broder report. Remember, Judge, I served it up on the head of a pin. The theory of the state is that Ashley Benefield killed her husband because the Broder report was going to be released 3 days later. Question, Dr. Quintal by the state. Was Ms. Benefield concerned about the release of Broder's report? Yes. Why was she concerned? She feared a reprisal from Douglas Benefield when and if he learned what she had to say about it. So this is consistent with that syndrome. I think it should be admissible. I think we've established that in the record, she says she was attacked and she shot him, and she doesn't just say it. The court's ruled it was a spontaneous statement. She's hysterical. Even the cops described her as hysterical. In fact, one said he thought she may have been shot.
All right, thank you both very much. Let me clarify. I'm pretty sure the ruling that I made regarding the 911 specifically revolved around Mr. Sant's statements. I found that they weren't excited utterances. I found that they were, some people call them present sense impressions, some people call them spontaneous statements, and therein lay the order. I had specifically, I recall saying that I had not heard about or argument as to the defendant's statements in the background. I remember I said if those were going to be introduced as excited utterances, they would have to be through the witness when he was on the stand. Here nor there was no objection. You could hear certain statements being made in the background of the 911 call. I think both sides are really talking about a macro issue, whereas this issue is much more refined than that. In order to, because I looked as well over lunch to try and find an answer to this particular question, because I think the argument being made by the defense to allow specific incidences of violence or aggression by the victim is new and novel. I think it's fairly unique in arguing that that occurred during the state's case in chief. And I'll start my analysis because I think this is a unique issue. I don't know if it's an issue of first impression here in the state of Florida, but I can say I didn't find a case on it, and neither side has presented a case to answer this question. And so I start my thought process by saying that self-defense is an affirmative defense. So generally speaking, the state must prove its allegations beyond a reasonable doubt. If the defense then wants to assert an affirmative defense, the burden shifts to the defendant to prove, using competent and substantial evidence, that is admissible evidence, by a preponderance of that competent and substantial evidence, that she acted in self-defense or acted under duress or necessity or whatever affirmative defense is being asserted. Then the burden shifts back to the state to disprove self-defense beyond a reasonable doubt. And as has been noted by both sides and the court as well throughout, that the case law, and I also start with Smith, which I quoted in a prior order. And this is, again, Smith, 606 Southern 2nd, 641, and this is at 643. Before a defendant may offer either type of character evidence, which is specific act, of course we know that the defendant has to have knowledge of that, or the reputation, which the defendant doesn't have to have knowledge of. And again, I'm reading from Smith at 643. Before a defendant may offer either type of character evidence, he or she must lay a proper predicate demonstrating some overt act by the victim at or about the time of the incident, which reasonably indicated to the defendant a need for action in self-defense. And then we get into if the defendant lays that predicate and there's the slightest evidence of an overt act by the victim, which may be reasonably regarded as placing the defendant in imminent danger, all doubts as to the admission of self-defense evidence must be resolved in favor of the accused. There's also Warren that we have been discussing. 577 Southern 2nd, 682, and in that situation, the evidence was kept out, and the trial court was reversed on that. There, the defendant sought to introduce evidence that Taylor, the victim, was a cocaine user whose habit had grown progressively over time. The defendant proffered, so the defendant testified that when the victim was unable to obtain cocaine, he became violent and argumentative, picked fights. The defendant also testified in that proffer that the victim appeared to be in the throes of cocaine withdrawal and that he was afraid of her. And the proffered testimony was excluded. And I use that as an example, again, to show my line of thinking that, yes, the homicide defendant can get into these things, but there must be that burden shifting and the defendant presenting evidence affirmatively, competent substantial evidence to prove by preponderance that she was lawfully justified in using force likely to cause death or great bodily harm, or not likely to do so. Finally, there was one other case in Hedges, which is another case I think we've talked about, is 667 Southern 2nd, 420, and this is at 422 and 423. It's first DCA 1996, and it talks about exceptions to character evidence not being admissible, where evidence of the victim's reputation for violence or specific acts of violence are admissible when the defendant knew of the victim's violent acts or of his violent reputation at the time of the alleged offense. This case is from 96. I think there's other case law now that establishes the defendant doesn't have to know about the reputation for violence, but here and there. that evidence of prior specific acts of violence by the victim is admissible if it is relevant, because it is relevant to reveal the reasonableness of the defendant's apprehension at the time of the incident. However, even Hedges says, before the defendant may offer this type of character evidence, a proper predicate must be laid by evidence of some overt act on the victim's part at or about the time that reasonably indicated a need. So the reason I wanted time over lunch to try and find some cases, if there was any cases that had said that predicate can be laid during the state's case in chief, and I was not able to find it, and I looked at Henry, I was reading Henry that the defense produced, to see if it explained factually how the information came in regarding the hand in the pocket, and it doesn't say. It just says that the trial judge excluded evidence and unfortunately it doesn't give any indication about whether that was during the state's case in chief or the defense case in chief.
May I make an inquiry of Your Honor?
I'm sorry?
May I make an inquiry of Your Honor relative to what the...
I guess you can ask, but I'm in the middle of a ruling.
Well, I think it may be relevant, helpful for
okay.
the court's ruling. I think what the court is saying is it's looking for some guidance as to the procedural aspect of whether or not this evidence can be introduced during the state's case as opposed to the defense case.
Correct.
Okay, so...
Right, and that's what I'm making my findings about.
Yeah, and the only thing I would say to the court, directing myself exactly to that, is I don't think any of us, would dispute that self-defense is a recognized justification. I don't think any of us would dispute the 9/11 call, he attacked me and I shot him. The only thing I would say to the court is, to the extent Ms. Benefield is presumed innocent, wouldn't the court rather want a case that says it cannot be introduced during the state's case in chief, rather than assuming it can? I think the defense is entitled to the benefit of the doubt, and in the absence of case law that says the defense may not introduce this during the state's case, I think we should be entitled to it.
All right, thank you. So I did think it was an interesting issue, so I did the research, and this may be the case that ultimately, if it gets to the second BCA or the Florida Supreme Court, where we get the answer saying that unobjected to statements or excited utterances by the defendant on a 911 call played during the state's case in chief would be sufficient predicate for that overt act to raise self-defense and allow prior acts into evidence during the defense cross of the state's witnesses during the case in chief. I'm not prepared to make that ruling today. So I'm not saying that the WhatsApp messages are not admissible. I'm just saying that I don't think they're admissible at this point. So that's my ruling.
So they could potentially still be brought in.
These WhatsApp messages do come in another way. We would also be asking for the rule of completeness that the rest of what was taken out.
Well, that's why I mentioned earlier, because there may be other ones that you want to introduce.
Right. So just to put defense on notice that may be an issue.
So we're going to bring the witness back in, and you can resume your cross.
Okay, so they could still be brought in
Aspect of my cross.
potentially.
Okay, can you step back out?
As fast as I can, but this, then maybe the defense can confirm. I believe these are supposed Google searches.
Right, now we're
searches for certain subjects.
Yes,
that are on
yes,
this
they're on the
phone.
phone,
And
that of which was extracted
Gosh, they hardly had the jury in here at all yesterday, huh?
by this witness.
there are things like, ask Amanda, how do I co-parent with an abuser? Co-parenting versus parallel parenting with an abusive ex, the Good Men Project.
Did you give the judge the date of those?
The first one was, I'm sorry.
2020, Your Honor.
The first one was 5/11 of 2020. That was the ask Amanda, how do I co-parent with an abusive, or the parent with an abuser. The next one was the same date, and that was co-parenting versus parallel parenting with an abusive ex, the Good Men Project. Same day, 6 tips to help you co-parent with an abusive ex. And then there appears to be what I would assume is one of the Bible verses that was sent by Doug Benefield, which says, for the wages of sin is death, but the gift of God is eternal life in Jesus Christ our Lord. Romans 6:23.
No, that one was shown by the state.
Her face.
Just moved past it a little quickly.
So, Judge, I have several objections to this. First, what is the relevance of her searching for these things? Second, she cannot just put on information that she was looking for abuser information without taking the stand and saying that she thought he was an abuser. And also, by her entering this on her own behalf, it's hearsay that she's typing in these things as she's searching. So I would object to any of this.
Okay, relevance. Let's see, Your Honor. These are 5 internet searches on the phone that Sergeant Keyless extracted. First of which is on May 11th of 2020, and the subject is domestic parenting with an abuser.
I'm sorry, it's a search or it's an article?
It's a search, an internet search. This is Ashley Benefield, who, according to the state, as the court knows now, killed her husband to stop the release of Dr. Perota's report. A few months before the shooting, searching the internet for how to co-parent with an abuser, and then again on 5/11/20, asked Amanda, how do I co-parent with an abuser? On 5/11/20, co-parenting versus parallel parenting with an abusive ex, the Good Men Project, and 6 tips on 5/11/20 to help you co-parent with an abusive ex. So the relevance, I think, is acute. Our whole theory of defense is that Doug Benefield was an abusive spouse. We have been denied the opportunity to introduce any evidence of that at every turn based on 2 rulings by the court. The first being the break. Once the 9/11 tape came in, which said my husband attacked me and I shot him together with the swollen eye and the scratches.
The 9/11 thing drives me crazy. I don't know why.
May certainly qualify for the slightest evidence.
I just ruled on that.
All right. Then we find ourselves now in the same position as the ruling that the court just made, excluding the text messages of Doug expressing a murderous...
You said I excluded them? I did not exclude them.
You're not allowing me to introduce them.
I said not now, at this point.
Okay, so that's excluded, at least at this point.
Okay, go ahead, sir. I'm sorry for interrupting. Go ahead.
You're admitted. Now I find myself in the same position, except now the evidence is much more acute and much more corroborative of an abused woman's fear. Here we have, in her quiet, most private moment, what is she doing 5 months before the shooting? She's searching the internet about how she is to get along with an abusive ex-spouse. If that doesn't go to her state of mind about fearing Doug Benefield because he's abusive, I don't know what does. Now, procedurally, I can't provide the court with a case that says you're not allowed to introduce such persuasive evidence in the state's case. Again, I take the position, Your Honor, that the state should produce evidence that says I can't. And if they don't produce that evidence, then I think, at worst, it's within the court's discretion. I think it would be an abuse of discretion to not allow me to introduce this evidence when the state's whole theory that they just spent an hour and a half with this witness was establishing how well she and Doug Benefield got along in the week prior to the shooting. I've told the court several times now, that's the whole MO of an abused woman, is to get along and go along and act like everything is okay. That's why both Broder and Quintal have told the court and told the jury, yes, Miss Benefield was different. She acted differently when she was here and she saw me with Doug. At that time, she would always act deferential, but when she was by herself, she let me know, I don't want anything to do with this relationship anymore. So, Your Honor, I think in the interest of justice and fundamental fairness, I should be entitled to ask this witness to identify this information, which came in the same extraction he did for the state for the last hour and a half.
State response?
Judge, the reason this should not come in is the exact same reason that you just ruled on last session. There are other reasons, if it becomes relevant, if it becomes admissible, but that would be my reason now.
Could I please see the exhibit?
Of course. Yeah.
And the purpose of offering Defense Exhibit 4A is to prove that Ms. Benefield actually made those searches?
It's not being offered for the truth of the matter any more than the state's exhibits that Sergeant Keyless went through are being offered for the truth of the matter. It's being offered for the identical reason. This is part of what was on her phone. It shows her state of mind prior to this incident, and it is relevant to the defense. In fact, it's the backbone of the defense.
Hear ye, hear ye. Oh my gosh.
Made the ruling that the text messages were admissible not for the truth of the matter asserted, and I was not asked to give any sort of limiting instruction, but I believe I had previously either I expressed that or during a ruling or put that in a prior order. The admissibility of those items and documents was established through the state's case. Let me start here. 3 things for admissibility of evidence: authenticity, relevance, and admissibility. So the authenticity for the text that we're talking about, the potential internet searches and so forth, the state provided that case. It came, the testimony is that it came directly from either Ashley Benefield's phone or Doug Benefield's phone, and the case provided by the state, I don't have the site in front of me now, the authenticity was established by the technical services officer explaining when and how he downloaded them. But authenticity doesn't automatically mean admissibility. You still have relevance and admissibility. Relevance, I understand what the defense is saying and how it's relevant to their case. And we've had this discussion on a number of pieces of evidence that the defense is trying to get in. And I understand how they're relevant. I understand the arguments, but I cannot blindly disregard the third prong, which is admissibility. And just because it helps a case or hurts a case doesn't make it admissible. I'm trying to think of, I know you're saying you're not offering it for the truth of the matter asserted, but I can't think of any other reason to put that information, these internet searches, in front of the jury, but to show that Ashley Benefield made these searches on a certain day. And so it's an out-of-court statement used to prove the truth of the matter asserted. I'm happy to consider case law if you have some that says that I'm wrong, but that's the definition of hearsay. So at this point, I'm going to rule that they're not admissible.
I have no further questions of Sergeant Keeley. I would like the next proffer, if I could, for the record.
Of course. Do you want me to call him back in for the proffer? Or are you just going to proffer?
No, yeah, I'm just going to read Defendant's Exhibit 2, anticipated Exhibit 2. These were text messages that were downloaded by Sergeant Keeley.
Judge, can you just copy that and put that into evidence?
Yeah, can you show a copy to the state?
He did.
Oh.
If we can just make a copy and enter it.
Oh, we already have an Exhibit 2, the clerk says.
Yeah, it didn't make it. I had marked it as Exhibit 2.
That's the text messages.
The concealed weapons permit?
No, sir.
That's in.
Oh, I'm sorry, Exhibit 3. I marked it as Exhibit 3, the text messages, and it did not make it in.
Okay, yes. These are texts from Doug Benefield's phone to Ashley Benefield's phone, downloaded by the officer. Right? So you want to put it in the record?
Yes, sir.
All right. You don't have to read it. I mean, it's going to be in the record. So that's 3. Did you also want to do 4A?
Yes, composite.
State, for purposes of the proffer, do you believe that Detective Keyless would testify that he downloaded Defendant's Exhibit 3 and 4A from Ashley Benefield's phone?
I believe he would. Judge, I don't know specifically with the second exhibit, specifically because I haven't investigated that, but I would assume yes.
All right, is that sufficient for your proffer?
Yes, sir.
Do you want Keyless to stay under subpoena?
All right, let's.
That's why
I did it.
Sergeant, I'm sorry. Able to let you go for today. This is still, you can't to restore.
All right, they're letting him go for now.
All right. Well, the Bible verse, that's already in.
Yes.
I'm not denying that at all. Do you want?
Well, I'd like to have it on there because they showed it, but they showed it very quickly.
Oh.
Defendant's Exhibit 5, which is one of the I think this might have been the last one or one of the last ones.
Yeah.
All right, so there's a stipulation to the admission of Defendant's Exhibit 5, so that's in. Thank you, Madam Clerk, for catching that.
Well, it's
Right, 5 is in, 3 and 4.
all right.
Number 4 and not entered. Just get.
I love his facial expressions.
All right, so I'm saying I would receive 5 in evidence. There's been a stipulation to it, but I'm not receiving it?
Correct.
Okay. I don't know what its status is then.
And I think.
Okay, so now we're getting to medical examiner. The jury's finally back in.
Yes, I do.
Y'all, yesterday was an almost 8-hour stream. We are 5 hours into it, and we've only actually been streaming for less than 2 hours.
Microphone does adjust up, down, left, and right as you need. Speak in a loud, clear voice, and we should hear everybody.
Oops.
I will, thank you, Your Honor.
All right, medical examiner.
Good afternoon, doctor.
Good afternoon.
Would you please state your full name and spell your last name for the record?
Certainly. My name is Russell Scott Vega, last name spelled V-E-G-A.
And how are you employed?
I'm the chief medical examiner for the 12th District of Florida, and that includes Sarasota County, DeSoto County, and here in Manatee County as well.
And how long have you been a medical examiner?
I finished my training in 1997, so more than 25 years.
And how long have you been the chief medical examiner?
All right, can we?
Yes, please.
For my undergraduate, I went in
I'm
general
sure he's
specialty
got a lovely resume.
some of the exam.
I'm gonna. And when did you do that?
Then evidence collection.
In the autopsy of Mr. Benefield.
It is.
Thank you. And during your autopsy, are photos taken to document injuries found, if any, on the body?
Yes.
And in this case of the autopsy of Mr. Benefield, were pictures taken?
Yes.
Your Honor, may I approach the witness?
No.
Dr. Vega.
Oops.
I'm showing you what the pre-market states 86 through.
He's going to flip through the pictures. Every day I'm shuffling.
I determined the height and the body length. That's what we measure with the body reclined on the table. I think it's a very close approximation to height. It might not be exactly the same.
Yes, sir. And what was Mr. Benefield's weight at the time of his homicide?
That was 169 pounds.
And the length?
The body length was measured to be 69 inches, or 5 foot 9 inches.
Thank you for converting it for me. And during your external exam, as we discussed, those injuries are documented in these photos as well. Is that correct?
Yes.
Okay, and I'm going to now show you.
Let's shuffle and whisper. Shuffle and whisper. How do y'all watch this live? As slow as it goes. I can't even.
And what are they?
These are photos taken at the time of the autopsy of Mr. Benefield back in September of 2020.
And do they fairly and accurately depict some of the injuries and some evidence that was as they were in September of 2020?
Yes.
Thank you, Your Honor. Thank you. Your Honor, at this time I'd ask to enter states 86 through 97.
No objection. Received.
Thank you. And generally, when you examine Mr. Benefield's body, I'm going to display them here in just a moment.
Okay.
Did you find injuries on the outside of his body?
I did, yes.
And where were they? And we'll talk about them in detail, but generally, where were they?
There was an injury to the right side of his chest, there was an injury to his right shoulder, and there was an injury to his right leg.
And did he have any injuries to his face or head?
No. Well, he did have to his head. Yes, I'm sorry, not his face.
And what type of injury was that?
The injury to his head was what we would typically call in medical terminology, we'd call an abraded contusion. That's a swollen and scraped bruise. And it was on the very back of his scalp at what we call the occipital protuberance, or the lump at the very back of the head.
And what would that type of injury be consistent with?
Typically, it's from falling backward and striking the head.
And when you were looking at his external injuries, did you have some opinion as to what had caused them, specifically the chest and the leg?
Yes.
Okay. And what did you feel that they were?
They were gunshot wounds.
And did you then conduct an internal exam?
Yes.
And did that internal exam confirm what you felt about that they were gunshot wounds?
Yes.
And I'm going to display behind you states 86. Hold on. Okay. And I believe this is generally what we call an identification photo. Is that correct?
That is correct.
And is that Mr. Benefield as he was in September of 2020?
Yes.
Thank you. And then let's first talk about the injuries you said he suffered to the chest. You said that was a gunshot wound?
Yes.
And how many defects in his body were associated with the chest wound?
There was one defect, and that was on the upper right side of the chest.
And is that what we see here in states 87?
It is, although we're also seeing the injury to his right arm area as well. Actually, that's the one that has the marker on it. And the chest injury is just above and to the right of that, at least according to the viewpoint of the viewer of this photo.
And for orientation purposes, this is his right side of his body?
It is, and I'll use the laser pointer to indicate this is the arm injury, and that's the chest injury, just to the right side of his right nipple.
And was there, you said there was only one injury. Does that mean this is an entrance wound?
That's correct.
Was there and there was no corresponding exit?
That is also correct.
And did you locate a projectile that was associated with this chest wound?
I did.
And where was it?
It was lodged in the tissues of the left side of the back.
I'm going to show you states 88. I believe that's a close-up of the injury we saw on his chest.
It is.
And then can you kind of orient the jury as to what we're looking at in states 89?
Yes, this is the back of Mr. Benefield's body. He has been rolled up onto his left side. So what we're seeing here is his back, the head here. So this is the left shoulder. The right shoulder would be up here. This is the left side of his back, and it's this purple area right here that represents where the projectile was lodged under the skin in the tissue.
And did you remove it?
I did.
I'm going to show you states 90. Is that the removal process for the projectile from Mr. Benefield's body?
It is. In order to visualize it and then remove it, I made an incision in the skin, which you see here. And then just for documentation purposes, I reflected the skin with the tip of the scissors so that we could photograph the projectile in place in the tissue prior to its removal.
And Dr. Vega, I'm sorry, I'm going to go back to states 89. Where you described his body, but there's some skin discoloration. Can you explain to the jury why his skin looks red or darker?
Certainly. That is what we call lividity. Lividity is the settling of blood in the tissues that occurs after death when the heart's no longer pumping, and the major force acting on it is gravity. When somebody's lying on their back after death, which is typically what we see, we are of the usual process of putting somebody on their back in a dignified position after death. And so the blood typically does settle into the back, and we see this purplish coloration here, which is a result of that. There's some here as well. This area here where there isn't any discoloration, except where the bullet is because this is where the table was pressing up against the skin, and that pressure kept the blood from settling in those areas. So most of this purple discoloration is lividity, with the exception of this area right here, which is due to a little bit of bruising associated with the placement of the bullet there.
And Dr. Vega, I'm going to show you what's in New York as states 14. Would you take a look at that item and tell me if you recognize it?
Yes, I do.
And how do you recognize it?
This is the projectile that I recovered from the back that you could see in the photograph you had up previously.
And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's back?
It does, yes.
Your Honor, at this time the state would ask to enter states 14.
Objection received.
And Doctor, I'm going to show you states 95. Is this the same projectile that you have there in states 14?
Yes, it is.
And what, if you know, is that red part that's next to the projectile?
This is a small rubber plug that is occasionally found in certain hollow point type projectiles. Not all hollow point projectiles have these rubber plugs, but it's part of the process of creating this hollow point that allows a projectile to expand and deform, as we see in this case here.
Thank you. And so going back to the location of the projectile, based on where the entrance wound was and the where you found the projectile, did you determine a path of travel that projectile took through Mr. Benefield's body?
I did.
And what was the path of travel?
So the path of travel was one of entering the right side of the chest, striking the 5th rib on the right side, the right lung, the 10th vertebral body on the in the middle of the spine, then the left lung, the 10th rib, and then the soft tissues of the back until it stopped where it is. And that path then, if one were standing upright and straight, would be from the right side toward the left, from the front towards the back, and essentially horizontal. In other words, without angling upward or downward. And again, that's relative to a standing upright position.
Yes, sir. And would you mind, would you be so kind as to stand up and kind of point on your body to where the entrance wound would be?
Certainly.
Thank you. And where would the exit wound be?
Well, no exit. But
I'm sorry, the projectile.
Projectile.
Yes, sir.
My mobility is limited, but essentially would be in the back over here, where the tip of my thumb is.
Thank you. And would you just turn back so we can see the entrance again?
Yeah.
Thank you, sir.
You're welcome.
And you said that the wound was front to back. Was it, and from how you showed, you said it was essentially horizontal?
Yes.
It wasn't front to back like it went straight through. Can you describe it?
Certainly. I mean, it went through an angled path through the body, and that angle took it from the front toward the back, but at a greater angle from right to left.
Thank you.
So front to back,
And you said
right
it
to
struck
left.
his ribs and his lungs and his vertebral.
His vertebral body.
Thank you.
The
So
spine.
his spine.
Yes.
And would that injury have been immediately fatal?
Probably not.
And would it have incapacitated, if you can say, incapacitated Mr. Benefield quickly?
I think it would have incapacitated him quickly. Whether or not it was immediate, I don't think one can predict.
Thank you, sir. I'm now going to take you to the arm wound. Was this wound different from the wound we saw in Mr. Benefield's chest?
Yes.
And how so? And this, for the record, states 91.
Yes. What one can maybe not clearly appreciate just from viewing the photo, but was clearly evident at the time of the examination, is that this is only a surface wound. So what you see as the mark on the skin here is the full extent of this injury. So it's an abrasion or a scrape on the skin, but outside of the effect on the skin, nothing deeper was involved with this injury.
Thank you, sir. And then finally you said he was also shot in the leg. Is that correct?
That's correct.
Okay. So I'm going to show you states 92. Can you orient the jury as to what we're looking at on Mr. Benefield's body?
Yes, and this is a little bit of a tough one orientation-wise, but the injury is to the back of his leg. So what we're seeing here is the back of the leg, and it's the calf area here. This is a perforation of that calf. Yeah, I think that's the best way to describe it, the calf area.
And the chest wound we saw entered and did not exit. Was this wound the same or was it different?
It was different.
And how so?
Because this injury did indeed have an exit.
And where did you locate the exit?
The exit was on the right side of the knee.
And Dr. Vega, how can you, and I have a picture of that, but before we move on to that, how can you tell the difference between an entrance and an exit wound?
It's not always possible, but typically entrance wounds have more of a well-defined defect in the skin. Frequently, that defect in the skin is paralleled by defect in the tissues that one can appreciate underneath. Many times, the edge of the skin perforation or the edge of the skin defect will have a ring or at least an arc of abrasion or scraping as the bullet passes through. Exit wounds tend to not have those features. One way that I like to think about this is it's like a very fast-moving awl or punch in that it goes in and it almost drills a hole into the skin, but when it exits, what it does is it tenses up the skin until the skin tears. That's how a bullet exits. So typically, the tear doesn't have the same well-defined drilled appearance that the entrance wound rather does. And in this case, that's exactly what we see.
And I'll show you 93 correct me if I'm wrong, but that is the exit wound associated with the entrance we just saw.
That's
Thank
correct.
you, Natalie.
And I have a close-up. This is states 94. And so can you kind of show the jury how you knew this was an exit wound?
Yes. So this injury does not appear to be a round or drilled type of defect, but rather a tear in the skin that occurred when the skin was stretched until its breaking point by the bullet trying to exit.
And were you able to determine the wound path for this injury?
Yes.
And what was it?
So the wound path started at the back of the leg and went through the musculature of the calf, and then I couldn't tell for certain if the path actually went through the bones or if it passed right next to the bones, but because of blast effect injured them, causing fracture. The amount of tissue damage can make that part difficult to separate out, and that was the case here. After doing that and fracturing the very top part of the leg bones, the tibia and the fibula, it then exited through this exit defect on the lower right side of the knee.
And I hate to ask you, but would you mind stepping down and showing us on your leg where this entered and where it exited?
Certainly.
Thank you. If you're more comfortable, you can. It's easier. Yes, sir.
Mr. Taylor, if you need to reposition so you can see, please feel free to do so.
So on me, the entrance was down here.
If it helps, I can put my finger there.
Okay. And the exit here.
So here to here.
Yes.
And so that's, you said slightly up or up.
It's upward from the right toward the left and from back to front. Yes, largely all three of those components.
Thank you. Well, you know what, Dr. Vega, while you're down here, just for clarification, would you show me again the chest wound? Just because I think you're easier to see now that maybe
Sure.
you understand.
Entrance. Lodged bullet.
And would you just spin one time? Just turn so they can see. Thank you. Thank you so much, Dr. Vega. I appreciate that.
Mr. Taylor, were you able to see
So-
those demonstrations?
Yes, sir, Dwight, thank you.
Dr. Vega, was there any physical evidence associated with this injury that was recovered from Mr. Benefield's body?
From the leg
So
injury?
then he was kind of to the side, like
I'm going to show you states 15. You'll take a look at that and tell me.
front and to the side.
Yes, I do.
And how you recognize it?
This is the lead fragment which was recovered from Mr. Benefield's leg just deep to the exit defect.
And how does this differ from the projectile? Like you're saying fragment. What does that mean compared to the projectile?
Well, as we've already discussed, we have an entrance and an exit here. So essentially, the projectile exited the body. Before it did, a small piece of it broke off and remained in the tissues. This is that piece, and that's what I recovered at the autopsy.
Thank you, sir. And other than having been repackaged for trial purposes, does it appear to be in the same or substantially the same condition as when you removed it from Mr. Benefield's body?
It does.
Thank you. Your Honor, the state would ask to enter states 15.
No objection.
Received.
Thank you. And Dr. Vega, I have a photo of states, this is states 97. Is that the same item that is in states 15?
Yes.
Thank you. Did you find any, I'm going to go back to the, well, Dr. Vega, what is stippling?
Stippling is a term we use to describe certain changes that occur in association with gunshot injuries. It refers to the pattern on the skin or any other target of unburned gunpowder fragments that strike that target and create a pattern.
And did you find any stippling associated with the gunshot wound to Mr. Benefield's leg?
I did not.
Did you find any with a wound associated with his chest?
I did not.
And what, if anything, does the absence of stippling tell you? Specifically, we'll talk about the leg first.
Well, the absence reflects the same principle in either injury, and what it means is that typically when the weapon was discharged, it was far enough away so that the unburned gunpowder fragments, which are ejected with the bullet, had a chance to lose velocity and fall away prior to striking the skin. In general, typically that means that the muzzle of the weapon was more than 3 feet away from the target or the skin in this case, but any more precise determinations require the test firing of a weapon, same weapon or same style of weapon with the same ammunition to try and get more specific information.
And for the chest wound, if he were wearing a shirt when he was shot, would that affect what you would find on his body?
Yes.
Okay, that was why I was asking separately. And so to be clear, you said the muzzle, so would that mean that if, it's not necessarily the body of the shooter, but if they had their arm extended or even here, it's the end of the gun from Mr. Benefield's body?
That's right.
I know you determined a path of travel for, and we're still talking about the leg injury, for this leg injury, but does it tell you this path of travel anything about where the shooter would have been standing?
All it really tells me is the relative position of the weapon to the leg at the time that the weapon was fired.
Yes, sir.
And trying to come up with the relative position of the shooter at the time that the weapon was discharged is much more complicated because both the shooter and the victim, and specifically the victim's leg, can be in multiple different positions and still end up with that required relative position of the gun to the leg and still create this same injury.
And, Your Honor, may I have just one moment?
Yes.
Dr. Vega, if, hypothetically, Mr. Benefield were falling, would it make sense that his legs would flip up in the air enough for this path of travel? Does that make sense?
If this injury were sustained while he was falling,
Yes.
then the injury would be sustained while his body is changing its position and in motion. But regardless, at the time the weapon was fired, the muzzle of the weapon would still have to be, relatively speaking, below, to the left of, and behind the right leg in order to get this particular angle of path of travel through the leg.
Thank you. And can you tell, when you conduct an autopsy, and specifically in Mr. Benefield, which of these wounds occurred in what order?
I cannot.
And once you completed your autopsy, did you order toxicology testing?
Yes,
And was that done in this case?
it was.
And were there any drugs or alcohol found in Mr. Benefield's body?
No, there were not.
And finally, based on everything that you did during your autopsy, did you determine the cause of death?
I did.
And what was that?
I determined the cause of death to be a gunshot wound to the chest that caused perforation of the lung, or the lungs, both lungs, with hemothoraces. It's a fancy word for bleeding that occurs in the chest.
And I didn't ask you this, but I guess, could you explain, so once this bullet entered Mr. Benefield and started to travel through his lungs, what would have been happening inside his body, or what would happen right after?
The primary things that happen there are that very rapid bleeding starts to occur. The bleeding is rapid because the lungs are very vascular, and so when they're damaged, they bleed very quickly. And also, there's no impediment to the bleeding. The cavity around the lung can expand very rapidly to accommodate bleeding. So the bleeding that happens as a result of a gunshot wound to the lung is very rapid. In addition to the bleeding, when the lung gets a hole in it, it no longer holds its shape and its anatomical arrangements, and it collapses to some extent. That collapse is made worse by the accumulating blood pressing on the lung as well. So the combination of physiological effects of bleeding and lung collapse are the primary things that are occurring in the body at the time that, or immediately following the bullet passing through the lung.
Thank you. And did you determine the manner of death in this case?
I did.
And what was that?
I determined the manner of death to be homicide.
Your Honor, may I have just one moment?
Yes.
Yeah, I'm glad she takes the stand on this because I'm going to have to hear her explain it.
Cross. And of course, the question is, do you need this?
I do not.
Yes, sir.
Good afternoon, Dr. Vega.
Good afternoon.
Haven't seen you for a while. How's that new facility that you're in?
Very nice, thank you.
Just a few questions, if I may. I think you told us that the deceased was 169 pounds and stood 5 feet 9 inches tall.
Correct, yes.
Muscular build.
I don't think I use that terminology. I think I just talked about the weight and the body length.
I want to ask you mentioned about hollow points. You know, the public perception about hollow points is that they are more lethal. The fact is it not true that the hollow point is designed to expand when it goes through tissue?
Yes, that's right.
The theory being it's to stop a bullet from exiting and harming someone else.
That's certainly part of the philosophy or utility of having a hollow point projectile.
And when you tell us that the wound was probably not fatal, within a reasonable degree of medical science, and I think you made it pretty clear, you really can't say one way or another that upon being shot like that, he would have dropped immediately, that he may have continued for a couple of seconds.
Yes, that's right.
The stippling issue about gunpowder, it's from a distance of approximately, you told us, 3 feet.
Roughly, yes.
Okay, so when you exceed more than 3 feet, you would not expect to find stippling.
That's correct.
Okay, and you didn't find any stippling on his shirt?
I didn't examine his shirt.
Okay, so if somebody were backing away while they were firing and they got beyond that 3-foot range, there may not be any stippling.
That's correct.
All right. You said that the wound to the scalp was indicative of, you traditionally see it, of somebody falling backwards and hitting a hard surface like a tile floor.
Yes.
I want to ask you just a couple other questions. Are all homicides crimes?
Objection, Judge. No, on his expertise.
I'll allow that the witness has the knowledge to answer. In my experience, homicide, as determined by a medical examiner, has a certain medical legal significance, which does not necessarily imply criminality.
Okay. In simple language, it could be excusable,
Objection, poker legal.
I'll sustain.
justifiable. I think if it's within his knowledge, Your Honor.
No, I'm going to sustain because I asked for a legal conclusion as opposed to a medical conclusion.
All right. You mentioned, Dr. Vega, that you could not determine the order of the shots.
That's correct.
Okay, there is no medical method of being able to say which shot came first, which shot came second.
In certain cases, the physiological findings may help you with that, but in this case, no.
Would it be a fair statement for me to say that for the chest shot, the weapon would have had to have been pointing at his chest from the front?
Yes.
I'm not sure on that.
Let me just check, Your Honor. I think that might conclude.
Hey, 80s.
Last question with respect to the leg. You've told us that the gun would have had to have been lower than the leg to get that upward trajectory.
Yes, although I would say that, lower is a relative term.
Yeah.
And legs can be put into various different positions. And if we're going to say lower, then it needs to be clear that lower means with respect to the leg in an upright position. And if the leg were horizontal, for example, then we might be talking about a position which is above the leg, but pointing up towards the head of the body, for example.
Okay, so let's try to be clear here. If Mr. Benefield fell backwards and his legs went up in the air, might that injury be consistent with that?
Given that scenario, it's possible.
I believe that's all I have, Your Honor. Thank you, Dr. Beck.
State any redirect?
Yes,
Yeah, the neighbor called
Dr.
911.
Vega, I don't want it to be unclear.
When she went over
The gun
there.
would have, for the chest wound, the gun would have had to have been in front of Mr. Benefield's body. That's what you said.
Yes.
But it didn't enter his chest. It entered the front of him. It entered through the side.
Yes, so the weapon did have to be in front of him, but even more so, it had to be to his right side.
And based on your training and experience, is it typical that if somebody were to fall backwards, that their legs would go above their heads when falling?
Without the intervention of something to fall over, an ottoman, a chair, or something like that, it seems unlikely.
And if Mr. Benefield were running, or his legs were up in the back, could the angle have also been accomplished?
Yes.
Thank you, Doctor. I don't have anything else.
That's all.
All right, can the witness be released?
Yes, sir.
Yes.
Sir, you're released from your subpoena. You're free to go. Thank you, Your Honor.
Okay, so
The jury, as with yesterday, would pass these around. These
to the front and the side.
You all finish up. Thing will go back.
Please state your full name and spell your last name for the record.
My name is Daniel Hausdorff. Last name is spelled Hausdorf.
And how are you employed?
At the Florida Department of Law Enforcement, also known as FDLE.
And how long have you been with FDLE?
It'll be 11 years in September.
And what is your title and position?
I'm a crime laboratory analyst in the firearms section.
Yeah, she went over to the neighbor's house
I've
and
been
he
in that
called.
position out of training since August of 2018.
And what are your official duties as a crime lab analyst in the firearms division?
My main duties include microscopic comparisons of fired ammunition components, such as cartridge cases and bullets. I also perform firearm function testing, which means I test for the firearms
Microscopic?
as well as check the safeties. I perform distance determination, serial number restoration, and imaging cartridge cases into our database.
And when you say cartridge, well, we're going to get there. I'm sorry. What kind of training did you receive to become an
Okay, we're gonna skip through the credentials.
ammunition for that?
Bullet.
So the cartridge case leaves the fire. I want to draw evidence the normal procedure.
The normal procedure is the agent should elaborate on that.
And when did you conduct your examination of the items in this case?
I started working this case on March 9th of 2021.
And I want to first show you states number 13. It's already in evidence. It's not open. Would you take a look?
Armory 45 auto pistol that I received.
And how do you know that it's the same firearm that you received in your lab?
It has the FTLA case number, item number, and my initials in my handwriting on both the pistol and the magazine.
Thank you, sir. And what type of analysis did you perform on this firearm?
So whenever I receive a firearm, I'm going to perform a function test on the firearm to make sure that it does fire, in fact, and also check the safeties on the firearm. In this case, there are 3 safeties on this firearm. There's a trigger safety, a grip safety, and a firing pin block, all are designed to make sure there's no accidental firing.
And was this firearm found to be in proper functioning order?
Yes, ma'am.
If Your Honor and the deputies don't mind, is it okay if he removes it to display it to the jury so I can ask him some questions?
3 safeties.
It's empty.
I'm going to leave gloves here if you need them.
It's okay, sir.
Again, Mr. Taylor, if you need to reposition so you can see exactly what's going on, please feel free to do so.
Mr. Hausdorff?
Yes, ma'am.
Would you mind just standing up so the jury can see and telling us the parts of the gun that you just talked about?
Yes, ma'am. So this is the top portion of the firearm called the slide. There's the trigger, where the trigger safety is right in front of the trigger here. There's the grip safety in the back, which is depressed by normal operation of the firearm. There's the firing pin block, which is housed in the slide that is deactivated when the trigger is pulled. And the way that this firearm works is there's ammunition loaded in the detachable box magazine. It's inserted in the grip of the firearm. At that point, I would release the slide and load 1 round into the chamber of the firearm. I would pull the trigger, which is going to cause the firing pin to release, striking that primer on the cartridge, causing a spark to go through the flash hole, and then like the gunpowder, which is going to cause those rapidly expanding gases to propel the bullet down and out of the firearm. But it's also going to cause the slide to move rearward. The fire cartridge case is going to extract and eject out the side. As the slide moves back, it's going to recock the firearm, and then it'll go back forward again, pulling another cartridge from the magazine and into the chamber of the firearm, ready to fire again.
Thanks, sir.
I'm sorry, Mark. Can we put Of course.
Let's approach. Again. Shuffle
Testimony that
papers.
when this firearm was found,
Again.
the slide was not totally seated. Does that make sense to you? Am I saying the right words?
Are you basically saying that it wasn't in battery, that it wasn't all the way forward?
Yes, in battery, that's what he said.
Okay.
And that there was a live round still in the shape.
I'll allow it to set up the scenario.
And that the deputy testified there was a live round that was still in the chamber.
Okay.
Is that something you're familiar with occurring in firearms?
It's a possibility. If the extractor is really tight, if the spring is very tight on that, it's possible that it would not go around the extracting groove on the cartridge. If that happens, it could get stuck back just slightly. I mean, a quick jar to the back of the firearm could knock it over that. But normal operation of the firearm, it should cycle properly. And since I test fired it 3 times, I didn't have that issue when I was firing.
And if it were not seated and that live round was not in a completely normal position, would that prevent the gun from firing?
Yes, ma'am. It won't fire when it's out of battery.
Thank you. I'm now going to show you states 4 through 7, which I believe are your items 3 through. You take a look at states 4 through 7 and tell me if you recognize them as items you previously examined. I messed up.
Yes, ma'am.
Thank
Did
you.
she just say I messed up? Did she just say, wait, did she just whisper I messed up?
You take a look at states 4 through 7 and tell me if you recognize them as items you previously examined. I messed up.
Yes, ma'am.
Yep.
Thank you.
I don't know what she
And
messed up.
how do you know these are items you previously examined?
They all are marked with the FDLA case number, item number, and my initials in my handwriting.
And what are these items?
These are the fire cartridge cases that I received in this case.
And what is the caliber of these casings?
They're 45 auto plus P, and the plus P just stands for higher ammunition pressure.
And what does that mean, higher ammunition pressure?
It means they're loaded to have higher velocity.
And velocity is the speed at which they travel?
Yes, ma'am.
And how do you know the caliber of these casings?
It's written on the head of the cartridge, which is right back here.
And is there a name for that end of the cartridge?
That's the head.
Thank you. And what type of examination or testing did you conduct on these cartridge cases in states 4 through 7?
So these cartridge cases, I performed an examination that I was trying to compare these cartridge cases to the test fires that I created from this firearm to determine if they were fired in this particular firearm.
And how do you accomplish that?
So when I test fire the firearm in our indoor laboratory range, I use laboratory ammunition that's similar to the evidence that I received in this case. So I test fired 3 Hornady rounds that were 45 auto, which is the same brand that I received in this case. After I get done test firing it, I take the cartridge cases and the fired bullets that I received back to my office where I compare them under a comparison microscope. It's 2 microscopes joined by an optical bridge that allows me to view 2 objects at the same time under the same magnification. So what I'll do is first look at my test and I determine what's the repeating pattern that's coming from the firearm itself that's being transitioned to the cartridge cases and bullets during the firing process.
Can I stop you there?
Thank you,
Just gonna
Erica.
talk about that part.
Yes.
We're really going. And so you said you first look at test to test. And can you explain slowly
Yes,
how,
ma'am.
what you're looking for to compare those, to see your test and what you're looking for to determine that?
I'm looking for the reproducible pattern that's coming from the firearm. So what happens is when the cartridge case is fired, or the cartridge is fired, the cartridge case will expand back and make impressions from inside the chamber of the firearm, as well as this end of the firearm, which is known as the breech face. And this is where the firing pin comes through and strikes the primer. All that pressure is going to push the cartridge case back against those areas, and all the microscopic imperfections within the firearm are being transferred to these cartridge cases during firing. The reason is the firearm is the harder object, the cartridge case is the softer object. The same thing is happening with the bullet. The bullet is going to expand, also known as obturating. It's going to seal all the gases in the barrel, and there's rifling inside the barrel, known as the lands and grooves. It's going to seal all those gases. The impressions are going to be transferred from the barrel to the bullet.
And when you look at your test fires, you said there were 3?
Yes, ma'am.
Did they all have consistent patterns on them?
Yes, they do.
And so once you determine that they in fact received consistent patterns, what's the next step?
The next step is to take the one that has the best representation of that firearm. It's essentially, if you think about it, you're making like an ink stamp on the ground. It's the same stamp, but depending on the pressure, the angle, it's not going to look exactly the same. So I'll pick the one that has the best representation of everything from the firearm. And when I do that, I'll place one of those test fires on the right side of my scope, and I'll take one of the unknown cartridge cases on the left side of my scope. And when I look at them on the oculars, I overlay the images on top of one another, and I can see the patterns repeating between one another.
And once you compared your test fires to the cartridge cases in states 4 through 7, did you make a determination about their relationship to this firearm?
Yes, ma'am. All 4 of these were in fact fired in this firearm.
Thank you. I want to now show you states 8, 9, 10. And 14. Would you like to take a look at these items?
Thank you.
And tell me if there are items that you've previously seen in your lab.
Yes, ma'am.
And how do you know?
They all have my markings on the base of the bullet with the FDLE item number, case number, and my initials in my handwriting.
And how are these items different from the cartridge cases we just talked about?
These are the bullets that are fired from the firearm.
And are you able to determine the caliber of fired bullets?
Yes, ma'am.
And how do you do that?
So what I'll do is a couple different ways. I'll measure the base of the bullets as well as the weight, and if I have both of those, that'll already give me my answer like that. And in this case, all four of these projectiles were intact, so I was able to tell the caliber just based off of that.
And what was the caliber you determined these bullets to be?
They're in .45 caliber class.
And that's the same caliber as the casings in the firearm, is that correct?
That's correct.
And what type, other than the weighing the measurements, what type of examination or testing did you conduct on these projectiles or bullets?
So I did the same thing as the cartridge cases. I examined the test fires from this firearm to the bullets here, determining if they were or were not fired from this particular firearm.
And once you did that comparison, were you able to, did you determine?
Yes, ma'am.
Okay, thank you, sorry. And I got distracted. And what was your finding?
That all four of these bullets were fired from this firearm.
No, I think the first time you said fired in, and then you said fired from.
The reason I just say in is the cartridge cases are technically in the firearm, and I say from because the bullets leave.
And so there's really no difference other than it's technical?
Yes, ma'am.
Thank you, sir. Finally, I want to turn your attention to States 15, which is a fragment. Will you take a look at that and tell me if it is also something you previously examined?
Yes, ma'am.
And how do you know that is something you previously examined?
On this one here, it was too small for me to mark on the evidence itself, but on the container, I have the FDLE case number, item number, and my initials in my handwriting.
And were you able to conduct any analysis of that item?
On this one, my only analysis was that there was no value of a microscopic comparison because it was too small and there was no individual characteristics or rifling seen.
So you can't make any determination. Could you make any determinations in comparison to the firearm or any of the other evidence?
No, ma'am.
Thank you. Does your work at FDLE also involve the chemical analysis of some clothing or other items?
Yes, ma'am.
And can you kind of describe what that entails?
So what that entails is what we're trying to accomplish is if there was a max distance to the discharge of the firearm to a garment that we receive. In this case, I received one T-shirt, and what I will do is I will visually, microscopically, and chemically test the T-shirt to see if there's any presence of gunshot residue or any vaporous lead from the firing process. So what happens when a gun goes off is there's a cloud of smoke that comes out of the gun. That's the vaporous lead that's caused from the primer material. What that is it will create basically a sooting around the hole, and it's indicative of a close shot. There's also gunpowder particles that can get left behind on the T-shirt as well. And some of those you can't see visually or microscopically, so we have to do chemical comparisons. In this case, I didn't see anything visually or microscopically, and I also did chemical testing to test for those burned gunpowder particles as well as that vaporous lead, and I was able to determine anything.
You got ahead of me.
I'm sorry.
But it's okay. This is States 2. Is this an item
Yes.
you previously analyzed in your lab?
Yes, ma'am.
And I just want to slow you down a little bit and back up. So when you analyze this, you're looking for microscopic particles of
gunpowder.
Gunpowder. Thank you. And
As soon as I say microscopic
examined
pieces,
this,
I'm
did you
thinking
find-
tail light.
No, ma'am.
Automatically.
And did you make any other observations? Any observations that indicated to you that this shirt was involved in a shooting at all?
Just besides the hole, no, ma'am.
Thank you. And what might explain the lack of gunshot powder on this shirt?
There's a multitude of reasons. Some of the common ones are going to be, it could be poor evidence handling. It could have maybe shaken off some of the gunpowder particles. It could be an intervening object. If there's something in between at the time of discharge, obviously those gunpowder particles or residues cannot make it to the actual T-shirt. It could be that there was either blood or debris that could have inhibited the chemical processing or masked any of the gunpowder residue that was on there. And then finally, it could be too far away to actually produce onto the shirt itself.
And what distance might you expect to find stippling on a shirt if those other factors were not involved?
It's various, but with a pistol of this nature, the gunpowder particles will typically fall off around 5 to 6 feet, and the vaporous lead will fall off around about 2 to 3 feet.
Thank you, sir. Judge, may I have just a moment?
No.
I don't have anything else for this witness, the defense may. Thank you, sir.
Thank you.
Cross. Very briefly, Mr. Housekeeping, your testimony here today is basically that the ammunition was fired from that gun in this case.
Yes, sir.
And you found no evidence of stippling or gunpowder residue.
That's correct.
And there's all kinds of reasons why that might be.
Yes, sir.
Thanks very much.
You're very welcome.
Redirect?
No, sir. Thank you.
Can this witness be released?
Yes.
Mr. Taylor?
Yes, sir.
Sir, you're releasing your...
Easy enough.
Please don't do any research on the people. When I just sent them on an afternoon break, I could see some worried looks on your faces. It's not my intention to, do JOA and everything else and keep plowing through this afternoon. But I wanted to talk to you all about scheduling so I could give them an idea. The ruling.
We don't care about scheduling.
And she wasn't listed, but you want to call her to authenticate those emails, and I would assume put her own.
To impeach. To deal with who she's all.
Well, I guess we'll eventually just kind of wait and see if her all the option. If you want to
We don't need to know about scheduling because we're zooming anyway. We're not on their schedule.
We're not leaving early. We got stuff to do, and then we can hit the ground running tomorrow morning. Still motion for release of uncharged offender. About 12 minutes.
Thank you. It's never easy, Your Honor. We have a witness issue. Faith Brown is available now, but she's not available tomorrow.
Witness issue?
She will not be a long witness. Or a witness, and when she's...
Of course, I'd absolutely give you that option. So that may, and certainly based upon the case law, certain witnesses and facts and evidence are going to have to be presented.
And so they're attempting to seek also, I think, was never provided to the state. That's the other subject of your Richardson hearing, is those emails from the sealed hearing that we've now had access to. I think had to have been obtained by the defense from his Faith Brown. Faith Brown, and because the state's never gotten us until yesterday.
What was the date, September 30th? Start the trial. Let's go. Let's get this thing done. Not delaying it for the jury any more than we have to. So this is really outside the box for me. With all of the things that need to be done, what do you think about we make tomorrow a work day? I let the jury go, and then we come back Monday and hit the ground running with the defense case in chief. Tomorrow's a work day for us.
I think that would be an outstanding idea.
My first one at the trial.
No, it works out really well, because I got witnesses like planes stacked, and my head is spinning over it. So, yeah, that would...
And violation for the emails, or whatever the other one was. I can't remember what the other one was. I hit reset, and then defense, you can come forward with your obligations, specifically identifying it, and hopefully that'll obviate those issues. Again, it's a little bit different for me.
Scheduling. See, we don't need to know about scheduling because
I didn't mislead the court when I said I had a number of witnesses.
we're not on their schedule anyway.
For me, I had scheduled...
Is all this scheduling issue?
But we can start first thing tomorrow morning. So if you could, let's bring the jury back.
Bring the jury.
Yeah.
This is me, because I want to get these, I got a bunch of hearings that I got to get done, including colloquy with the defendant. If Faith Brown isn't available tomorrow, then we could just call her Monday, and that'll give you a chance to get a deposition done. No, I agree with the state. She hasn't even been listed, so I certainly will allow you to call her, because I understand the reason why you need to speak with her.
Zoom, 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 zoom. All this is scheduling? We don't need scheduling.
Proceedings, so she has watched some of the proceedings. Once I contacted her, told her that we needed her.
Don't care, don't care.
8:45, start at 9. Okay. The next step, don't do any research on people.
Oh, the defense motion for acquittal.
In self-defense claim. And it's our position that, number one, the state has utterly failed to offer any evidence whatsoever to establish the essential element of a depraved mind.
Early failed. Okay, real quick. Keep in mind, for this, it's a different situation than it is for a normal case where it's like you're trying to figure out what happened or if the person did it or whatever. On this one, we know that she shot him. The point of the trial is to figure out if they think that it was justified if she was in fear of her life. So the first thing they have to do is the state has to prove that Ashley shot Doug on purpose, right? And we that's established. No worries there. Then they have to I can't remember what the fancy schmancy Latin word or whatever it is, but they have to, what is it, like prima facie, or I don't know. Anyway, well, whatever it is. I should have Googled it before I started talking, I guess. But anyway, it's basically like the clear and convincing evidence standard. So the defense has to, after the state has proved that Ashley shot Doug, that part's done. Then the defense has to prove not prove, but the standard is not like beyond a reasonable doubt, but it's like the clear and convincing evidence or whatever, which means it's like more likely than not, or however they word it. It's like substantially more likely to be true than untrue, I think is how it's worded. That it was in self-defense. So they don't have to prove beyond a reasonable doubt it was in self-defense. They just have to show that it is more likely than not that it did. And then which they've, put in a lot of their stuff before they even get to their case in chief. They've put in a lot of their stuff through the cross-examinations and stuff. And then the state has to prove beyond a reasonable doubt. Their burden is different, of course. They have to prove beyond a reasonable doubt that Ashley did not act in self-defense. So it's like, it's different than just proven beyond a reasonable doubt that somebody did something or didn't do something. So we'll hear his argument. Balance of probabilities. What is it? It's like prima facie or something.
Has failed to offer any evidence to overcome the
Tony.
self-defense claim that was raised as a result of the 9/11 call, wherein my client is heard to exclaim, "He attacked me and I shot him," together with the scratches and the bruise to the left side of her face. So let me expand on that a little bit. For purposes of a depraved mind, we need ill will or hatred. No credible evidence has been forthcoming in any shape, form, or fashion that Ashley Benefield acted with ill will or hatred towards Doug Benefield.
Primavera.
What has been established is that Ashley Benefield feared Doug Benefield, and that Ashley Benefield wanted to be done with that relationship, but there has been no evidence at all that Ashley Benefield hated him, acted out of ill will, spite, or malice. The record is devoid of any evidence establishing that. There's also no demonstration, Your Honor, of indifference to human life, the alternative element. In fact, what there is evidence that in response to this terrible event, Ms. Benefield immediately fled next door to call 9/11. And 9/11, of course, is what you do to summon help. And there has been nothing indicated otherwise that Ms. Benefield displayed indifference to human life. In particular, Your Honor, John Sant put the self-defense issue in play. He testified that Ms. Benefield said, "He attacked me and I shot him." The state has failed to negate in any capacity whatsoever, even when viewed in the light most favorable to the prosecution, that there has been proof established beyond a reasonable doubt that Ms. Benefield's use of force was not justified. All we have is "he attacked me and I shot him." There's been nothing to undermine that. The state claimed that the release of the Broder report was the linchpin, and I think that that's pretty much been voided entirely by Dr. Broder's own testimony, yet alone Dr. Quintal's. And they have utterly failed to prove beyond a reasonable doubt that the use of force was not justifiable. Under those circumstances, at this point, Judge White, no reasonable jury could convict Ashley Benefield, and if they were properly instructed on the law of self-defense and the state's burden to disprove it, they could conclude that the state has failed to meet its burden. The self-defense context, Judge White, is crucial because it directly contradicts the notion of a depraved mind, and that Ms. Benefield was acting pursuant to that as opposed to acting in self-defense. She acted out of a legitimate fear for her safety. Then I have two other bases. Again, the court should remember that the state's theory, very specifically advanced in the opening statement, was that 3 days following the shooting was the denouement, the release of Dr. Broder's report, and therein was the reason for the shooting. Their alternative theory was that she killed him to keep him away from Emerson, their child together. What evidence has been produced to establish that? We heard from Dr. Broder nothing whatsoever contained in his report that was in the slightest manner detrimental to Ms. Benefield. Quite the contrary, Dr. Broder told us he concluded that Ashley had no impetuous tendencies, was not prone to anger. And of course, then there was Dr. Quintal, who said that yes, she was concerned about the release of Broder's report, but only because she was afraid it would create reprisal from Doug Benefield if he found out what she said about him. And of course, then there's the whole issue about the email where Broder's release of that report was not scheduled for the 30th.
Get in the car.
The only evidence that we've seen that supports their alternative theory, the state's alternative theory that she killed her husband to keep him away from their child, is this. 5 reports of abuse of Emerson were filed with DCF. Of those 5, 2 were from independent sources. Where is there anything in that other than sheer speculation, trying to roll an inference and an innuendo into a fact, where's there anything possible that justifies the fact that 5 abuse reports were filed, 2 of which were by independent third parties? How do you go from that to killing Doug Benefield to keep him away from the child? This is their case. They have the burden to produce that. They haven't done it, Your Honor. And we think a judgment of acquittal is appropriate. Thank you.
Thank you, sir. State.
And Judge, just at the onset, I disagree with a lot of the defense's recitation of the facts as they've come out. I believe a lot of what he said, witnesses said, were not accurate. I don't believe that a lot of the witnesses said exactly in the manner that he just said the things that he said. But anyway, Judge, clearly the state has shown that this defendant killed Doug Benefield. She shot him 4 times. He died as a result of that. There is no dispute. No one is disputing that she did not kill him. So the only issue would be the depraved mind, regardless of human life. And the defense did mention ill will, hatred, spite, or ill will and hatred, but there was also spite or evil intent. And that is disjunctive, so it's or. And ill will is a very low threshold, to be honest. And the state has shown extensive evidence of motive, of the fact that this woman did not want to share custody of her child with this victim, to the point where she would make allegations against him of sexually abusing his 1-year-old daughter and physically abusing his 1-year-old daughter. And none of these were sustained. And she moved on and on and on and on. And she made comments like, I'll do whatever I have to do to keep my baby a-hole. I'm running out of time, and she's frustrated that nobody's helping her. I'll do whatever I have to do. She's making all of these comments at the same time that she's making all of these false complaints, and the state does call them false complaints, of abuse to her child. Also, I think defense counsel has made a much bigger deal about Dr. Broder's report coming out than I think the state actually ever did. The state had said this was the same exact judge that she had not had luck with before, and implied that she didn't want to be in front of this same judge again. And in addition, Dr. Broder's report was coming out, and that was going to be a problem as well. So I think there are several reasons. But when you talk about the actual evidence itself of the shooting, she shot 4 times, and the entrance wound of the fatal wound is not front; it is side to side. So he was turned away from her, and then it's the state's argument that he was moving his leg to run when he was shot as he's running away. She then just leaves him there to die and runs away. And Judge, I think all of these things together, in the light most favorable to the state, I don't think the defense has put on any evidence of self-defense. The defense has attempted to put in a lot of evidence, and things were objected to and sustained by Your Honor. So a lot of the things that the defense just argued have not come in as evidence. So in the light most favorable to the state, we would ask you to deny the JOA.
Thank you. Mr. Taylor, would you like to place any rebuttal on the record?
Very briefly. Thank you.
Or not briefly?
Yeah, no, briefly. So here's what we have, according to the state. We have a woman who is going through a divorce, who has no prior history of criminality or arrest, who, according to Broder, has no impetuous fits of anger, who has done everything according to the requirements of the law, filing a report after report, not doing anything but staying in compliance as to what a citizen is supposed to do. And she goes from that to killing Douglas Benefield on a naked theory. There's no evidence in support for a predicate to establish that theory. There's an inference. You have to take an incredible leap of faith to go from somebody who has no prior history and is living with a gentleman who's committed this kind of conduct, and you go from there to killing him. She didn't shoot him 4 times. He wasn't running away. It's going to be a pretty good trick. As the court knows, the trajectory of the leg bullet was up. So how high do you want him to lift his leg as he's running away? Because she would have to be laying on the floor and shooting up to be able to get that bullet to go into his calf and out his knee. That's a real trick. I would suggest to the court, we have raised the legitimate issue of self-defense by virtue of that 9/11 call. They have failed, and failed miserably, to rebut it.
And I thought it was very, very clear. Dr. Vega, I asked him, would this be an accurate statement, Dr. Vega, that the pistol was facing Douglas Benefield when he was shot? Dr. Vega said, yes, that would be an accurate statement. No matter how much she wants to twist it, and I hope she stays with it because I think the jurors will punish her. The bullet may have gone in the side, but Dr. Vega said he was facing the pistol. She was firing from in front of him. That's uncontradicted. Thank you.
All right, thank you both very much. I'm not aware of any recent changes in the standard by which I'm to make my ruling on a judgment of acquittal. I think I heard the defense argue that no reasonable jury could find the defendant guilty beyond a reasonable doubt. I know certainly the appellate courts talk about looking at cases in that light, and I believe that's the standard at the close of all evidence. But my understanding of a judgment of acquittal motion is I am to look at the facts in the light most favorable to the state, including any reasonable inferences therefrom, and decide whether the state has established a prima facie case. Am I mistaken?
Prima facie. See,
Okay, all right,
I said it wrong.
Sure. So
I was so close.
Again, I think it is a very interesting and unique argument that the defense raised, and they very well could be right that the issue of self-defense can be established during the state's case in chief by preponderance of the evidence. I don't find support in the law for that, and I think that my findings from earlier are bolstered when you consider at the judgment of acquittal. I'm not looking at any evidence that the defense has produced or any inferences on the defense evidence. I'm looking solely at the evidence presented by the state. I have to construe all facts and in the light most favorable to the state. Any reasonable inferences that can be drawn from those facts have to be inferred in favor of the state. And I'm only looking to see if they've established a prima facie case for the charge or charges alleged in the information. So as I look at the information that we all agreed is the operative pleading in this case from November 16th of 2020, the state has made a prima facie case, I think based upon the facts that have been established. Again, looking at them in the light most favorable to the state, including the reasonable inferences, I do find that the state has established the elements of murder in the second degree prima facie. There's a prima facie case for the elements. So I will deny the judgment of acquittal.
Prima facie. I was so
We're going to
close.
see Ms. Brown. I'm assuming you want to talk to her first and look through these emails before we address the Richardson, but that's just an assumption.
There have been some developments with the Richardson, you're talking about the Richardson issue based on the emails.
The 391 emails.
It's 390.
Was it, I might be mixing apples and oranges. Something was 390 and something was 316. And
I think there's two issues. I think the first issue was this document that we got that you unsealed had a part missing. And so I could not identify this as something that we gave to the defense. Mr. O'Keefe and I have talked, and he showed me the part that was missing, and based on that part missing, I will go back now and try to find it. So
what is it, a header or something?
Yes, it was the top of an
The
email.
auto-generated header?
Yes.
All right.
And he was saying that it came from a Google search warrant. I said, I would not have gotten Stephanie Murphy's emails from a Google search warrant. Well, apparently this was in Ashley Benefield's Google account. And with the heading forwarding it to her was not on this. That being said, I can no longer represent that we do not have this. However, the defense listed it as number 391. Is that what the number is?
277.
277 on their exhibit list. And it listed the entire Google search warrant return data. And I recognize that there's not a lot we can do now with what I'm holding in my hand, but I just want to reiterate that the defense is supposed to give us what they intend to enter. So saying to me that the Google search warrant return, which had hundreds and hundreds of documents, that is not complying with the rules of discovery. The rules of discovery are that you give me copies, or at least clue me into where it is and what exact pages are intended to be entered, and that's the rules of discovery. So I don't know that there's a whole lot we can do to solve this now, and anything that there would be to solve, I can hopefully do that in the future before we have any more testimony about these. But that I can just tell you that that's sort of some of the difficulty that the state's experiencing, is that we're looking at some of this for the first time because we haven't been put on notice of it.
So are you asking or alleging a Richardson violation? Because it's per se reversible error if I don't conduct a Richardson hearing.
I would ask you to go ahead and conduct a Richardson hearing, Judge, and just to be safe.
And do you want to do it now?
Yes.
All right. So the issue is a discovery violation by the defense, and I just need you to outline it specifically for me. Are you saying that they did not turn over evidence they should have, or is this based upon the alleged failure to specifically identify documents and other tangible objects that they intended to use at trial, or is it something else?
It is the second, Judge. It is that a list of 365 items, and they are all folders, computer folders with attachments and different pages, is not the notice that is required by the defense when they are required to give the state notice of what they intend to enter into evidence. So while the file umbrella may have been listed on this exhibit list, the state was not put on notice or told which pages would be used as an exhibit. So that would be the substance of my argument.
Did these emails come from the state? Were they recovered by law enforcement?
Yes.
And so you listed them in your discovery and provided them to the defense?
Yeah, and Judge, I have not been able to verify that. This is the first time.
Yeah, so don't say yes if you haven't verified something.
I am saying yes because the defense has shown me the page that I was missing that puts the puzzle together and shows that it probably was, as they are saying, that it came back to us in a search warrant amongst thousands of documents. So without verifying that, I would take that as true based on that representation that I can probably go back now and trace it and see that it's probably part of the thousands of documents. So that would not be the basis of my objection or my allegation. The basis would be not complying with the specific notice requirement of what exact documents you intend to use at the trial.
All right, do you want to be heard?
I think what keeps bouncing around in my head is I understand and I appreciate that even though there's hundreds of thousands of pages, we are supposed to extract and list specifically what we intend to use. But what keeps bouncing around in my head is I never expected a witness that the state called come in and perjure themselves. And now, we would have been fine if Stephanie Murphy had just told the truth. And now we're in this position where the emails clearly demonstrate beyond any shadow of a doubt that the testimony was wrong.
This is the stuff we watched yesterday.
The court should factor that into the position we find ourselves, because I understand
That'd
and I
be nice.
appreciate technically it's a violation. I would suggest the court certainly wasn't willful. But let's assume the state gets their way. We live with perjured testimony, that can't be right either. So we have to find a happy medium here somehow, understanding and appreciating that we were on guard for this development months ago, and that was why we issued the subpoena to the JA. Well, I'll tell the court candidly, I never actually expected to see it again on the witness stand in front of the jury.
Thank you, sir. Rebuttal?
Yes, Judge. I think that is, I'm trying to find the right word. On July 16th, Your Honor held an ex parte hearing, as you know, that you unsealed yesterday. At that hearing on July 16th, Mr. Taylor said, on page 4, I have an envelope to seal this. If necessary, I have Ms. Murphy's stand your ground testimony that I will pass to the
You
court.
might need to slow down a little bit.
That I will pass to the court, which I marked, where she says exactly that the hearing on the release of Dr. Broder's report was scheduled for the 30th. The shooting took place on the 20th. He goes on to continue talking that was the point. These are the very emails he provided Your Honor during that hearing. So it's clear that he anticipated from this unsealed transcript and the documents that Ms. Murphy was going to testify the exact same way she testified at stand your ground. So to now say he had no idea that she would do this, which the state finds offensive, he keeps calling it further testimony, but that he had no idea this was going to be the testimony is confusing. I can't think of the right word. Because it's clear from your hearing that he did, and Your Honor asked him, was he turned over? You had extensive conversations about these emails, whether they were provided, those kind of things. So it's clear that in the state of the defense, 6 days before trial, they knew this was an issue, and they knew that it was going to become an issue. So to now say that they did not know is confusing to the state. So the state feels like this wasn't intentional. They had a hearing with Your Honor that they asked for it to be private. And although they said it was about the mechanic, they're the same emails. It's the same email chain. And so the state feels that it was an intentional violation. Thank you.
All right, thank you both very much. Richardson is very specific, and fortunately for experience purposes, I've had to do quite a few of them. Unfortunately, I still continue to do them because they're discovery violations. It is one of the most basic fundamental ideas in Florida criminal law, and anybody who's done any practice in federal court or other states knows the length, breadth, and extent of how open our discovery rules are. This is not supposed to be a surprise or a gotcha state. With that said, I am not aware of case law holding a Richardson violation for a failure under the defendant's obligation under 3.220 to specify those documents or tangible things that they intend to use at a hearing or a trial. It's much more along the lines of never disclosed or hiding. So with that said, I don't think ultimately the Richardson framework or rubric fits this situation. I think the findings I think I'm going to make and need to be made are, I don't think there was a willful violation to the extent of the defense hiding the ball or hiding information or withholding information. If I understand correctly, there was a search warrant of the defendant's email, which the state had, and whether the state had a chance to go through it or not, they turned it over to the defense. The defense apparently combed through it and found information that it wanted to use. So I don't find a willful violation there. Is it trivial or substantial? Quite frankly, that remains to be seen, the weight that a jury is going to give to this. Do I think that the email string could be interpreted by Ms. Murphy and Ms. Brown as meaning different things? Could it be received by the jury to be substantial in their decision-making? Possibly. But in the grand scheme of things, I don't find that it was a substantial violation. I find, and I think that this is an appropriate finding, that it wasn't in full compliance with the rules, and I will, as part of my ruling, direct the defense, especially as you embark on the presentation of your portion of the case, that you do comply with Rule 3.220 and your obligations. There should be no doubt now where your obligations are and what they are and what you need to do, and you must comply with that. You must identify witnesses and list them that you intend to call at a trial or hearing, and also identify those documents or tangible things that you intend to introduce. More so than these 12,000 or whatever the number was documents, we could pull something out of there. I think the obligation is different, and I agree with that interpretation of the rules. The final analysis is the prejudice, and it's not the prejudice we typically think of. The answer is, how would the other side's trial preparation have been different? Certainly, I can imagine the state may have made different arguments. They may have prepped witnesses differently, but just at the end of the day, this was in the state's possession from whenever they had it from the search warrant. So I just don't find that there was any prejudice. So that's my findings on the Richardson hearing regarding the emails. I had down that I was supposed to do another Richardson hearing. Was that the only one?
It was about Faith Brown, because she was not listed.
Yes, okay. Do you want to be heard on that?
We just have a minute, we were just
Of course.
discussing it.
No minutes. No minutes.
Brown tagging to the state, or trial by ambush, as I think as Your Honor called it. And that was our concern. But in the light most favorable, in our mind, to the defense, we'll assume that they realized once that Ms. Mechanic couldn't be called, then they listed or they were planning to call Ms. Brown. I don't know, because I'm not sure when they thought Ms. Mechanic could be called.
Now that you've had it, you don't have to respond. Now that you've seen my order that has been unsealed, yes. I would think that the way I wrote it would clearly explain that my thought process of who's available to authenticate that email string and where Ms. Mechanic would fit on that hierarchy.
Yes, sir.
And I think that Mr. Taylor is moving along consistent with my order.
Yes, sir.
Although I will say this, while Ms. Murphy testified extensively about the email and the substance of the email, you never authenticated it with her. You never laid the predicate. And I was waiting and waiting and waiting. So I think she's available to authenticate it, and I think Ms. Brown is available to authenticate it. Sounds like it's going to be Ms. Brown. Sounds like you have the opportunity to depose her this evening. Quite frankly, Ms. Brown may have different thoughts on the interpretation of that email, and you'll have the opportunity to depose her before she testifies.
Thank you.
Okay, so to be clear, Richardson withdrawn as to the listing and calling of Ms. Brown.
Yes, yes.
So hold off on mechanic subpoena for now. The argument about it.
Yes,
Okay,
I think so.
I'm just going to put that on the back burner for now. My colloquy to Ms. Benefield regarding defendant testifying. I typically will do this at a trial. I'll do it early on, but I know we're a couple days into it. So at least the defendant will know the issues that I will bring up.
Does the court's colloquy include recitation of the penalty?
I don't think so. Let me look real quick.
If it does, Your Honor, I would ask that you
Skip that?
respectfully.
Hi, Regina.
Fair enough. No, let me look. I don't think it does. All right. All right, Ms. Benefield, listen closely. This is what you're going to hear me say. It might be tomorrow, and then I'll tell you the questions will be asked me. It might be Monday. I don't know. One of the most important and fundamental constitutional rights you have is the right to remain silent and not testify in this case. You cannot be compelled to testify. That is, the state cannot call you as a witness. It's your decision and yours alone whether to testify or not. You should speak with your attorney about your options and the positives and negatives and benefits and risks with testifying in your own defense. For example, your testimony may provide facts that would prove certain affirmative defenses or allow your attorney to make certain arguments in your defense. But if you testify, the prosecutor will have the opportunity to cross-examine you, just as your attorney has had the opportunity to cross-examine the state's witnesses. For example, on cross-examination, the state would have the opportunity to impeach your trial testimony with prior inconsistent statements that you may have made in the past, or any of the other ways that are allowed by Florida statutes to impeach. I would normally then go into prior convictions, but those don't apply in this case, so I'm going to skip that whole section. It's important to listen to the advice of your attorney about whether to testify or not in this case, but as I said a moment ago, the decision is entirely yours and yours alone to make. So your attorney may advise you that you should testify, and you can say no. Or your attorney may advise you that you should not testify, but you can. If you choose to testify, I will instruct the jury to consider and weigh your testimony and credibility as it would every other witness in this case. If you choose not to testify, I will instruct the jury that they are not permitted to consider the exercise of your right to remain silent as any evidence of guilt or let it influence their verdict in any manner whatsoever. And then the questions will be along the lines of, have you had, not that I won't want to know anything at all that you've talked about with your attorney, but just confirming you've had time to consult with your attorney and make this decision. What is your decision? Confirming just sort of like a plea that you're not under the influence of any alcohol or drugs, you understand what you're doing, you're not being forced, threatened, or coerced to to take this case to trial.
Judge, I have to tell you honestly, no disrespect intended, I think it's intrusive into the attorney-client relationship. I have, as a professional, discussed this matter with my client. My client trusts that I have her best interests at heart, and I think that this unintentionally potentially drives a wedge between my relationship with my client.
Do you have case law about that? There's cases out there that talk about the colloquy with the defendant regarding testifying or not testifying.
I don't have a problem with you advising Ms. Benefield that she has the right to not testify and the equivalent right to testify if she wants. I even don't have a problem with you saying if she chose to testify, then her credibility gets put in evidence like anybody else. I start getting uncomfortable when it goes beyond that. I begin to feel that it is an unintentional intimidation of a woman who has made a choice or is in the process of making a choice after consultation with her attorney, and this is just piling the pressure on the client. I'm sorry, Your Honor, I find it uncomfortable.
You would be heard for that. I mean, it's my
I would
decision.
like to be heard. I have heard this colloquy dozens and dozens and dozens of times. And the fact that the defense acts like this is somehow wrong or intimidating is offensive. And it is not about what Mr. Taylor is comfortable with. It's about what the court is comfortable with at this point. And what is important is that we find out what is in the mind of Ms. Benefield when she makes a decision. That is not for Mr. Taylor to speak. That is for Ms. Benefield. So she needs to know everything that the court is going to do in its colloquy, as we do with every defendant in this position, just like everyone else.
All right. I guess when we get there, I'm going to tell you what I say, and if you instruct your client not to answer, that'll be fine. I think I've shown that I don't get too upset when people disagree with me, so if you say, hey, don't answer that, okay. But I'm going to have it on the record, because in the future, if anybody says, oh, I didn't know, I thought I couldn't testify, my lawyer told me no. I mean, the plethora of cases that are out there, I think the case law supports a colloquy with the defendant regarding the right to testify and the right to remain silent. So I'll make sure that nobody's threatened you, forced you, or coerced you to make this decision. That nobody's promised you anything, any benefit or a particular outcome to make this decision, that you've made this decision freely and voluntarily. That is, it's your decision and your decision alone. If your choice is to testify, I'm just going to ask you if you've had adequate time to prepare with your lawyer for that testimony, and then I will make my findings. So that's what I do. So I'm glad I brought it up. That way you're aware of it, and if you decide not to answer any of those, that'll certainly be your prerogative. So we'll have that, like I said, we'll have that. I want to let you know about it, and then we'll have that conversation.
He said you're trying to drive a wedge between us.
All right, anything else? That was everything on my list.
I have one matter about an ex-party brief discussion I had with the court, and I supplied the court with some case law. I support my position, and I'm hoping that the court will, now that the defense case is starting, I'm hoping that the court will give me some response on it.
All right, well, I think whenever you had approached me about this case that you gave me the other day, ex parte, without going into the details,
yeah, a little over the
answer
top.
Was, I think that the state has every right to be heard on this request. So I will leave it to you. Do you want to talk about it?
Fair enough. Can you give me a moment?
Of course, absolutely.
He can be a little over the top.
All right, Judge White, we're good. Request withdrawn.
Okay. All right. Anything else we can talk about today? No?
What time is it starting tomorrow? 9, shoot for 9.
Where's my list going? Let's shoot for 8:45, just in case there's any last minute stuff.
Yes, sir.
And then with the goal of starting at 9.
And is the plan then to have testimony all day?
Yeah, I think so.
Okay.
Right? You're going to have them lined up one after another, ready to go?
Pretty much.
Okay. All right, we'll be off the record tomorrow morning.
Thank you, Justice.
Okay, we made it through all of yesterday in 3 hours. Not bad. Love me some speed trialing. Love me some speed trialing. Okay, now let's get to today. Moving right along, y'all.
Did anybody talk to anybody outside of this jury? Yes, sir.
I want to keep it on faster speed for this witness. We can go to normal speed when she testifies so that we can fully see her reactions and stuff.
Good morning, Your Honor.
Comfortable in the chair. Pull yourself up to about 12 to 15 inches from the microphone. It does adjust where you need it. If you just speak in a loud, clear voice, it'll pick everything up.
Thank you, Your Honor. Good morning.
Will you tell us your name, spell your last name for the court reporter?
Faith Brown, Brown.
Ms. Brown, are you employed?
Yes.
How?
I'm an attorney.
And how long have you been practicing?
Not quite 20 years.
Do you have a specialty?
I practice exclusively family law.
And in your practice of family law, is email communications traditionally used on behalf of you and your...
On a day, yes.
Why is it doing that?
Do email communications, are they employed in correspondence with the various courts that you have matters pending in?
Yes.
Is the exchange directly with the judge or representative?
Representative.
And their title is what?
Judicial assistant, or JA.
Mm-hmm. And these emails, Ms. Brown, are they ordinarily sent and received in the normal course of business for your firm?
Yes.
And are they kept under your care and custody?
Yes.
Are the emails preserved at or about the time that they are either received or sent?
Yes.
I'm going to pass to you, Ms. Brown. May I, Your Honor?
Yes, ma'am. Yes, sir. Sorry.
I'm going to ask you what I marked as Defendant's Exhibit 6 and ask you if you would take a moment and review that.
Zoom, zoom.
In favor.
Yes, it was.
And what case do the contents of Defendant's Exhibit 6 represent?
This was in reference to the petition for injunction for protection against domestic violence that I filed on behalf of Ashley Benefield and her daughter, Emerson Canny.
All right. Are those emails an accurate, true and accurate reproduction of the emails that you sent and received on that day, or those days?
Yes, they are.
Your Honor, I'd move at this time to introduce that as Defendant's Exhibit number 6 into evidence.
Any objection? Yeah. Received.
Thank you. That is a string of emails that covers a range of dates?
Yes, it is.
Would you tell the ladies and gentlemen of the jury, Ms. Brown, what date the first email starts on?
Sure. The first date was September 17th of 2020.
And when is the last email?
The last email is when I forwarded the email to my client, Ashley Benefield, on September 23rd, 2020 at 9:30 a.m. But are you referencing the last email between the three of us in the email?
My next question indeed is, would you be kind enough to tell the ladies and gentlemen of the jury who are the participants in this string of emails?
The participants in the stream of emails was Vicki Mechanic, who was the judicial assistant to Judge Diana Moreland, who was the judge presiding over this matter, Stephanie Murphy, who was representing Douglas Benefield, and myself.
And it's normal and customary, is it not, to the extent Ms. Murphy representing the adverse party, that you would share all correspondence between you and the judicial assistant?
Yes, it was a requirement.
Okay. Do you recall, having reviewed the email, was there a particular issue in play?
Yes.
What was it?
Initially, we were trying to stipulate to the release of Dr. Brad Broder's report.
And were you attempting to secure a date to do that?
Yes, we were. Well, eventually.
Okay. So I have some very specific questions for you. First, would you tell us whether or not, based on that correspondence, Dr. Broder's report was set for release on September 30th, 2020?
It was not.
In fact, based on those emails between you, Stephanie Murphy, and Judge Moreland's JA, Was there even a date that existed at that time for the release of Dr. Broder's report?
There was not.
If somebody testified that the release of Dr. Broder's report was set for September 30th, would that be accurate?
Oh, sustained.
Would you take a moment, if you don't mind, and read the emails?
Sure. Did you want me to read them out loud or to myself?
Yes, read them out loud and start with the string in chronological order. It covers a 6-day period, 17th to the 23rd.
The 17th to the 23rd, yes. The first email was on September 17th of 2020. It was a Thursday from Attorney Stephanie Murphy to Family Division 4, which was the judicial assistant's email address. I was on it, as well as my paralegal's email address, Sarah Hawk at myflfamilies.com, and Dr. Brad Roeder. It states, "Good afternoon, Vicki. I hope you are doing well and have had a good week. Please see the attached joint motion for release of psychological evaluation and report and correspondence regarding same with regard to the above referenced case. Thank you, Stephanie." Shortly thereafter, same day, the judicial assistant responded, "Thank you. Can one..."
Is that okay? Let me swap feeds because I don't. That skipping on the feed is driving me nuts. Let's see if it's like that on. On the other.
And review that.
For protection.
All right. Are those emails an accurate?
We got through this.
Stephanie Murphy, who was representing Douglas Brad Roeder's report.
Between you, Stephanie Murphy,
which was the judicial assistant's email address. I was CC'd on it, as well as my paralegal's email address, Sarah Hawk at myflfamilies.com, and Dr. Brad Roeder. It states, "Good afternoon, Vicki. I hope you are doing well and have had a good week. Please see the attached joint motion for release of psychological evaluation and report and correspondence regarding same with regard to the above referenced case. Thank you, Stephanie." Shortly thereafter, same day, the judicial assistant responded, "Received, thank you. Can one of you kindly prepare a proposed order in case the judge wishes to grant your motion?" About 30 minutes later, Ms. Murphy responded, "Thank you, Vicki. I will work on that right now and send it to Ms. Brown for her approval." The next morning, Friday the 18th at 10:18 a.m., we received a response from the judicial assistant, marked importance high, that stated, "Good morning, Ms. Murphy and Ms. Brown. Per the judge, she will not sign an ex parte order for release of psychological evaluation and report. The judge will allow an expedited hearing on this motion. I have available Wednesday, September 23rd at 9 a.m. for 30 minutes. However, besides both attorneys being present, the judge has stated that Dr. Broder and Manatee Children's Services must be present at the hearing as well, and must be present at the hearing as well is underlined. Further, Ms. Murphy, the judge stated that absent showing where the court granted permission for the other motions stated in your September 17th letter to her, the only, and only is underlined, matter being heard on September 30th day is the injunction hearing." And then the next sentence is also underlined. "Please advise whether Wednesday, September 23rd will work for all parties. Thank you, Vicki Mechanic, Judicial Assistant to Judge Moreland." A few minutes later, Attorney Murphy responded with an email that said, "Thank you so much for all of this information, Vicki. I admit that I did not go back to check what is scheduled for that hearing, so please accept my apology. In my mind, these cases have always overlapped so much that I just took it for granted that the upcoming hearing is just the DVI. I am available for that hearing. I will contact Dr. Broder, and we are trying to track down the correct attorney who represents Manatee County. Sarah Hawk, it appears, represents Sarasota only." The next email was actually from my assistant at the admin email address, because she handles my calendar, September 18th at 10:58 a.m., where she stated, "Ms. Brown is available at 9 a.m. However, she has mediation starting at 9:30. The next email was about 2 minutes later from the JA, stating, if this goes forward on the 23rd, it shall be via Zoom." Then at 2:09 p.m., Attorney Murphy emailed, "Good afternoon, Vicki. Ms. Brown and I are both available next Wednesday at 9 a.m. on Zoom. Dr. Broder is not available as he is out of town on an anniversary vacation with his wife. I've called into 3 different people with Manatee Children's Legal Services, including the DCF regional headquarters, to find out who needs to be included from the organization in the hearing. We have been directed and redirected to the wrong people several times. Can we go ahead and set the hearing?" The next email was about 15 minutes later from the JA stating, "Good afternoon. No, per my email to you both this morning, the judge stated that Dr. Broder must be present at the hearing." Vicki.
Per my last email.
So that was Friday, the 18th. The next email was Tuesday, September 22nd at 2:20 from Stephanie Murphy, where she wrote, "Good afternoon, Vicki. Dr. Broder never got back to me regarding whether he could appear at the hearing even by audio only while he is on vacation. So I wanted to let you know that per your prior emails, we cannot have the hearing tomorrow morning. When Dr. Broder did speak with Attorney Faith Brown on Friday, he told her that he would be returning Wednesday night. Is there any chance that Judge Moreland could schedule the hearing for Thursday? We will be in mediation in this case, but we can take a break to do the Zoom hearing."
And what is the JA, Ms. Mechanic's response to that request?
Unfortunately, no. The judge has a full docket on Thursday, and even if she didn't, Manatee Children's Services would need to be present as well.
All right.
That was Tuesday, September 22nd. So then on Wednesday, September 23rd at 1:02 p.m., Ms. Murphy, Attorney Murphy, wrote, "Good afternoon, Vicki. I've spoken with Attorney Kimberly Griffin, who represents CPS, and who confirmed that she is the attorney who will need to be present for the hearing per Judge Moreland's instructions. Now that we know who the hearing needs to be coordinated with and Dr. Broder is returning tonight, can you please forward additional hearing dates and times for this matter?" To which the judicial assistant responded about 25 minutes later. "Unfortunately, there is no availability before the injunction date of the 30th.
All right. Was there anything unclear about the fact that the only thing being heard on September 30th, 2020 was the injunction?
No.
Was there any chance, under any circumstances, Dr. Broder's report was going to be released on September 30th, 2020?
No.
I don't believe I have anything further, Your Honor.
Cross.
Yes.
So that goes against
I just
what?
went through these emails along with you, and you say it's very clear that the release of the report was not going to be heard on the 30th. In reading this, it's hard to get that because the last email says, "Unfortunately, there's no availability before the injunction date of the 30th. But that still means if the attorney got the doctor and the appropriate people present, that it maybe could be heard on that date, correct?
No.
Okay. So it was your understanding it was not going to happen?
Correct.
All right. What was your understanding of what was going to happen on that date, on the 30th?
The injunction for protection against domestic violence hearing was going to be held that afternoon.
Okay. So you were going to call witnesses. You were prepared to call witnesses?
Yes.
Okay. And have a full hearing on Ashley Benefield's motion to get an injunction against Doug Benefield. What? I didn't.
I'm sorry, can you repeat the question?
So the hearing on 9:30 was, in your opinion, only to hear the motion to get an injunction that was filed by Ashley Benefield against Doug Benefield, and that was the only thing to be heard on that day?
Correct.
Okay. And wasn't it true that previously you had agreed to drop that injunction?
It's sustained.
No further questions.
That's all, just a request to publish the email.
Absolutely. By passing? Okay. And can this witness be released?
Yes.
Yeah, that's the opposite of what the.
Ma'am, you're releasing your subpoena. You're free to go.
Thank you, Your Honor.
Thank you. No,
I'm so sorry.
pass it around.
Thank you.
What the attorney said yesterday. The one in the pink dress. I can't remember the name. Oh, I love to zoom. Goodness gracious.
Attorney's approach for me.
Attorney's approach.
Chair, get about 12 to 15 inches from the microphone. It does adjust up, down, left, or right. And if you speak in a loud, clear voice...
I'm going to drop it down to 1.25. Okay. All right, here we go.
Good morning. Will you tell us your full name and spell your last name, please?
Ashley Christina Benefield, Benefield.
How are you feeling this morning, Ashley?
Nervous.
All right, try best you can to relax and we'll get through this.
Okay.
Tell us a little bit, Ashley, about where you were born and raised.
I was born in Corpus Christi, Texas, and I grew up in Annapolis, Maryland.
What type of family values were instilled in you?
Objection, relevant.
I believe in the importance of kindness and compassion, empathy, honesty, hard work, accountability.
What type of work did your father do?
Objection, relevant.
I'll allow it.
I'll allow it.
My dad was a Naval Academy graduate who was a Navy pilot and then started flying privately for the airlines, which is what he still does.
And how about your mom?
When I was born, my parents decided that my mom would stay home to take care of me full time since my dad traveled so much.
I want to ask you a few questions about your childhood. Did you have any siblings?
I grew up an only child.
Were your parents active in your development as a child?
Yes, they were very active in my schooling and supportive of my pursuit of the arts.
Hold on 1 second, I'm sorry. We need some, get some headsets. Headsets. How many? Oh, I'm sorry. I apologize. I misunderstood. All right, Ms. Benefield, yeah, if you could scoot a little bit closer and speak up so the jury can hear you.
Okay, I'm sorry.
Do the best.
I apologize. Go ahead, sir.
Sure, do the best you can, Ashley.
Okay.
Do you have any hobbies?
I love art. I like drawing, painting, sculpting, ballet. I enjoy gardening, baking, cooking. Most importantly, I'm a mom.
What type of high school did you attend?
Objection, can you move on?
I'm going to sustain you at this point.
I'm trying to establish her ballet, Your Honor.
All right. If it's related to something specific, then yes.
Sir. Thank you. Tell us about your high school, Ashley.
I went to a small private Christian school.
And did you study anything in particular in high school?
I was focused on pursuing ballet.
And was ballet a large part of your curriculum when you were in high school?
Yes, I danced full time. I actually finished my last few credits my senior year with an accredited homeschool program for athletes, so I could dance during the day.
Do you still dance professionally?
No.
Why not?
I retired after I tore my hamstring.
I want to ask you about Doug. When did the two of you meet?
Looks could kill.
We met August 25th of 2016.
And tell us what your impression of him was when you met.
He was very confident in who he was, passionate about what he was doing for work. He was fascinating to talk to.
What was it, if you recall in particular, that attracted you to him, Ashley?
He was funny, very smart, charming. We just instantly clicked.
Was Doug in the military?
Yes, just like my dad, he was in naval aviation.
Did he turn out to be who you thought he was?
No, not at all.
I want to direct your attention, Ashley, now, if I can, to the day of the homicide, September 27, 2020.
Okay.
Specifically, late in the afternoon, would you tell us why Doug was at your home?
He came over to help load some of the larger items that my mom and I had kind of pre-staged in the garage into the U-Haul truck.
And were there any discussions between the two of you about the order that these things should be placed in the back of the truck?
Yes, we had discussed that my things would be going in last, right at the front, so they would be easy to get out first. At one point, he had me help him load one of the larger pieces into the back of the U-Haul truck. And when I was up in the truck with him, I realized that everything had been all like mixed together and it was no longer separated. And I pointed that out to him. and he got really offended and upset. He said, it shouldn't be your stuff, my stuff, your house, my house.
Was there a particular demand he made at that time?
He said I needed to start acting like a wife.
Tell us at that point how you chose to deal with him.
I tried to change the subject. I could see how upset he was getting. So I wanted to kind of alleviate that.
And how was Doug reacting to your efforts to do that?
He was getting more upset and aggressive and threatening.
Do you attempt to avoid confrontation with him?
Yes.
What do?
I was trying to get him to leave. I kept suggesting that maybe we should be done. Saying I was tired. We should just wrap it up for the day.
And what was Doug's reaction to that effort?
He heard me, but he completely disregarded what I was saying.
Ashley, would you tell us if there came a time shortly thereafter where there was physical contact between the two of you?
Yes.
Tell us about it.
We were in the living room, and as he came up to me, instead of walking past me, he walked like right into me, like a body check. He like bumped me.
His shoulder to your shoulder?
Yes.
And describe for us, if you can, the force of the bump.
It caught me off guard. I almost fell. I stumbled.
How was he acting at that point?
He was clearly hostile. He was mumbling under his breath and was glaring at me.
What was your concern?
I could see that it was escalating, and I didn't want him to blow up at me.
Was there a second instance of physical contact?
Yes.
Tell us about that, please.
We were in the garage, and it was very much like the living room. I had just suggested strongly that I wanted to be done for the day, and he, as he came up to me, he walked right into me. Again, body checked me.
Finally, was there a third instance of contact?
Yes.
What happened?
We were in the hallway, and we were coming opposite directions towards each other, and he had a box. And as he walked up to me, he looked me in the eye, and he drove the corner of the box up into me.
Where?
My side.
Indicating on your right side?
Yes, sir.
In the hip area?
Yes, sir.
What was the result of that?
Scratching. It burned.
Yes, sir.
Be kind, Tiger. Happy 14 months.
Ashley, I'm going to hand you what's been marked as defense exhibit numbers 8, 9, and 10. That approach?
Yeah, just do me a favor, whenever you're holding them up, they were facing the jury until they're admitted.
Sorry.
Yes, sir. Thank you very much. 8, 9, and 10?
Yes, sir. Will you tell us what exhibit 8 represents, Ashley?
It's a scratch right here.
And was that scratch caused by the cardboard box that you just related?
Yes, sir.
When was that photograph taken?
The night of September 27th, 2020, at the sheriff's office.
Okay, and how about exhibit number 9?
Also scratches on my side.
From the same incident?
Yes, sir.
Also taken that evening at the sheriff's office?
Yes, sir.
Okay, and exhibit 10?
The same scratches as in 9. They're just, it's a close-up.
Do these photographs, Ashley, truly and accurately reflect the scratches and bruises you received on late that afternoon on September 27, 2020?
Yes.
Do they accurately reflect how the scratches looked when they were fresh?
Yes.
Thank you. I move respectfully, Your Honor, defense exhibits 8, 9, and 10 into evidence.
Any objection?
No.
They'll be received.
What was your response, Ashley, after being struck by the cardboard box?
I apologized.
Why would you have apologized?
Because I could see how upset he was, and I didn't want him to get more mad at me.
Where does Doug go after that incident?
He continued to the garage with a box.
And what happens at that point?
We started getting into a back and forth about being done for the day and what still needed to be packed and that I wanted to be done. And we ended up in our daughter's bedroom, and he started screaming at me. He said, "Shut the fuck up." He started calling me names. And he said, "I can see what you're doing. You're trying to get me to leave." He said, "I don't have to leave. I can stay and spend the night if I want to because I'm your husband."
At that point, Ashley, how did you feel with respect to your own personal safety?
I was scared.
Did you take any steps to try to avoid anything further?
Yes, I ran to try to leave the house.
And where did you run to?
To the front door.
Did you make it?
No.
Tell us what happened.
He stopped me. He grabbed me by the hand and he yanked me back. I'm not really sure how he did it, but he spun around so he was in front of me, between me and the door.
So
he said,
I'm sorry, go ahead.
he said, "Where the fuck do you think you're going?"
What was your response? Do you specifically recall? Tell us.
Just blurted it out. I said, "I'm done and you need to leave now."
What was Doug's reaction to that command to leave now?
He said, "You can't fucking leave me."
Then what happens?
He hit me on the side of the head.
Ashley, I'm going to ask you what's been marked as defendant's exhibit number 7. Tell us what that represents.
It's a picture of my face.
Is it an accurate picture of what your face looked like on that night?
Yes, sir.
Who took that photograph?
I don't remember her name. She was at the sheriff's office.
At the sheriff's office? Okay. Now, what is it about that photograph that shows or reflects the slap or the hit that you got to the side of your head on that day by Doug?
That side of my face is swollen and puffy and discolored around my eye.
And is your eyelid drooping?
Yes.
On the side where you were hit?
Yes.
Your Honor, I move defense exhibit number 7 into evidence.
Received.
What was different at that moment, Ashley, than at any time in your prior relationship with Doug?
He had never actually hit me before.
What did you do?
I ran
Where?
to my room
Why?
because I was scared.
Ashley, did you have anything in your room that could protect you?
I had my gun.
Did you grab the gun?
Yes.
As you're grabbing the gun, what, if anything, did you hear?
I heard the door hitting the doorstop.
As if it is flung open?
Yes.
And what do you see, Ashley, when you look up?
Doug was standing in the doorway. His face was red. Like the veins were bulging in his neck. The way he was looking at me, it didn't even look like Doug. His eyes were black.
Does he yell anything at you?
He said, "You're fucking done."
And what does he do at that point?
I held the gun in front of me and I said, "Stop." And he turned and he got into this it was a fighting stance. He I got low and he started moving his arms and his hands around. He was making these jerking motions.
What were you expecting when you were holding the gun out in front of you and you told him to stop?
I thought when he saw it, he would leave.
Did he?
No.
At that point, Ashley, what are you thinking?
I thought he was going to kill me.
Tell us What happens next?
He started coming towards me, and then he lunged at me, and I started pulling the trigger. And he just kept coming, and I remember trying to move to get away from him, but he kept coming at me.
Ashley, would you tell us why, if you're holding a loaded firearm, you were attempting to move away?
I was trying to get away from him. I was terrified.
All right, so you're firing. He keeps advancing. What happens next?
It was like his feet slipped out from under him and his legs went up in the air.
When Doug hits the floor, what's your immediate reaction?
I ran to get help.
Can you tell us how many shots you fired?
I have no idea. I was in a panic.
Do you remember anything about the shooting beyond what you've told us here?
It was a blur.
Where did you run for help, Ashley?
To my neighbor's house.
What's your neighbor's name?
John Sept.
Ashley, I have to ask you a couple of very difficult questions. You okay?
Yeah, sorry.
Ashley, tell the ladies and gentlemen of the jury why you shot Doug.
I was scared to death. I thought he was going to kill me. There was nowhere to go. I was trapped. In my own house, he wouldn't let me leave.
As you sit here today, Ashley, how do you feel about what happened?
Horrible. He's the father of my child. Someday you have to explain it all to her.
Judge, I wonder, could we have a minute, maybe a brief recess to have her compose herself?
All right. Members of the jury, if you could step out for a couple of minutes, we'll bring you right back. Just leave your notes where they are. You put them face down. Please don't begin your deliberations. You can use your phones, but don't talk with anybody outside the jury about the case. Don't do any research on the people, places, things, or legal topics we're going to talk anything about. Thank you. All right, you all can have a seat. Ms. Benefield, you can have a seat. You need to take a moment to compose yourself.
Yeah, would it be all right if she stepped out?
No, sir.
May I approach her? With no conversation?
As long as you don't say anything. Yeah.
Not say a word.
Yes.
You okay?
Yeah, I'm sorry.
Ma'am, there's Kleenexes here next to you. Those.
Okay, thank you. I'm sorry.
All right, Judge, I think you can bring it back in.
Okay, great.
Yes.
All right, let's go and bring the jury back in. Yes, sir. We might have stepped into the facility, so we'll wait a minute.
Yeah, there's tears. Okay, I know that everybody's split on this. And everybody behaves different in domestic violence situations. I had to testify against my ex. They subpoenaed me. I didn't want to. It was a case that had nothing to do with me, but I had to testify, and I can remember being on the stand and fidgeting, like my hands were like down and fidgeting a lot, and I kept my head down. And when I was getting upset, like I can remember like not wanting to look at anybody. And I'm seeing a lot of that in what she's doing and saying. I think that I won't name names, but I have seen other people testify saying that they were victims of domestic violence, and everything about it made me be like, no, you're not. But I personally don't see that with her. I think that because I have gone through it, it is my multiple times. It is my automatic instinct to want to believe, when anybody says that, I like it, you want to believe it. So in order for me not to believe it, there has to be enough evidence to the contrary to make me not believe it. So I see the way she's looking down, and I see the way she's got her hair kind of like a hair curtain. And the constant apologizing is something that is a common part of it too. So that's a good way to say it, feeling like an animal on the stand. It almost felt like you have the most raw part of who you are, like the most raw part of who you are that you are having to open up in front of people who you don't know. You're not comfortable talking about it. You don't want to be there. You don't feel like, I mean, even when I was going through it, I didn't tell anybody about it. I lied to everybody and said, yeah, everything's great. Like, everything's fine. Everything's great. He's I think that having to open up something that's so raw to strangers, and you couldn't even tell your own family, is a difficult experience. So I choose to believe them unless I'm given enough reason not to. Edward, welcome. I hate it for Eva too.
All right, bring him in.
Oh yeah, I lied about all this stuff like that. Like, every time I had bruises and stuff, and my mom was like, "You've never been this clumsy in your life," and now all of a sudden, every time I see you, you've fallen or run into something. But you hide it because it's embarrassing. And you don't want, it's like this, even though it's your abuser, you still feel this instinct to protect them, but you don't want everybody else to hate them. And also, two things can be true at once. Like, this could be, two things could be true at once. This can be a situation where she is, a victim of these things. And it could be a situation where she is also toxic herself. It doesn't have to be, we're not choosing a good guy and a bad guy here. That's not what this is about. And I think that's really important to remember, too, because this is not about picking who was right and who was wrong, but more about figuring out her state of mind to see if she felt like she was in fear of her life and is justified in taking another life. So I think it's important to keep in mind that believing her does not necessarily mean that, that you're like screw Doug, whatever. Like, you don't have to. This isn't about villainizing one side or the other. They both seem toxic as hell, honestly. But it's all about finding out what her state of mind was and if she felt like she was in danger of her life to the point where she felt like she had to take his.
All right, it'll be a couple of more minutes till the jurors are finished with their break. Let's 9:56. Let's say at 10:05 we'll reconvene. Ms. Benefield, I'm going to allow you to leave the stand. However, you are in the middle of your testimony. You may not communicate with anyone.
Step forward.
Anybody do any research on the people direct examination?
Where the pistol was. Ashley, would you tell us where the pistol was in your bedroom?
It was in a storage bin. It was on top of my laundry basket.
Will you describe the storage bin?
It was like a square bin with hard sides and cloth covering the sides.
Do you remember how old Emerson, your child, was at the time of this incident?
About 2.
Was Emerson able to access that storage bin?
No.
Whose firearm was
Mine.
it? Did you have a license?
Yes, sir.
I'm going to show you, Ashley, what's previously been marked as Defendant's Exhibit Number 2. And Your Honor, I'd like to, if I could, put that up on the screen. Could we?
push the lines.
Thank you, Deputy. Ashley, take a look at the picture on your concealed firearm license. And in particular, are we able to zoom in on the portrait, the picture? Yeah. Ashley, do your eyelids look the same in that picture?
Yes, sir.
Do they look different in the picture that we admitted after you were slapped?
Yes, sir.
Let's put the, let me see now. Let's put defendant's exhibit number 7 up on the screen. Ashley, what side of your face did he hit you on?
The left side.
The
left side.
And as we're looking at this picture, it would be to the right?
Correct.
Is your eyelid on the right side the same as your eyelid on the left side?
No, sir.
And how about your eyebrow? The space between your eyebrow and your eyelid on the right side, is that the same as the space between your eyebrow and your eyelid on the other side?
No, sir.
All right, thank you, Judge. I think we can lift the blinds. Was the firearm registered to you, Ashley?
Yes.
Right, I'd like to now direct your attention back to your initial introduction to Doug. How long was it before Doug expressed his devotion to you?
It was about 4 days after we met that he told me he loved me.
Did any significant event follow after he expressed his love for you?
He flew me to South Carolina, where he was living at the time, and asked me to marry him, and I said yes.
You remember the date?
September 7th, 2016.
How old was he at the time on September 7th, 2016?
54.
And how old were you?
24.
When you finally moved in together, what was it like?
It was challenging. Doug hadn't told his daughter Eva that we had gotten married, and so when she found out, she was really upset. Just understandable. Her mom had suddenly passed 8 or 9 months before, and I was a complete stranger to her, and I'm moving into her house.
At that point in your relationship, Ashley, describe for us the man you thought you'd married.
He was very loving and attentive. He was always with me. We did everything together. We laughed a lot. And he made me feel very special and loved. He always was looking for ways to be with me and to do things for me.
Was there a short time after that you were separated?
Oh, yes, sir.
And what was the reason?
Before I had met him, I had planned a trip, and so I went on my trip. It was a cruise with my mom and one of my girlfriends.
Were you able to communicate with Doug while you were on the cruise?
Yes, sir.
How?
We mostly messaged each other.
I'm going to pass to you what's been marked as defendant's exhibit number 3, I believe, for identification.
Yes. Oh, sweet, I'm sorry. Oh, the ones that need to be sorry.
Yes, sir. I'll take a minute and go through those, and I'm going to ask you about them.
Okay. Do you want me to read all of them, or?
Yeah, go through all of them. And then I'm going to ask you some questions about them.
Okay.
Are those text messages actually a true and accurate copy of the messages you received from Doug Benefield while you were on the cruise?
Yes.
Your Honor, at this time, I would move defense exhibit number 3 into evidence.
Objection? Yes. Any additional objections?
Oh, I'm sorry, not other than what we discussed.
Okay. Admitted, subject to what we discussed at the bench.
Ashley, in this exhibit number 3, who's represented in blue and who's represented in green?
I take a look again. I'm blue and Doug is green.
You're blue and Doug is green.
Yes, sir.
Okay, so I want to ask you what you thought and how you felt after this series of text messages where he said the following to you. And I'll go through them and you can respond.
Okay.
Like always being armed. And understanding them and how to conduct warfare in them for the kingdom. If I dwelt on it, I would go into a rage to remove them from the earth. I desire to exterminate them, and holding back is a challenge. They are rats that should be removed. Last night, just the jerks arguing near you about put me in sheer murderous mood, but I was stuck. I couldn't defend you. But could have been a fight, etc. Only you being with me will over time remove the images in my head. It is same, and knowing you were taken advantage of still in my mind makes me explode with anger to take them out. God made you for me. You haven't seen the warrior side and never want to. We went from joy and passion to now I'm in a testosterone rage inside. But kill the bad people. How long had you been married when you received these texts from Doug?
I believe it was about like a month or so. Probably thereabouts.
Do you recall approximately how long you had been married?
Well, we got married in the beginning of September, and this would have been the end of November.
Okay.
So more than that, I'm sorry.
What did you think? Was there anything about those texts that caused you to pause?
You know, at the time, I kind of tried to write it off that he was my new husband, and he was just trying to be kind of manly and, you know, be protective, and, you know, was trying to show that he really loved me. I I think that was kind of what I
Did you
thought
think
at
it
the
was
time.
flattering?
Yeah.
Ashley, how long did this facade that you've described of Doug's last?
Probably about 3 months.
And what signs did you begin to see that he was not who you thought he was?
Oh, when I got back from the cruise, he started becoming very, like, controlling and possessive. He started criticizing everything about me, like the way I would wear my hair or did my makeup or the way I dressed. I found myself trying to change everything about me to make him happy.
If you had to pinpoint a specific incident, Ashley, early on that stands out to you, what would that be?
A friend of his had come to town to visit, and we went out to dinner with him. And when we went to leave, Doug had had a little too much to drink, and so I said that I would drive home. And he instantly got really mad at me. He was offended. He started screaming at me, and it continued all the way home. And when we got inside, I told him that he was drunk and he just needed to go to bed. And that really set him off. And he tried to flip over the dining room table. He threw a chair at me. He kept screaming at me until he stopped, and then he apologized. And he said it would never happen again. He said he was really sorry.
And Ashley, did it happen again?
Yes.
Explain what happened.
We had gone to church one Sunday, and after service, after everyone was leaving, we talked to the pastor in like the lobby area in front. And at one point, Doug stormed off, and by the time I caught up with him, I was in the parking lot, and he started cussing at me, calling me names. And when we got in the truck, he accused me of having a thing for the pastor, and he said I was a slut and a whore, and he screamed at me all the way home.
Ashley, was he aggressive and threatening like that in other instances?
It started happening more and more with me and with our animals. He would hurt our pets.
On approximately how many occasions was he cruel to your pets?
A handful.
How would Doug react following a dark episode?
Well, he was either really up or really down. And after, he would be very sweet and apologetic. And he'd be kind. And things would be good. And it was kind of like a flip of a switch. And something would set him off again.
Did you find anything one day, Ashley, that gave you insight into Doug's marriage to his previous wife, Renee?
Yes, sir.
Tell us what it was.
I had been going through and kind of cleaning and organizing. And I was going through a bunch of old devices like phones and iPads. And I found a texting conversation between Doug and Renee, his previous wife.
Let me pass to you, Ashley, what we've marked as Defendant's Exhibit number 11. Can you identify that, Ashley?
This is part of the texting conversation. This is a text from Eva Benefield to Doug.
Is that a true and accurate copy of what you came across that day that you just related to us?
Yes, sir.
At this point, I'd like to move that into evidence as Defense Exhibit number 11.
No objection.
Received.
I'm going to read this to you. Let me know if it's accurate.
Okay.
I was deeply disappointed that you distorted the truth about who you really were when I married you. I loved you, though finding out you weren't really what you pretended to be. You kicking me so hard on New Year's Eve on our honeymoon because you were having trouble functioning in certain areas. You holding a gun to your head twice in my home that I opened to you with my children that still love you. Having to sell everything down to my wedding ring.
Finding out you were on Viagra, which all of you had to do was tell me, you know I wouldn't care. Trying to film us making love on our honeymoon. Finding out that you wore eye pencil on and on. I loved you so much I didn't care. That's why I was shocked to think you would take pictures of me without asking. Is that accurate?
Yes.
Tell us, Ashley, how Doug would act when he would go off.
He would call it a fit of rage. Sometimes it was as simple as him just yelling and screaming at me or cussing at me, calling me names. Other times he would throw things or break things or smash things. He would come at me like he was going to hit me. He told me I was lucky that he punched walls instead of me.
Are there any incidences in particular, Ashley, that stand out to you?
Yes.
Tell us, please.
We were having an argument, and he came at me like he was going to hit me. And our dog, Sully, jumped up in between us, and he punched him in the face so hard that he knocked him out. I just remember screaming because I thought he had killed him.
Were there other times that Doug hurt the animals?
Yes, he had kicked, punched Sully. He threw our cat multiple times. One time he threw Snuffy down the stairs.
What kind of impact did this behavior have on you?
I was always walking on eggshells, trying to do the right things. Because if I said the wrong thing, he would get mad at me. And so I always tried to do it right. If I wore the wrong thing, he would call me a whore or a slut. I feel like I couldn't do anything right.
Was there an incident, Ashley, in June of 2017 that you vividly recall?
Yes.
Please explain it.
We were having an argument, and it started getting really out of hand. He pulled a gun out, and he was like waving it around. And then he threw it at me, and it hit the wall behind me, punched a hole in the wall. So I went to run to try to leave. He pulled the gun out and held it to his head. He said that he's going to blow his fucking brains out, and that's going to have to watch him. And he pulled the trigger and he shot a hole in the ceiling in the kitchen.
Ashley, at that point, what were you thinking about your marriage?
He wasn't anything like I thought he was. I feel like I'd made a really big mistake marrying him. It was like I was living in this nightmare. I never knew what I was going to get.
Did there come a time in July or August of 2017 when you found yourself with child?
Yes.
So let's be clear here chronologically. You became pregnant after this incident where you related that he shot the gun in the ceiling of the kitchen?
Yes, it would have been like right after that, I guess.
Was it planned?
No, it was the last thing on my mind at that point.
How would you deal with Doug?
I tried to do all the right things and keep him happy. Kind of just go with the flow. I didn't want to rock the boat ever.
Did you have a difficult pregnancy?
Yes, I was really sick.
Did you go home from South Carolina to stay with your mom here in Bradenton at the end of August 2017?
Yes, sir.
Did there come a time when you returned to South Carolina?
Yes.
Would you tell the ladies and gentlemen of the jury, Ashley, why you returned to South Carolina?
I had decided that I was going to leave him. And so I went back to get my things. When he brought me down, I didn't even have like a suitcase or anything. So I went back to get my stuff. And I wrote him a note and left him a letter saying why I was leaving.
I'm going to have an objection.
You approach.
statement for the record.
What is she saying?
All right, Ashley, can you identify what we marked for identification of defendants exhibit number?
Sustained.
Well, she can't even identify it.
No, sir. I made my ruling.
You told us you left him a letter?
Yes.
All right. I'm going to ask you a series of questions. Let me pass this to you. You can.
Sustained.
Do you remember independently everything that you said in the letter?
Not everything, no.
Would it help refresh your recollection if you were able to see the letter?
Yes.
Sustained.
At the time that you wrote the letter, Ashley, were the contents fresh in your mind?
At the time, yes.
The letter was written in September 2017.
Yes, that's correct.
It's now 2024,
Yes, sir.
so 7 years ago.
Yes.
All right, do your best
Okay.
to try to respond to a series of questions I'm going to ask you.
Okay.
What did you tell Doug?
Objection, consent.
Sustained. Sir, can we approach, please?
How did you feel about your personal safety when you left Doug?
I was scared.
What was it that made you uncomfortable?
It was a lot of things. It was the things that he'd done, like punching our dog and shooting the gun and different things he would say and do.
And were you afraid for just you?
I was pregnant at the time. I was scared for the baby.
Were there instances, Ashley, where you felt that your own safety had been placed in danger as a result of conduct by him?
Yes.
Can you give us some examples?
I guess one thing that comes to mind is sometimes he would drive really scary, yelling and screaming at me and like running up on curbs. One time he almost hit a tree.
Did you strike that? Describe the kind of things that would be done to intimidate you.
He would get in my face. He'd yell at me. He'd come at me like he was going to hit me.
What about breaking things?
He would break things, smash things, threw things at me.
How would you describe, if you were using adjectives, his behavior?
possessive, controlling, manipulative, aggressive, scary, unpredictable.
Ashley, did you take any steps in addition to leaving this letter to protect yourself in South Carolina?
Yes.
What did you do?
I filed for a domestic violence injunction, like a protective order.
Ashley, I'd like to pass to you what we've marked as Defendants Exhibit 13A and 13B and ask you if you can identify them.
Okay. Um, 13A is the
Was there a hearing?
Yes, sir.
Were you present at the hearing?
Yes.
Was Doug present at the hearing?
Yes.
Did the judge rule at the hearing?
From the bench, yes.
All right. What was the date of the hearing?
November 3rd, 2017.
I'm sorry?
November 3rd, 2017.
2017?
Yes.
Okay. Now, was that order that the judge decreed violated?
Yes.
By who?
By Doug.
How?
He sent me a package in the mail.
Sent you the package here in Florida?
Yes.
From South Carolina?
Yes.
What was the package represented to be?
A birthday gift, I believe.
And did you open it?
Yes.
What happened?
Well, when I opened it, there was an overwhelming smell, like a real strong chemical smell, and I got like an instant headache.
Did you report it to the police?
Yes.
Ashley, I'm going to pass you what we've marked as Defendants Exhibit number 14 and ask you if you can identify it.
Okay. So what do I do with these? Okay. Yes.
What is it?
It's a picture of the package he sent to me.
Is it a true and accurate picture of the package that you received on that day in November?
The outside of it, yes.
All right, Your Honor, on behalf of Ms. Benefield, we move that into evidence.
No objection. Received. Defendants Exhibit 14.
What did you do with the package after you opened it?
I sealed it back up and I put it in the garage before I brought it to the sheriff's department.
Now, you told us when you received the package, aside from the contents giving you a headache, that it was in violation of the South Carolina restraining order.
Yes.
Did you, when you contacted the police, request that they take some action?
Yes.
What was the result?
No charges.
office. Were you subsequently notified, Ashley, by the state attorney's office here in Manatee County that no charges were to be filed?
Yes.
Do you remember the date that you were notified?
Not off the top of my head.
Let me show this to you and see if it refreshes your recollection.
Okay. At the top, it says October 8th, 2018.
Ashley, when did you give birth to Emerson?
March 19th, 2018.
Where was Doug when you gave birth?
He wasn't there. It was during the restraining order from South Carolina.
So he wouldn't have been allowed to have contact with you?
Correct.
Do you remember how long the South Carolina restraining order was to last?
I believe it was 6 months.
Does there come a time when you're concerned about the South Carolina restraining order expiring?
Yes.
So at or about the time of that, what steps, if any, did you take to protect yourself?
I filed for a domestic violence injunction here in Florida.
What was the result?
It was denied.
And was there any directive entered with respect to Emerson?
There was a time-sharing agreement set up.
Shortly after that, or at or about the same time, was there additional litigation that you filed?
Yes.
Do you recall what it was for?
Divorce and termination of parental rights.
In the termination of parental rights petition, Ashley, did you tell the court?
Go ahead and finish the question.
Did you advise the court in your petition about prior domestic acts of violence by Doug?
Yes.
I'm sorry. Overrule main answer.
I'm sorry.
You're okay. Go ahead.
Okay. Yes.
Do you remember, or can you tell us today what you told the court?
I mean, not all off the top of my head.
You can answer.
I wouldn't be able to tell it all to you off the top of my head from memory now.
Okay, let's see if I can refresh your recollection. I would just like to ask you, has your recollection been refreshed?
I'm just getting to that part now.
Okay, then without referring to what's in front of you, tell us.
Well, can I finish reading this section?
Yeah, you need to remove the document if the memory's been refreshed.
I just said I didn't finish reading that part.
So it needs to finish reading.
I'm sorry, take your time, finish reading.
Okay.
Ask you for the high points.
Okay, sorry, there's just a lot in here.
So tell the ladies and gentlemen of the jury, Ashley, the things that you had to say.
I talked about him punching Sully and kicking him, throwing our cat Snuffy, about him trapping me, grabbing me, yanking me, tripping me, shooting the gun in the house, punching holes in the walls. They trapped me in the closet, smash things like that.
All right. As part of the domestic violence injunction that you filed here in Florida, that was before Judge Moreland, was a deposition taken of Doug.
Yes.
Were you present?
Yes, by phone.
Who else was present at the deposition?
My attorney, as well as Stephanie Murphy, Doug's attorney, and a court reporter.
Was the judge present at the deposition?
No.
Were you able to hear the entire proceeding?
Yes, sir.
Did Doug make
Objection.
Approach.
BL, that's okay. I know most people watched it live. You're not in trouble this time.
Okay.
Goodness gracious. The sidebars.
Ashley, I'm going to pass to you what's been marked as defense exhibit number 17.
Okay.
And ask you if you can identify it.
Their text messages between.
Ashley, do you recognize that?
Yes, sir.
Tell us what it is.
Their text messages between me and Doug.
And do they truly and accurately reflect texting back and forth between you and Doug?
Yes.
On behalf of the defense, Your Honor, we move into evidence defense exhibit number 17.
Objection overruled. Defendant's exhibit 17 will be received.
Ashley, in defense exhibit number 17, the text messages, does Doug admit to shooting the gun in the house?
Yes.
Does he admit to throwing the gun at you?
Yes.
Does he admit to punching holes in the drywall of the house?
Yes.
And does he admit to punching the dog and rendering him unconscious?
Yes.
Objection. No, those text messages do not say that.
If I'm going to sustain. If you want to publish the exact exhibit that's been admitted, you can do so.
We intend to publish upon completion of the examination. I want to ask you, Ashley, if I can, about other instances of abusive conduct. Was a tracker at any time placed on your car?
Yes.
Was it done with your permission?
No.
Did Doug... Well, hold on. Ashley, I'm going to pass to you defendants exhibits 19 and 20. Tell us, if you would, what they depict.
Holes in the drywall of the house, our house in South Carolina.
Refer to them specifically. Exhibit number
19 has a picture of a hole in the drywall with my hand next to it, kind of been like pushed back in.
Is it a true and accurate production of what existed at that time?
Yes.
All right, and the next one?
20 has a picture of a hole, like a fist hole through the drywall in our home.
Okay, is it a true and accurate photograph of that?
Yes.
On behalf of the defense, Your Honor, we move them into evidence.
State, any objection to defense 19 and 20?
No.
Received.
Again?
Ashley, did Doug admit to placing an illegal tracker on your vehicle?
Yes, in a message to me.
Did you report that to the police?
Yes.
What was the result?
No charges.
Were there incidents, Ashley, where Doug would appear unexpectedly?
Yes, a lot.
And how would that come about? Can you give us an example?
I'd be driving down the road and I'd see him in the rearview mirror, a couple cars behind me, or he'd be right behind me. Or sometimes he would show up at places that I was just unexpected. I'd see him, or like in the parking lot.
And was this while you were living here in Manatee?
Yes, I was living here
And where was Doug living at the time?
in South Carolina.
How could he do that?
He was driving here,
Was this also during the time that the South Carolina injunction was in place?
both then and after as well.
Did you report those incidents to the police?
Yes,
What was the result?
no charges.
Was there an incident with a neighbor, Ashley?
Yes.
What happened? Ashley,
She,
were you present
yes,
for the incident?
yes, he was outside in the yard at night looking in the windows of my house.
What is the neighbor's name?
Marianne Croft?
And was this reported to the police?
Yes.
Did they respond?
Yes, they came out.
Was it daytime or nighttime?
It was nighttime.
In your presence, was an identification made that it was Doug?
Yes.
What was the result?
No charges.
Was there an incident, Ashley, where you and your mother came home to find someone in the driveway of your home?
Yes.
Who was it?
It was Doug.
What did he do when he saw you?
He was on foot in front of the house, and when he saw us, he took off running.
Did you call the police?
Yes, I had to call several times before they sent someone out.
Did they take a report?
They did, but by the time they finally got there, he was long gone.
What was the result?
No charges.
I want to introduce what we've marked as Defendant's Exhibit 23 and 24. Can you identify that?
Yes.
What does 23 show?
23 is a picture of Doug with his shirt off. He's like taking a selfie.
And is that how Doug looked at or about the time of the shooting on the 27th?
Yes.
All right, and what does the next exhibit show?
It's also a picture of Doug with his shirt off. He's working out. He's like doing like a push-up, I guess.
Does that too accurately represent what Doug looked like on the day of the homicide?
Yes.
Your Honor, on behalf of the defense, we move those two exhibits into evidence.
Any objection? Received.
Just one or two more questions, Ashley. Was there a time back around May of 2020 where you wanted to learn about co-parenting with an abuser?
Yes.
Objection. Previous ruling.
Sustained.
To the question, Your Honor, or to the line of inquiry?
To the question.
Okay. Did you take any steps, Ashley, to try to determine how to co-parent?
Yes.
All right, and what was that?
I did some like Googling and reading to try to find helpful articles on what to do to make things
I'm going
good.
to pass to you what we've had marked as Defense Composite Exhibit 4, A, B, C, and D.
Objection, yeah, previous ruling, sustained.
Can you approach?
discussing defendant's exhibit number 4.
No, I already ruled on authenticity in the past. So over the state's objection, admitted.
Thank you. Take a look at exhibit 4A, Ashley. What's the date?
5/11/2020.
And did you do an internet search on 5/11/23?
2020, yes.
2020, rather?
Yes.
And will you tell us what the subject you researched was?
Domestic co-parenting with an abuser.
All right, and would you go to exhibit 4B? What's the date of 4B?
5/11/2020.
Did you do an internet search then?
Yes.
What was the subject you researched?
Ask Amanda, how do I co-parent with an abuser?
All right, and 4C?
Yes.
What's the date of 4C?
5/11/2020.
And did you do an internet search then as well?
Yes.
What was the subject?
Co-parenting versus parallel parenting with an abusive ex, the Good Men Project.
All right, and lastly, 4D. What's the date of 4D?
5/11/2020.
Did you do an internet search?
Yes.
What was the subject?
6 tips to help you co-parent with an abusive ex.
All right, Your Honor, I think I'm finished if you just give me one moment. It's been previously admitted as defense exhibit number 6.
Okay.
Do you recognize it?
Yes.
What is it?
It's a whole chain of emails that were forwarded to me by my attorney.
And what is the date it was forwarded to you on?
It says Wednesday, September 23rd of 2020.
Did you read it?
Yes. I mean, do you want me to reread it now or?
Did you read it when it was forwarded to you?
Yes.
No further questions, Your Honor.
All right, go ahead to the attorney's approach, please.
Okay, so it looks like they go to lunch and then come back and do cross, I'm assuming.
Relevance by testifying that she has her face.
We've had our lunch break. It's about 1:08 in the afternoon. I have both prosecutors and Mr. Taylor here along with Ms. Benefield. Before we get started, Ms. Benefield, when we took our lunch break, I gave you the full warning that I give to all the witnesses that you've heard multiple times regarding sequestration. I was erroneous, however, because my instruction to the criminal defendant has to be modified slightly. You are allowed to meet and speak with your attorney over the break. I no sooner got upstairs and realized I gave you the full sequestration instruction. Now, there was no objection to it. Case law talks about if there's an objection to it or a deprivation of the right to counsel. But I want to make sure if there was any error, or even arguable error, that I correct that now.
I appreciate it, Judge. We'll be able to get it all worked out.
Okay, so I'm happy if you want to take time to speak because you're allowed to. I'm happy to take a recess and give you that time if you need.
Thank you.
All right, sir.
I think there will be a pre-objection to something I intend to introduce.
Okay, yeah, let's. If you know about him now, let's talk about him before we bring the jury in.
I'm going to put this argument part back at 1.5. And then we'll go back to 1.25 when she's gone in.
All right. Oh, you don't have to approach her, or unless you want to. Is it something we want to keep?
No.
Okay.
It's her fault that she walked first.
So I have State's Exhibit 103 and State's Exhibit 104.
Yes. Is there objection, sir?
Okay, yes, objection.
Relevance is to the modeling photo, and mugshot, we submitted a memorandum to the court. It's pretty clear in case law mugshots are not admissible.
I disagree that the case law is clear, the mugshot is not admissible, but the relevance of both of those is to show her face before and after this incident, so the jury can make their own determination if there's swelling on her face. And I did say when we had a pre-trial discussion about the mugshot that I would not intend to enter it unless the defendant made it relevant by testifying that she has swelling on her face. So I do believe now that she said there was swelling on her face, I can introduce the mugshot that occurred weeks later to show.
I apologize.
I was done, I'm sorry.
Objecting party, rebuttal.
I know I wasn't able to introduce in the state's case in chief. I don't think they should be entitled to introduce at ours either.
Well, I think there was some evidence that was introduced. It all depended on what it was. Thank you both very much. 103, what did you refer that to, a modeling picture? Is a modeling picture showing the defendant's front face down to the chest area. And 104 is, I've not compared it, but you say that's the booking photo that was taken when she was arrested. All right, I was just checking because there's like a speck on it. I was checking to see if that was a paper speck or in the picture. So yes, what we originally talked about, I don't think I don't agree that there's a blanket prohibition on the entry of a booking photo. However, it is a bit of a more unique situation if there was an erroneous decision not to allow one party or the other to introduce evidence during the other side's case in chief. It's a fairly simple remedy that the other party can just call them in their case in chief or in rebuttal, lay the proper predicate and introduce the evidence if it's admissible. In this situation, it's a little bit different. Obviously, these would need to be authenticated by the defendant, so I don't think it's improper. I'll allow it. The only thing I'm going to require, however, is the 104 is just to be referred to by the date. On such and such a date was your photo taken.
And Judge, I respectfully disagree. There's no case law that says a jury cannot know that a person was arrested. The only case law is that a person cannot be made to sit at a trial in jail clothes. But there was no prohibition. They know she was arrested.
Mm-hmm.
So I believe that helps substantiate the date that it was taken and the time that it was taken.
And I think you can ask for the date and time. So, yeah, no, overruled.
Can I see the exhibits?
Of course.
Judge, just for the record, the state has still not received the order defense exhibit unless we instructed them to get.
Are there any other defense exhibits? Well, let's finish. Let's close this issue out.
Yes, sir. I'm sorry.
All right, so defense has handed State 103 and 104 back. The question was asked regarding defense exhibits. I don't know what's left. I don't know what witnesses are being called or when, but do you have an exhibit list that complies with Rule 3.220?
I think we gave them all.
No?
Judge, they gave us 360-something items, file folders with multiple pages in each one. That does not conform to the rule. They need to tell us what they are going to introduce specifically.
Well, the rule calls for what do you intend to introduce?
We have them, I'll share them with the prosecution today.
Prior to any witnesses being called?
Yes.
Okay. Are you ready? State.
I still would ask for a list because it's hard for us to, when showing us them, I don't have the ability to copy them and do all those things like I would have if I got a proper list. And so it's just hard for me to be able to then go find the things to be able to figure out if they're complete.
So here's what we're going to do. We're going to have a mid-trial exhibit exchange. And we'll take a break. Maybe it'll be the mid-afternoon break. I have no idea.
We'll give them a list.
And you're going to get a list. And if not, you can go through them and you can write on a piece of paper exactly what they are. And if
yes.
All right.
I don't need that. Oh.
All right, bring in the jury. These are legal topics we've heard anything about. Everybody says no. All right, State, you may begin your cross-examination.
I would like to just start with a couple of issues. So first, Doug Benefield never punched you, ever, correct?
Yeah, I think that's correct.
Doug Benefield never choked you, ever?
No.
He never kicked you?
No.
He never pointed a gun at you?
He waved a gun in my direction.
But it was not pointed at you, correct?
It was pointed at me while he was waving it at me.
He never came at you with a knife?
No.
Or a club?
No.
Or a baseball bat?
No.
So there are 30 years difference between...
To be clear, the things that she just listed are abuse. Yes. But those are not requirements to be able to say you need help because you are in an abusive relationship. Those are examples of abuse, yes, but those are not requirements. You can be in an abusive relationship without it being those things. And the reason that I think it's very important to point that out is because I convinced myself for a long time that I wasn't in an abusive relationship because I thought that nobody would that's not what it is, because those things weren't happening. And if you the longer you stay, sometimes it gets to that point and sometimes it doesn't. But I've seen it happen so many times with so many women, and I've experienced it myself, where you convince yourself that it's not abuse because he didn't actually punch you or he didn't actually kick you. Like maybe all he did was, because that's what you tell yourself, all he did was grab you or trap you in the house or knock you down or take your car keys and your phone so you couldn't go anywhere or call anybody or So I want to stop right there and make sure that we make that clear, that it doesn't have to be, regardless of what you think about this defendant, totally put that aside. You do not have to have experienced one of those things from that list to be able to accept or acknowledge that you are in an abusive relationship. And I think that's important.
Between you and Doug, correct?
Yes.
And you got married after 13 days?
Yes.
And you spoke with him about, or organized with him about starting this ballet?
Yes.
Correct. And all of the money for the ballet came from him or investors, right?
My mom also funded a part of the ballet.
You didn't put anything into it? Money?
Not from my account, no.
Okay. In fact, during this time in South Carolina, you never worked, did you?
He wouldn't let me work.
Okay. When you said in the very beginning he flew you to South Carolina to visit before you were married, he paid for that, correct?
Yes.
Okay. And the cruise you talked about going on, he paid for that?
No.
He didn't?
He did not pay for the cruise, no.
Okay.
Yeah, he paid for my friend to go, but I had already paid for my mom and I to go. So.
Okay. So he paid for your friend to go?
Yes.
And he did not go with you?
Oh, no. Mm-mm.
I want to ask you about the text messages that the defense talked to you about. It's going to be Defense Exhibit 3. I'm going to hand it to you. And I have the entirety of it on a spreadsheet that I'm going to put up, which is State's Exhibit 99. If we could dim the lights, please. And Judge, based on the rule of completeness, state would enter into evidence State's 99.
Did you want to be heard in addition to what we said earlier?
I haven't actually seen the specific message.
Well, Lucy can tell when I get upset.
So I'm going to put this up on the board behind you, screen. trying to get it to come up on the screen. Outgoing or incoming, that would be the third, fourth column that we're looking at. And what I would like you to do is read the body of these as we go through. I'm going to expand it so you can see it. And if you could just read these for the jury.
Okay. One part is just looking at Renee.
Who is that from you or from Doug?
It's from Doug to me.
Okay. So from Doug, one part is just looking at Renee. Okay, go ahead.
I'll tell that part to start. The day I met her, I felt her before I saw her. So, my ex-husband lived to argue. Renee and I maybe argued 5 times in 15 years, and even then ended up laughing. Smiley face. I'm a clown at heart and love people being happy. That seems like a hard act to follow. Baby. Like, always being armed. Yes, my love.
And the outgoing messages are you or Doug?
It looks like outgoing is Doug? Yeah, outgoing would be from Doug.
Judge, can we see the date for reference of the messages?
It's up on the screen. So yes, my love, I think was the last thing you said. And then what's the next thing?
Are you doing things that are dangerous?
And you're going to have to speak up just a little bit.
I'm sorry.
Here.
Are you doing things that are dangerous? To think of all the time that you were not with me and understanding them and how to conduct warfare in them for the kingdom.
Where was he when he was sending you these messages? While you were on the cruise?
I believe he would have been in Charleston.
Okay. He wasn't on a business trip?
I don't believe so.
Okay. Continue reading. All the other people.
All the other people. Then a rectangle. It makes me so sad. And then another rectangle. If I dwelled on it, I would go into rage to remove them from the earth.
And your response to that?
Yes, baby, I hate it. It hurts. He said I could defend myself, and you were easy prey for predators. You're sweet and want to please people, and they used that.
And you said? I'm sorry, and then he said?
I desire to exterminate them, and holding back is a challenge. They are rats that should be removed.
And you said?
Oh, baby, my love. Yes. Like that night, like last night, just the jerks arguing near you about put me in a sheer murderous mood that I was stuck and I couldn't defend you. I said, thank you, baby, but I was okay. He said, but could have been a fight, etc. Only you being with me will over time remove images in my head. It is same, and knowing you were taken advantage of in my mind makes me explode with anger to take them out. God made you for me. And I said, yes, baby. He said to enjoy the beauty he did craft on earth. I see Renee as Eva's mom, not my wife. It is strange, but...
Can you pull that back up?
He said it is strange, but there is no emotional connection. I said, well, I'm glad. I just wish I could see it that way.
And you said, I'm glad. I wish I could see it that way. Were you talking about being jealous of his relationship with Renee?
I guess you could put it that way.
Okay. You can continue to read.
I know we both have a battle to fight in our minds. He was sitting on the mantle in the background. I'm crazy, I know. But it just killed my heart. I know I see you in my mind with a bad person with your legs spread and a shitty person choking you out. That haunts me. I love you and I never want to hurt you. I'm sorry. Rectangle. Now all I see is some douchebag on top of you, fucking you with your legs spread and him choking you out and fucking you more. Right now, I literally want to kill him or them. I said, baby, don't even think like that. He said, you haven't seen the warrior side and you never want to. I said, no one will ever touch me. I am yours. I don't. You are right. I want to see you only as my sweet and loving husband who is gentle to me and kind. He said, we went from joy and passion to now I'm in a testosterone rage inside. And who is always there and safe? That's what I said. And I said, let's not ruin the day. He said, but kill the bad people. Okay. And I said, tell me that you love me.
So this conversation was about things that you had told him that people had done to you, correct? When he's talking about, I'm imagining this, I'm imagining people choke you, he's talking about a conversation that you had had with him explaining that this had happened.
I think he was referring to on the cruise. One night I was talking to him on the phone, and I was sitting out in the hallway up at the top deck, and I was just trying to get somewhere where it'd be quiet so I could talk to him. And it was near, there was some like a bar or something up there, I think, I'm not sure, but people were coming in and out, like maybe a restaurant. And while we were talking, he heard.
Is the answer yes or no?
She's saying she needs to allow her to finish her answer, Your Honor. Let me finish your answer.
He had heard a couple guys that were talking loudly, and he got upset because he thought these guys were going to hurt me. And so he had talked about then that he imagined that, you know, I was out in the world without him and that people were going to take advantage of me and that he didn't know it was going to happen to me.
And he was afraid for your safety.
Yeah.
And he was saying that if anybody hurts you or he thinks about anybody hurting you, it sends him into a rage.
Yes.
And that scared you.
I'm sorry?
And that scared you.
Well, as I said earlier, at the time I kind of, you know, played it off in my head that he was just my new husband who was trying to be protective and like show that he loved me by kind of being, you know, manly.
Okay. So I want to talk about you having a baby. So Doug had a vasectomy removal in April of 2017, right?
Yes.
And you paid for that?
Part of it went on my debit card or my credit card.
And your intention was to get pregnant?
Yes, we had talked about that, yeah.
And this was how many months after you were married?
We got married in September, so October, November, December, January, February, March, April, 7.
And was this, during this time, you said he had started criticizing you, right? Mm-hmm. About the way you looked, your clothes, the way you acted. He was, according to you, he flipped a table, tried to flip a table, threw a chair, right?
Yes.
He would scream at you.
Yes.
He would call you slut and whore.
Yes.
And you want a baby.
I mean, yeah, we were married. We wanted a family.
Okay. So the vasectomy reversal happens, and I believe you said that this baby was a surprise. Is that what you said?
Well, we weren't like planning on it right then, you know.
Were you having unprotected sex?
I suppose so.
Okay. So you knew that unprotected sex would result potentially in a pregnancy?
The doctor had told us that it probably wouldn't work for a while, so it wasn't something that we thought would happen that fast.
Okay. But it did?
Yes.
How quickly? When did you get pregnant?
I guess July.
And right around this time is when you say the incident happened where Doug threw a gun at a wall.
He threw it at me.
Shot a gun at the ceiling. I think you made several allegations, correct?
Yeah, he admitted to it, but yes.
What were you arguing about?
I think Eva was part of it. I don't specifically remember.
And wasn't it true that you had a problem with Eva and you thought she was disrespecting you at that time?
I wouldn't say I had a problem with Eva. There was a lot of tension in the house, but yeah, there's a lot of things going on that were not ideal.
You knew she was 15.
Yeah.
And you knew she had just lost her mother tragically to death.
Yeah.
And you were how much older than her?
10 years, 9 years, 10 years.
And this tension surprised you?
No. I mean, at first he had told me that she was really going to love me and that she was ready to have a woman in her life and that he wanted me to move in quickly because she needed a mom. So he made it sound like she also felt that way.
And you had no feelings of your own?
I was excited to get to be her stepmom.
And you gave her a shadow box right around this time, correct?
For Christmas, so it would have been in December.
All right. And what was the shadow box?
You want me to describe it?
Yes.
It was like a small picture that had like deep sides and like the glass was at the front of it. And there was a sand dollar that I had painted and decorated. And I put it on like a black cardstock. And I wrote a saying on it that said something about how like you can be strong through the storms and that, you know, seashells are beautiful things that come out of storms.
And that shadow box is the reason you were arguing that day with Doug, correct?
I know it came up at one point. I don't know if that was the reason.
And what was the problem with the shadow box?
Eva had taken it apart and I guess had thrown out the thing that I made and was using the picture frame for something else.
What was she using the picture frame for?
She had put a rose from her mom's funeral in it.
And that upset you pretty badly, didn't it?
It made me really sad. I had taken a lot of time to make it for her and I thought it was special. And
you began crying.
Yes.
And you dropped to the floor and sobbed hysterically.
Probably.
You were so upset that she put her dead mother's rose in the shadow box.
It wasn't that. It was that she took it apart. I mean, I would have bought her another shadow box.
You went to Doug and said it was disrespectful that she took this apart.
According to Doug?
No, according to you. You went to Doug and said, she's acting disrespectfully. You need to handle her. She upset me. I'm crying.
I don't remember saying that about that.
Isn't it, in fact, what you were arguing about before this whole incident with the gun and the ceiling?
Is this relevant as it relates to the daughter? Can you approach, please?
I'm this cross.
At one point, we're in the car. So the day that this argument happened, you actually, at one point, were in the car with Doug, right?
Yes.
Okay, you were going to the bank and going to do some other errands?
I believe so.
And the entire time, you're upset about this shadow box?
I don't distinctly remember that, but the argument kind of came from there, I guess.
And in fact, it wasn't an argument, right? It was you being upset.
Well, he said that like life was out of control and he couldn't deal with the people at home and he couldn't deal with the people at the ballet. And he felt like everything was just too stressful and he was upset with everybody.
And didn't he ask you to stop?
I'm sure at some point.
And you didn't stop?
I guess not.
For the car ride? No? Yes or no?
I don't remember.
And you kept telling him you need to discipline Eva?
I don't remember saying that.
Okay. And he said, let's just stop talking about this for a while. I need to think.
He was yelling at me.
So he's yelling at you, but you weren't sitting there like you are now, were you? You weren't sitting there like this.
I guess I was buckled into the car, so I probably would have been sitting further back.
And you didn't stop. And then you get home, you're still arguing, correct?
He's still yelling at me, yes.
And you're not yelling at all?
No.
And the fact that he had a gun with him when you continued to argue in the house was because he grabbed the gun from inside the car to bring his items from the car into the house, correct?
I'm not sure why he had it, I guess.
Okay. And it was in a holster?
I believe so.
And you both used to carry guns?
Mm-hmm.
You carried guns on a regular basis?
Yes,
you
ma'am.
have had, at the time, more than one gun?
Yes, ma'am.
And you actually bragged, as well as Doug, about having guns, correct?
Yes.
And you would go shoot them on a regular basis?
I haven't been to their range since before the presidential election.
Okay. But during the time that you met Doug at a political event, you had one of the guns in your bra?
Yes, that's where I concealed carried.
Okay. So having a firearm in a car or in the house is not that unusual to you?
No, ma'am.
All right. So after you get back inside, there's this argument that continues on and on and on and on. And you're still asking Doug to discipline Eva?
I don't recall that.
Okay. And you say he was waving a gun around and threw a gun at you. Is that what you said?
Yes, ma'am.
So he has a gun in his hand, could point it at you.
He did point
but
it at me.
he throws a gun at the wall.
No, he threw it at me. He missed me.
Okay. And it hit the wall?
Yes, ma'am.
Okay. When was this? What was the date of this argument?
I believe it was the end of June.
2017?
Yes, ma'am.
When was your wedding reception?
It was shortly after that, maybe like a week or two later. I don't remember specifically.
Okay. So even though you've been married before, you were now having a wedding reception?
Yes, when we got married, it was just the two of us.
And at this wedding reception, you had a lot of guests come?
I'd say maybe a dozen. My friends and family came.
And they're dressed up?
Yes.
You're in your wedding dress?
Yes.
Okay. And I'm going to show you State's Exhibit 10. I want you to tell me what this is. Or I'm sorry, it's 100. I want you to tell me what this is. It's going to come up behind you. What is this a picture of?
That's a picture of Kevin, Christy, me, and then Doug.
Okay. And is that a picture from the wedding reception that we just talked about?
Yes, ma'am.
Okay. I'm going to show you State's Exhibit 101. What is that?
That's a picture of me and my friend Christy.
And is it at the same wedding reception?
Yes.
And State's Exhibit 102. What is that?
It's a picture of my friend Laura and me, and then my friend Christy.
And this is also at the same reception?
Yes, ma'am.
Okay. State would move into evidence States 100 through 102.
Any objection?
I'm sorry, I missed it.
Any objection to States 100, 101, 102? No. Received.
Thank you. And in States 100, are you scared here of Doug?
Oh, that's
no, I
bullshit.
did not say no.
You said on direct examination that around this time you were living the nightmare. Those were your words, correct?
Yes, ma'am.
Okay. Were you living the nightmare here?
Oh, no, not at that moment, no. That was a very nice day.
Okay, see, stuff like this is the reason that people don't come forward. Because stuff like this is...
At this moment.
Oh, it was a good day.
And States 102 at this moment.
Same. It was a good day.
So you get pregnant and you decide to move in with your mother. So when do you decide to move in with your mother in Florida?
It was the end of August, I believe. I was really sick, and he brought me down to my mom's house and dropped me off.
Okay, but going to your mom's house was your choice, right?
We decided together. He said he couldn't take care of me. He was too busy, and that my mom could take care of me better. So I was happy to go.
You needed someone to take care of you while you were pregnant.
I was really sick, yes.
Okay. So you moved down with your mother at maybe August of 2017, you said?
The end of August, I believe.
Okay. But there's still this issue of the injunction in South Carolina while this is going on, this South Carolina-Florida thing, correct?
I'm not sure I understand that question.
Well, you said you applied for the South Carolina injunction, or you received the South Carolina injunction right around that time in 2017. Actually, I think you said November 2017.
Yes, a few months later.
So shortly after you moved in with your mother, a couple of months, you filed for an injunction in South Carolina.
Yes, ma'am.
And we talked about the fact that, or you talked with the defense about the fact that it was a mutual injunction.
Yes, ma'am.
So both parties agreed to stay away from each other, correct?
Yeah, I believe that it was for both parties to stay away.
No evidence was presented at this hearing.
I don't believe so.
None of your complaints were heard at this hearing.
There was like a written, like a filing.
But the judge, other than that, did not hear any evidence at the hearing.
That's correct.
All of that was forestalled because the two of you agreed, okay, fine, we will have this voluntary stay away order.
It was decided through the attorneys, but I believe that was, yes.
Okay.
Yes, ma'am.
So the judge never found that Doug Benefield was dangerous and ordered this injunction.
I'm not sure what the judge found. I don't know what you mean by that.
There was never a court finding giving you an injunction, other than you stipulated to it.
The judge ordered it, yes, ma'am.
Okay. And this injunction, actually, part of it says that neither party shall harass or threaten or do those types of things to each other.
Yes,
right?
ma'am.
Okay. So then after you're in Florida, you get a package that you say was in violation of this injunction. And it's a birthday present, right?
Yes.
It's a tea set.
Among other things, yes, ma'am.
And you liked tea.
I like drinking tea, yes, ma'am.
You drank tea all the time with Doug.
Yes.
Okay. And you opened this tea and you claim that it smelled so strongly that you automatically rushed it to the sheriff's office.
I didn't specifically sniff the tea. It was when I opened the box. The whole contents had a very strong chemical smell.
So you immediately rushed it over to the sheriff's office?
No, ma'am. I immediately sealed it up and I left it in my garage.
For how long?
I don't remember specifically. It was like maybe a day or two. I don't remember.
It was a little bit longer than a day or two, was it not?
I don't remember.
So after this time goes by, you take it to the sheriff's office and you claim that this was a violation of injunction. Right?
It was, yes, ma'am.
And you also claim that this was all part of Doug's poisoning scheme to poison you and your unborn child.
Hazmat informed me that there was toxic
I don't want to hear what
chemicals
someone else told you. I want to hear what you claimed, that this was part of his poisoning of you. Plan to poison you.
Based off of what I was told, that was the conclusion I came to.
Ma'am? Yes or no? What, according to the way you felt, this gift was a part of his plan to poison you.
It concerned me, yes, ma'am.
So no charges were filed for that, correct?
Correct.
So you filed for an injunction based on the same allegations, right?
When my injunction in South Carolina was getting ready to expire, yes, I filed for one in Florida.
Okay. So when you filed in Florida, about what time was this? What date?
I could give you a ballpark. It was in the spring. I don't remember exactly
Spring of 2018?
Yes, ma'am.
Okay. So you had left Doug in South Carolina August of 2017.
Yes, ma'am.
And you filed for an injunction in the spring of 2018.
That sounds right.
But you hadn't been living with him, correct?
Correct.
You hadn't even had any contact with him for a very long time when you filed for that injunction, right?
Well, other than him sending the box and, yeah.
Okay. So what violence were you trying to prohibit by filing this injunction? Everything that happened in South Carolina.
Well, I was just hoping that wouldn't happen again.
Okay. And at the same time you did this motion for an injunction, you also did a motion to terminate Doug's parental rights, right?
Yes, ma'am.
Okay. So during this time that you haven't been with him in almost a year, at least half a year, there hasn't been any violence other than you say the T said. You're filing for an injunction all at the same time that you're trying to terminate his parental rights. This is all correct, right?
Sounds correct.
Okay. And you hadn't even had the baby yet.
As of when?
As of the time that you were trying to terminate his parental rights.
I don't remember what the date was, but it would have all been around that time.
And then there's the hearing that goes on for this injunction, right? And this is in front of Judge Moreland, correct?
Yes, ma'am.
Okay. And you had a 2-day hearing on this?
Yes, ma'am.
Partially, it was a motion for your injunction based on these issues, and it was also Doug's motion to be able to see his child, right?
I believe at some point things got consolidated, but I don't recall specifically.
So at this point, Doug had not seen his daughter?
Correct.
And your daughter was how old?
As of the date, like the last court date?
Yes.
About 6 months old.
And had there been any violence towards you between the time that you filed for this and the time when you had the hearing and she was 6 months old?
He had showed up at night in my driveway, but I mean, there's no physical contact if that's what you're asking.
Okay. And was this a time when the baby had been born?
I don't remember the date of when he was in the driveway.
How about, since we're talking about this, let's talk about the incident you talked about where the neighbor said that that Doug was there. Can you tell me about that?
Yes, ma'am. He was outside standing in the yard at night, I guess trying to look in the windows of my house.
And where's this neighbor's house?
She is directly across the street.
Okay. And isn't it true, in fact, that this was very dark? It was very dark out.
Yes, ma'am, it was at night.
Okay. And your neighbor told you that she saw someone in her backyard walking, correct?
I think she said that when she confronted him, he kind of ran away.
Okay. She never told you he was at your window.
What she said was that he was trying to look in the windows.
In her yard?
The way the houses are situated, where he was standing, he was looking across into the windows of our house. Yes, ma'am.
And she couldn't see who this person was?
Object.
She told you?
She's asking Ms. Benefield about what the neighbor knew.
She told you she could not identify this person?
She said by just looking, as dark as it was, she had a hard time identifying him by his face, but that she identified his voice.
That's interesting. So let's talk about that. So when she tells you that there's somebody in her backyard, you go to her house, right? You end up together with her.
Yes.
All right.
Not at her house, but yes.
And you play a recording that you've recorded, like a voicemail from Doug, for her, right?
She believed it was Doug, and she said that she could probably identify his voice because he had a unique voice. And so I played a voicemail I had from him, and she identified him.
The fact is, she didn't tell you she thought it was Doug. You just asked her if it was Doug.
I believe she contacted us and said that there was a strange man looking across into our windows, and she was freaked out, and she wasn't sure if it was him.
Okay.
I don't remember specifically. I'm sorry, this is a long time ago.
And you play a recording of Doug's voice for her.
Yes, ma'am.
And she goes, oh, that's him.
Yes,
That's the one that was there.
Yes, ma'am.
So that is the ID that Doug was in her backyard.
I believe she also described his body type, his stature. She said he was wearing a baseball cap, which he often did. So I think that was probably
Don't a
part
lot
of
of
it.
people wear baseball caps?
She needs to allow
I'm sure.
clear answer before she cuts her off.
I've been able to follow along, so I'll overrule at this point.
There's a lot of people that are 5'9", right?
Oh, yes, ma'am.
A lot of people that weigh 160 pounds.
Yes, ma'am.
A lot of people that wear baseball hats.
Yes, ma'am.
And isn't it true that this person in the backyard said to her, I live around here, I live here?
Mm-hmm.
Okay.
I believe so. I wasn't there for that part, but that's what I believe she told me.
Thank you. Now I want to move forward to 2019. Around this time, Judge Moreland had already ruled that you could not have your injunction, right?
She denied it, yes, ma'am.
And that Doug could have immediate visitation with his daughter.
She ordered time sharing, yes.
Did you start visitation with Doug and Emerson very shortly after that hearing?
Yes, according to the court order, yes, ma'am.
And you decided you were going to go with him on this visitation?
I offered, and he said he would be glad for me to come, so yes, I went.
This person that you lived in a nightmare with, you decided to go with him on this visitation?
Yes.
Now, the Judge Moreland hearing, when she ruled, she made it very clear that she did not see your side.
Sustained.
You had no faith that Judge Moreland was going to help you from that day forward.
Overruled.
You had no faith that Judge Moreland was going to help you from that day forward.
I don't know that I'd say I thought she would never help me, but I mean, she denied the injunction, yes.
So you go for this visitation with Doug, along with him and Emerson, and that begins sort of a, I think Stephanie Murphy called it like a honeymoon period or a happy period piece. Would you agree with that?
Yes, ma'am.
Okay. So during this time, you spent a lot of time with Doug.
Yes.
And a lot of time with Emerson.
Yes.
And you weren't scared of Doug at that time?
He was being very kind.
Okay. So you weren't scared of him at that time?
No. I mean, I had things at the back of my mind, but he was being very kind.
So then around summer of 2019, you actually make arrangements with Doug. He's going to move into your mom's house.
He wanted to move in, yes.
You actually agreed to that?
Not specifically. He didn't really ask my opinion. He told me.
Okay. And then the date that he was supposed to move in, you made plans with him,
Hold on a
correct?
second. Sir, who's crinkling the paper? Is that Mr. O'Keefe? Sir, can you please stop? Thank you. Go ahead.
So during this time, you're speaking with Doug.
Yes.
Right?
Yes.
And you're talking with him about moving into your home.
He was insistent that we needed to
The
move in
answer is
together.
yes or no, please. You were talking with him.
She interrupting the answer.
If the question calls for yes or no, the questioner has the right to expect a yes or no, or I don't know, or I don't recall,
So
as opposed to a narrative.
You were speaking with Doug about him moving into the house
Yes.
and about his things being moved and when they were going to be moved.
Yes, I'm sure.
And at any time during this, did you say to Doug, no, you're not moving in?
Yes.
You said no.
I'm sorry.
You told him, no, he cannot move in?
Yes, that's why he ultimately didn't move in, as I said, I can't do this.
Isn't it true that, in fact, you didn't tell him no, you just weren't available the day he was supposed to move in?
No, that's not correct.
Okay. So you're saying the day he was supposed to move in, he knew he wasn't supposed to move in? Is that what you're saying?
We had a conversation that day, and I told him that I didn't want him moving in.
Okay. And then you did not take his phone calls. You would not speak with him. I think the word was ghosting. You ghosted him.
I don't know whose word that is, but that's fine. Yes, ma'am.
Okay. But visitation continued.
Yes, ma'am.
Right. And you continued to exchange custody of Emerson where? The sheriff's office or?
I believe at the time we were doing the sheriff's office.
And sometime around this time, you show up to this visitation with an engagement ring on, right?
No, ma'am.
Okay. Who is Dennis Beatty?
Dennis Beatty?
Beatty. Who is that?
He was a gentleman I dated at one point.
And it was during this time that you were dating him, right?
After I told him not to move in, and then we started just doing time sharing with Emerson. Yes, after that, there was a period of time where we dated. Yes, ma'am.
And isn't it a fact that Doug filed for a divorce after one of these visitations?
I'm not sure when he filed for divorce specifically.
He filed for divorce after he knew that you were dating this other man, right?
Once again, I'm not sure when he filed.
How did he find out? Did you tell him you were dating him?
No, ma'am.
Right. How did he find out?
I think he was stalking me.
It wasn't the ring on your finger?
It was not an engagement ring. Yeah.
Well, it was a ring. Did he see the ring on your finger?
I'm not sure what he saw. I wear rings all the time.
Okay. So Doug files for divorce. And all of a sudden you file for, you start a bunch of complaints, correct? About his treatment of Emerson. What you say, his bad treatment of Emerson.
Well, she started coming home hurt.
It's a yes or no question. Did you file complaints about his treatment of Emerson?
Yes.
Okay. And you eventually filed for another petition to get an injunction based on those incidences that you claim happened with Emerson.
Yes, ma'am.
Okay. And you complained about the first time and nothing was done. Is that correct? With the police, no charges were filed, nothing was done?
I'm not sure specifically what you're referring to.
The first complaint that was made
about
Emerson and Doug, you agree that you made allegations.
Object. Can we?
Yes.
I'm not sure specifically what time you're referring to.
During the time that there were allegations that Doug was abusing Emerson, did you speak to the sheriff's office?
Yes, ma'am.
On numerous occasions?
I would say so, yes.
At least 5?
Probably, yes, ma'am.
And during those conversations,
today's so long, I'm going to speed it up to 1.5 again and see if it ends up being too fast. We can go back down. We've been doing 1.5 the whole time, but they're still there, and it's...
You were making allegations that Doug was abusing Emerson, right?
I was explaining the injury she'd come home with. I wasn't there. I don't know what happened.
Okay, but you were alleging that Doug was abusing the child.
I was concerned after her pediatrician called CPS and said that she thought she was being abused.
Are you aware that pediatricians are required to call CPS when a mother alleges that?
I didn't allege anything. I brought a video to show her at the appointment, and she called CPS.
Objection.
Well, after showing her a video of some behavior, she called CPS and she informed me that I was also a mandatory reporter and that it would be negligent if I didn't also call and make a report.
You brought Emerson to the pediatrician specifically for this reason, correct?
No, ma'am, she had her checkup.
But you brought this up to the pediatrician.
At the end, she asked if either of us had any questions.
And that's when you bring up, oh, she must be being abused.
No, I described to her the behavior that I was seeing, and I showed her a video when she came to her own conclusions.
Okay. So you spoke to the sheriff's office about that investigation and other investigations, and about that investigations that Doug was abusing Emerson.
A sheriff usually comes out with the CPI from Child Protection.
And you spoke to them?
I mean, they were there when I was talking, I guess, yes.
And you were talking, making allegations against Doug, assuming that he caused injuries to Emerson.
I'm not sure of my exact words. I was trying to describe to them what I was seeing and my understanding of the situation at the time.
You filed a petition for an injunction based on those things, correct?
At the advice of my attorney, yes, ma'am.
Okay. Whether your attorney advised it or not, you chose to do that, correct?
Yes, I followed the advice of my attorney.
And you were aware that if you went forward on this injunction, that it was going to be in front of Judge Moreland?
Yes, ma'am.
And this injunction hearing was supposed to take place on September 30th of 2020. Yes, 2020.
Yeah, it got moved several times, but that was a date.
Okay. So it was supposed to take place on that day?
Yes, ma'am.
And there were other things pending? Do you know what the other pending items were?
Not specifically.
Okay.
I'm not sure what you're asking.
One of them was Doug's request for a divorce, correct?
Yes, we both filed for divorce at that point, yes.
So Mr. Benefield filed for divorce, you file an injunction petition, then you file for divorce.
I filed for divorce first.
Okay. And then you're scheduled to have this hearing on 9:30.
Yes, the hearing was scheduled for 9:30, yes.
And you're speaking with Doug during this time, right? I mean, we just heard 200 and whatever text messages between you and Doug.
Yes, ma'am.
So do you at any time in that say to him, I'm going to go forward with this injunction on Wednesday, on the 30th?
No, ma'am.
In fact, based on those text messages, you were dropping the petition for an injunction.
Yes, we talked about dropping everything, yes.
Okay. No, you talked about it, but you said you were going to.
Yes, ma'am.
And that is what the result of the mediation was, that there was not going to be any mediation really because you were reconciling.
Yeah, we agreed, I guess, in order to move to Maryland. My understanding, the attorneys were advising us to, if we close things down, that it would make it easier, like legal-wise, for us to relocate.
So you were telling Doug that's what you were going to do.
Yes, we were trying to work things out so we could all go to Maryland, yes.
And drop the injunction.
That was one of the things.
And you wanted him to drop everything, right? The motion to release the report, the dissolution of marriage, you wanted him to drop everything.
No, we filed a joint stipulation so we could get the report.
But then you asked him to drop that, didn't you?
I know we kind of went back and forth with so many things.
Okay. You never had any intention of not going forward on your injunction?
Honestly, it was kind of one of those things that some days I thought that maybe I should and some days I thought that I shouldn't.
So during this 1 week before you shot Doug, you're talking and you're saying to him things like, oh, we're packing boxes, we're getting everything together. This whole time, you knew you weren't going to stop that injunction hearing.
I hadn't decided yet.
Okay. Your attorney testified that you were going forward on that injunction hearing.
She was advising me to keep it.
Okay. So during this time when you're telling Doug to bring different boxes, bring tape, you asked him to go to Selby Gardens, right?
Yes, we all went. I think we got lunch. We brought Emerson so she could play.
Okay. And you are having conflicted emotions about whether to go forward on an injunction?
Yes, ma'am.
While you're out having these types of experiences with Doug?
Yeah, sometimes things are really good and other times they weren't.
Okay. And so how about, let's see. This is part of State's Exhibit 98.
Jeez. I didn't know what it's doing. I think it's giving you clues that I gotta guess. Get real? Real?
Working mother, not a working mother.
Working mother, not a working mother?
Not a working mother. Better than a
Slum. Oh, no, it's running out of time. House. Real house. White. Oh, housewives. Oh, real house. Oh.
And this video was taken the week before you shot him, right?
I don't know the exact date.
When was? I mean, in your mind, it was very close to the time, correct?
Yeah, I'm sure it was right around then. I don't remember when it was.
And during this time that you were having these text messages with Doug and you're planning to move to Maryland, there's no violence going on?
No.
No?
I guess not, no.
He's not hitting you?
No, ma'am.
He's not choking you?
No, ma'am.
He's not shoving you around?
No, ma'am.
So this entire time, there is no violence going on?
Well, I don't know specifically what time frame you're talking about. I'm sorry.
But during this, let's say from 2018 to 2019, when you're not living with him.
I mean, if you classify violence as him like
I'm asking
punching me or
if there's
choking me.
physical violence during this time.
He could be rough sometimes.
Okay.
Yeah.
Did he ever punch you?
Not during that time, no.
Did he ever hit you?
No, ma'am.
Did he ever use a weapon against you during that time?
Not during that time, no.
So in between the time of 2019 to 2020, where you shot him, was there any physical violence?
Like I said, sometimes he'd be a little rough, you know.
But other than that, he never was physically violent.
He didn't like punch holes in the walls or anything like that, no.
So when I asked you, has he been violent? You said, well, he didn't punch holes in the walls. Is that what you just said?
That's what I just said, yes, ma'am.
So punching a hole in a wall to you is a definition. When I ask, was he violent? Your definition of that is punching a hole in a wall.
I think that is violent.
Okay.
I'm not sure what you're asking.
So, hang on just a second. So I want to get to the day that all of this happened. This happened on a Sunday, right?
Yes, ma'am.
And you're moving on, or you have a hearing on Wednesday.
I believe that's correct.
And you're moving right after that.
I think the actual day of move was kind of in flux. It seemed like it changed 1,000 times.
You're all getting in the car together, not together, but you're driving cars together to go to Maryland.
Yeah, I believe he was going to be driving the U-Haul and pulling his truck. And I think that my mom was driving her car and I was driving mine.
And you were telling him during that time that you were going to move to Maryland and attempt to reconcile.
No, ma'am.
You weren't telling him that.
No, not in those words, no.
Did you hear Dr. Broder testify about that? That he said that when you were with Doug. So you're denying that you ever told Doug that you were wanting to reconcile with him?
I said I wanted to find a way that we could do things together as a family for Emerson's sake, you know, and that's why we started doing things differently. He wanted to move back in, you know, together, and I told him that I didn't want to do that. I didn't feel comfortable with that.
Did you say that in Dr. Broder's office? In front of Doug?
No, not in front of him.
So when you're with a safe person, a psychologist, you're not telling Doug this.
What? I'm sorry?
You're saying that you told Doug when it was just the two of you that you didn't want to move in together.
Yes, ma'am.
And you felt safe telling him, I don't want to move in with you, right? That's what you're saying.
Yes, we had that conversation many times, yes.
But you're in front of this psychologist who one would think is a safe environment with Doug sitting next to you. You hear Doug say to Dr. Broder, we are going to Maryland and we are going to try and reconcile. And you don't feel safe enough to say to Dr. Broder, no, that's not what I want to do.
I would want to make him look bad in front of somebody else.
Okay.
I wasn't going to disagree with him in front of anybody.
Okay.
Remember I said that a little while ago, that while even when it comes to other people, even if they're doing things like this, you still have that that desire to protect them, and not because you don't want other people to dislike them.
So the plan was to load up the truck, get everything done, and then move very shortly after the court hearing, right?
Yes, ma'am.
Okay. And you had no intention of dropping that injunction, so you knew on the day of that hearing, he was going to know, right?
I'm sorry?
You knew that Doug was going to know that you had no intention of reconciling with him.
We had the conversation many times. I think he understood where I was at.
Okay. You saw the text messages between you and him, right?
Yes, ma'am.
Would you agree that those text messages do not indicate that?
It doesn't say we're getting back together, moving in together.
It doesn't say we're not going to reconcile.
I mean, not specifically, no, I wasn't going to argue with him.
If you got your injunction on that day, September 30th, how would you have moved together?
Speculative.
What was your plan if that injunction was granted?
Different question. Over the
Judge, speculative.
No. You can approach.
So if the injunction were granted on that day, what was your plan about moving to Maryland with them?
I don't know that I really had a plan. I wasn't even sure whether or not I was going to go through the injunction at that point.
Okay, so I want to get to the night that all this happened. So you knew Doug was coming over.
Yes.
You invited him over
Yes.
to help you move stuff in the house.
Well, specifically stuff in the garage, but yes.
Stuff in the garage to the truck.
Mhm.
Right. And he came to your house a couple of times. He came and then left and then came back again.
Yeah, I believe he came twice that day.
And there is a gate to your community.
Mhm.
And when he's at the gate, you had to let him in.
Sometimes, because he was frequent in and out, sometimes the gate remembers license plates, and sometimes it opens, and sometimes it doesn't. Sometimes he would just follow people in. The gate kind of stays open for a while. Yeah, sorry.
But on this day, you weren't concerned about him coming over.
No, I knew he was coming.
Okay. And when he came over, your mother and Emerson went to the park.
I believe they were headed there. I'm not sure. I think they were down the driveway or on the sidewalk, something like that. They were on their way there.
You weren't so afraid that you wanted your mother to stay there and watch.
No, we were just packing to move.
Okay, so you weren't afraid.
I definitely didn't expect this to happen.
So it was okay with you that your mother left?
Yeah, at that time.
Okay. So if I heard you right during your direct, you said he bumped your shoulder twice. Body check, I don't know if that's what you called it. He walked into you with a box, right?
Yes.
And then at the end, you say he slapped you?
He hit me. I wouldn't know how to classify it. He struck me, he hit me.
Was his hand open or closed?
I don't remember.
Okay. And because of those things, you claim that you thought he was going to kill you.
He had never hit me before.
Okay. And you thought he was going to kill you.
He wouldn't let me leave. I tried to leave, he stopped me.
The question is, you thought he was going to kill you.
Yeah.
Okay. Now, when you were in the bedroom, you decided to get your firearm. And it was where?
It was in a storage bin on top of the laundry basket.
Okay. So I'm going to show you State's Exhibit 52. If you could turn around and look at that. Where was your firearm?
It was in the bin on top of the basket.
Here?
That's the basket.
Where was the bin?
It's that right on top.
Okay. So it was in here?
Yes, ma'am.
Why would you have a firearm in there?
I had just emptied all the furniture and everything out of my room, and it was kind of like what was left from my drawers, and so it got put into a bin.
Okay. And that was not your only firearm in that room, correct?
Correct.
You had a firearm in the closet?
My carry gun was in my backpack, which was my purse at the time.
So in this room, with a mattress and a broom and a hamper, you had two firearms?
Yes.
So you go into the room and you grab your firearm. Is it in a holster?
I don't remember.
Okay. And you claim that Doug does what?
He came and slammed the door open. He was standing in the doorway. He said, "You're fucking done."
He said, "You're fucking done." And that made you fear for your life?
Yeah.
Can we turn the lights up, please? Thank you. So he says you're fucking done, and you point the gun and you shoot.
I held it out in front of me first so he could see it. And I said, "Stop."
Judge, if I could have her step down so she can demonstrate.
You may.
If you could just come down. So Doug opens the door and does what?
Standing in the doorway, here, like this. He said, "You're fucking done." And I held the gun out in front of me and said, "Stop." He got into this like fighting pose where he like turned sideways. And he was like moving around with his like arms in his hands. And he started like inching forward towards me.
So he why do you call it a fighting stance?
He was like a fighter. Like I don't know, like a ninja or something, I don't know.
Okay, so he's standing there, he turns to like this and starts moving his arms around. Well, show me, what was he doing?
And like I really got like this, and he was like making like fighting motions. I don't know, I'm not a fighter, I don't know.
Okay.
It was scary.
Did he have his hands in fists?
Not at that point, they were like, I don't know.
Was he coming at you like this?
And he lunged at me really quickly.
Okay, so he lunged. Was his fist up when he lunged?
I don't remember.
Okay. So you start shooting, and he does what?
He kept coming at me.
Okay, so then you keep shooting again. And he falls down on his back?
His legs went up in the air.
Okay, where do his legs go?
In the air.
How high in the air?
I don't know.
Do they go over his head?
I don't know, it's like his feet slipped out.
Okay.
And his feet and his legs went up in the air.
And were you still shooting at the time?
I don't remember.
You can have a seat. So after this incident, you claim that you had swelling to your face, right?
All right, Mr. Jury, can you please close up your notes, put them on your chairs. I'm going to ask you to step out for a minute. You can use the facilities. It's not quite our mid-afternoon break, but we'll treat it as such. Please don't discuss it amongst yourselves. Don't discuss it with anybody outside the jury. Don't do any research like we talked about. All right, the jury's out. You can have a seat.
I'm sorry.
All right, we'll take 5 minutes. Yes. Seat. Welcome back, everybody. Usual questions. Did anybody discuss the case or anything about the case amongst yourselves with anybody outside the jury or do any research? Everybody says no. You may resume your cross-examination.
Thank you. Can we dim the lights again, please? Thank you. So after this incident, you said you had swelling.
Yes, ma'am.
And that would be to the left side of your face?
Yes, ma'am.
And that would be where? Show me where.
Like in this area.
Okay. Now I'm going to show you State's Exhibit 103. I'm going to put it up on the big screen. Can you tell me what this is?
It's a picture of me.
And when was it taken?
I have no idea.
Was this taken before you met Doug?
I believe so.
And I'm going to show you State's Exhibit 104. And I'll move it up a little bit. When was this picture taken?
I believe in October of 2020.
Wasn't it taken on November 4th of 2020?
I believe that's correct. I'm sorry.
Thank you. I have no further questions.
Redirect. All right, man. You can retake your seat. Just leave that exhibit there. But you take your water. I meant the paper. Okay. There you go. Yeah, that's all. Thank you. All right, defense, call your next witness.
I believe it's Mara Sweet, Your Honor. We're just checking to make sure she's here.
Because I think we need to have a conversation.
Okay. So I'm going to let you step in the back so we can have our legal conversations. I'll get you back out as soon as you have a seat. Is the witness in here?
She's right outside.
Okay, good. I want to make sure she stepped out. Okay, so the defense has called a Miss Sweet, who apparently is a former prosecutor in the 12th Circuit.
Yes.
And she, if I understand correctly, she was assigned in the misdemeanor division, the domestic violence division, and the case, the alleged violation of domestic injunction regarding the T-Set was assigned to her.
Correct.
And you expect her testimony to be that she intended to file the charge, she was waiting on some receipt.
Receipt of the package.
Like a mailing receipt?
Yes.
That would have shown what the return?
That Stephanie Murphy gave to Detective McGill.
And then you believe her testimony would be that she intended to file the charge, but then she was transferred out of that division.
She left the office.
She left the office, okay. Because that's one of the temporary assignments that they give to misdemeanor folks. So she left the office, and that's it?
Well, and her training, based on domestic violence training, she believed Ashley to be a victim of domestic abuse, and that Ashley exhibited all the symptoms of domestic abuse. In particular, remaining quiet as a result of intimidation And going, for example, the state's case is predicated on Miss Benefield going along with Douglas Benefield, for example, on the first parent sharing exchange. And the week leading up to the shooting, they put in those 263 text messages and the video at the restaurant, all showing Miss Benefield and Mr. Benefield's company as apparently happy and not afraid. And those are the classic symptoms exhibited by abused women. They are afraid to reject the abuser for fear of reprisal. And what happens is, after a while, they reach a state of compliance where physical threats are no longer necessary because they know what the potential is. So they become compliant. That's also what Bruce Ferris is going to enlighten the jury on. And I remind the court that this is the state's theory. They have put into play, they injected it, they raised it, initiated it, that because Miss Benefield didn't look scared in the company of Douglas Benefield, and that she was exchanging these text messages with him for the week leading up to the shooting with smiling faces and basically compliant behavior, that shows that her claim to fear of Douglas Benefield on the 27th is a fraud. And we now need to explain to the jurors why an abused woman would act like that and would, for example, not agree to be present at the first parent sharing exchange. When a child is involved, it magnifies the situation so that the mom, if she's afraid of, in this case, Mr. Benefield, because of prior acts of domestic violence, she's even more afraid for her child. So the mother's going to make it a point to accompany the abuser in an effort to protect her child. That's what we are now obligated to show to properly defend this case. And we can do that through the training and expertise of Samar Sweet, as well as Bruce Ferris.
Judge, first of all, this witness was not listed as an expert, because if she had been listed as an expert, I would challenge the qualifications to be an expert. Just for your Honor's knowledge, we did not have a domestic violence unit at the time. I know our office has in the past. We did not have a domestic violence unit, so she was not in any domestic violence unit. Even if she were an expert, there is absolutely no way that she could testify that she felt that Ms. Benefield was exhibiting behaviors of an abused person. I think it's completely improper. And the issue of the decline of the injunction, or the fact that Ms. Sweet intended to file, is irrelevant. I can tell Your Honor, and for the court's knowledge, it's because when we got the receipt, when that package was sent, that receipt showed a date that was a problem for us. And that is why that case was declined. So the decision was made after Ms. Sweet left the office and we received the receipt. So the fact that she would be testifying, I believed her and I wanted to file it, is completely and totally irrelevant.
Yes, sir. Rebuttal?
Yeah, so the court may recall that Deputy Weber had issued a capias for the arrest of Douglas Benefield for the delivery of this package. Detective Gillen came into court and told us that he suspended Deputy Weber's request for a capias, and we have a communication from Deputy Gillen that we got by way of a public records request where he acknowledges, plain as day, that it was a violation, that it was during the time that the South Carolina injunction was in effect. But he nonetheless refers it to the state attorney's office. This is the assistant state attorney that was working that case. She would testify. We'd like to put her up for a proffer that she fully intended to file. She believed it was clearly a violation based on the fact that the court.
Well, I'm just saying, if you want to proffer, let's get her in and proffer, because then all these arguments would happen after the proffer.
Okay.
I mean, but I haven't made a ruling, so I'm just, you can make your argument, I can make a preliminary ruling, and then you can proffer.
Yeah.
Okay. Mr. Taylor, you didn't go outside. So, listen, how about I do this? The jury's out. It's about 3 o'clock. I'm thinking maybe give them a 20-minute, a longer afternoon break. When I do that in the afternoons, I will typically have a deputy escort.
I'm going to skip through this.
Now, make yourself comfortable in this seat. Pull yourself up so you're about 12 to 15 inches from that microphone. There you go. Adjust up, down, left, right, however you need it. Jury's not here.
Your full name and spell your last name.
Yes, Samara Sweet, SWEET.
Are you currently employed?
I am.
What's your title and where are you employed?
I am the trial lead of counsel at Lydecker, which is a civil litigation firm.
All right, and you're a Florida Bar licensed attorney?
Yes, sir.
At one point, were you a staff attorney for the Manatee County State Attorney's Office?
Yes, I was.
How long did you serve in that capacity?
I stayed there from 2018 to 2022. It's about 4.5 years, I believe.
All right, and during that 4.5 year stint,
was there any special assignment that you held?
I began with the misdemeanor division here in Manatee County. After 6 months, I moved to Arcadia, so I was in DeSoto County, where I started in misdemeanors and moved up into felonies, where I would have dealt with anything from possessions of controlled substances all the way up to child sex crimes and murders.
Specifically, did you have any training in domestic violence?
We did. Every attorney at the state attorney's office does go through CLE's trainings on how to deal with domestic violence victims, because especially when you're working in the misdemeanor portion, a lot of your crimes are batteries and a lot of them are domestic violence victims.
Can you give us an idea of how many cases you handled involving domestic violence?
Oh, I think at one point my caseload was 700 when I was in Arcadia, and at least a third of those were probably something domestic violence related.
Did you deal with not only abusers, but the abused?
Yes, most of the cases I had as a prosecutor, my victims were abused individuals.
Were the majority of your victims in domestic violence cases females?
I would say a large amount were females, yes.
Were you assigned, while in your capacity as an assistant state attorney for the 12th Judicial Circuit, were you assigned to a matter involving Ashley Benefield?
I was, yes.
How did that come to pass?
So when I was in Manatee, I had the caseloads with all defendants that had the last names with B, B, or I. So Ashley Benefield's case came to me, and she was the victim, and the case had been assigned to me for a violation of an injunction.
Do you recall specifically the nature of the violation?
It was a package that had been delivered to her, allegedly from her ex-husband.
All right, and the domestic violence injunction that was violated, do you recall from where it had been issued?
It was from out of state. I believe it was South Carolina.
And did you meet with Ms. Benefield?
I did.
Do you remember on how many occasions?
I believe it was twice, because when the case first came, there's elements to a violation of injunction that have to be met. We had not yet had all the information, so I did meet with Ms. Benefield, got some more information, and then had to follow up on the investigation. I had to meet with her again after that.
Did there come a point in time when you made a filing decision?
I did not. I had left the office before a filing decision was made. I had been moved to Arcadia at that point.
I should have articulated that question better. Had you, as part of your investigation, individually reached a conclusion as to whether or not you felt it justified going forward and charging?
I did. I think I was still waiting on some information to prove if the package had actually been sent by Mr. Benefield, and that was the last information that I had left to my predecessor before I left, but I did think that if that information was given, there was enough to file.
And would it help refresh your recollection if I suggested that you were waiting on a copy of the receipt for the package?
Yes, I was waiting on to see who had sent that, and I know I had been in contact with the officers involved.
Do you recall whether or not you were dealing with Detective Gillum?
I'm very bad with names, so I do not want to say yes or no, sir, if it was Detective Gillum or not. That does sound familiar, but I might have worked with him on other cases as well.
All right. How was Ashley Benefield when you first met her? Can you describe her demeanor?
She was very upset. She seemed scared, worried. She had come to my office, and she was crying when she was sitting in my office with me. I did think that she was worried about the package that had been received.
Now, was it your practice generally to always meet with the victims in the cases that you were prosecuting?
Yes, it's office policy.
Had you formed an opinion about the genuineness of the fear that Ms. Benefield expressed?
I did believe that she was in fear and worried about that.
And from the investigation that you conducted, did it vindicate, other than the actual label for the package, the factual representations that Ms. Benefield had made to you? Want me to restate that?
Yes, please.
Yeah, that didn't come out too good. Did your investigation corroborate the facts that Ms. Benefield related to you?
It did, yes. There had been a package received. The package, I know she believed had some weird smell coming from it, and my recollection was that had been investigated, that the package had been delivered to her. I think she said it was close to her birthday, around that date. I can't remember exactly. But it did. The facts that I had investigated did lead up. South Carolina, when I reached out to them, had said they had given an injunction for her.
All right. And do you recall contacting the toxicologist with respect to the contents of that package?
I did. She had brought me a toxicology report on that meeting, and I did call the doctor. Now, in all candor, I can't confirm if that's exactly the doctor, but I did speak to someone on the phone who said that Ashley did have weird things in her blood system at the time that did not correlate to someone's normal toxicology. But she couldn't say from where that had come from, but that there were abnormalities in that report.
And you say you have considerable experience with women who have been victims of domestic violence?
Yes.
Is there a certain pattern in your training and experience that you see in these women?
Yes. So a lot of times we'll have a lot of these meetings involve an abuser. We have the abuser who has abused someone. By the time they're coming to us, a lot of time has passed. So we always want to explain to them that normally we see a cycle. You have an abuser, he does something wrong. Then it's, I'm sorry, I'm very, very nice. They come back, and then we end up again in the situation with more abuse.
Kind of like a hamster wheel.
Yes.
Did you form an opinion as to whether or not in your discussions with Ms. Benefield that she fit the profile of an abused woman?
I did. When we discussed, she did seem that she had been isolated at that time. She was very scared. The way she had spoken to me did give rise. She had mentioned some minor physical issues that had been occurring, but abuse doesn't always have to be physical. Sometimes it's psychological, mental, emotional. And she was in my office when she was sitting. She did seem to be presenting like that.
Is it a pattern and practice of abusers to employ psychological intimidation?
I mean, normally a lot of the times in the reports I would have, we would have something of threats or some sort of information leading up, text messages, Facebook messages, things of that sort.
And let me ask you this. Are these abused women, despite their fear, often in the company of the abuser?
A lot of times I've seen them return back to their abusers, yes.
And have you experienced abused women, when in the company of the abuser, acting as if everything is fine?
I wouldn't be able to say I've seen them with their abusers, but a lot of times if we were in court trying to present, I would see them come in to defend the defendant that we had or to withdraw claims and that kind of thing.
I guess the point of my questioning is, merely because the woman appears content, is that an indication that she's happy in the company of the abuser?
No.
Why is that?
I mean, I have more facts by the time I've seen the investigations, I've seen interviews, things of that sort in our caseload. They might be presenting, telling the judge something, but clearly we've seen, photos of abuse. They've sat and given us recollections of abuse, that kind of thing.
You left the office before you were able to actually conclude and file a charging document.
That's correct.
And as you sit here today, do you know what the disposition was?
I believe it was decided to not move forward, so it was dismissed.
That's all, Your Honor.
Close.
When you were in the misdemeanor division in Manatee, I think you said 6 months.
Yes.
So what was the time frame then?
I know I had started, I want to say April of 2018. So it would have been 6 months from there because I think I got out to Arcadia around October, November-ish.
Okay. And was the misdemeanor job in Manatee your first job out of law school?
No.
No. Okay. Did you work, where did you work before that?
Before I worked with Eric Reisinger, I actually did criminal defense.
Okay. Okay. So when you talked about the domestic violence training, were you referring to the domestic violence training at the state attorney's office?
Yes.
Okay. And was that the normal domestic violence that everyone is sent to, the class?
Yes.
And how long is that class?
I think it's 4 days.
Okay. And is there any other domestic traiing?
I know the office does some pretty good domestic training. They'll do PowerPoints, luncheons, things of that sort. I think there's some, I don't know if they still do it because now I'm aging myself, some field trips to like the TILA and some of those organizations that work with abused women.
Okay. Thank you. I don't have any other questions.
Thank you.
No, I think that's all.
You can step back onto the hall, please.
Yes, sir.
She looks so young.
She's out. Proponent, you can start with your, there you go. She's waiting in the ante room. Now we got her in the hallway. Proponent of the evidence, argument.
Yes. So, Your Honor may remember that Detective Gillum made the allegations 2.5 years later, despite the fact that there was no earlier report documenting what he alleged 2.5 years later in any of his 2 or 3 prior supplements, that Ms. Benefield acted completely inappropriately, that he did not believe that the South Carolina domestic violence injunction was in effect because even though the hearing was on November 3rd, the judge hadn't signed the order until the end of the month. And therefore, he countermanded Deputy Weber's request for a capias. This witness impeaches the statement by Detective Gillum because she was the assistant assigned to the case at the time, and she had made a decision that, in fact, she was going to file, but for the fact that she left the office beforehand. She had conducted the investigation, completed it. All she was waiting on was the label of the package, which, interestingly enough, the court may recall, Detective Gillum recovered from Stephanie Murphy. But it apparently didn't make its way to Samara's suite until after she left the office.
All right. And the objecting party?
Judge, I would object. I don't think she can testify as to anything. She just testified to. I think most of it is opinion, and she is not an expert. And even if she was an expert, she wasn't listed as an expert, so she cannot give opinions. And any opinion about whether someone, as a prosecutor, whether someone violated the law or not is inappropriate testimony for court. A lot goes into filing decisions. The prosecutor has discretion the same way police officers have discretion. To add any significance to that, I think would be completely improper. And so I would object to anything to do with her decision-making with the state attorney's office. And also, as I said, I think there was some information that was gained after she left. that played into that decision. But additionally, I think she would not qualify as an expert of domestic violence, and I think even if she could, a lot of those things would be inadmissible anyway, what she would say.
All right. Mr. Taylor, do you have any final thoughts you want to put on the record? Any final thoughts? Rebuttal?
That's right.
All right, thank you. So one of the very interesting things about this case as we have gone along is there have been some very interesting, and I think I said the other day, unique legal arguments that have been made. Certainly, I would like to think it's in honor of the Olympics starting tonight that you guys have put me through my mental gymnastics for the last couple of months. You know, another judge that's here in Manatee County, I hear him say this a lot, and I think it rings true. There are some very difficult decisions that we make as judges, emotionally difficult, legally difficult, factually difficult. This is not one of them. This is a very, very clear and easy decision. I'm going to put the part about Ms. Sweet offering any sorts of opinion as an expert kind of to the side because I resolved this matter well before I consider that she wasn't listed as an expert and the Richardson aspects of that. And what I want to focus on is the purpose of allowing these other incidents of violence or threats is, as we all know, it's one of the carve-outs of obviously case law provides an exception in stand your ground and self-defense cases for battered spouse syndrome. Normally, any peculiarities for a particular defendant, PTSD, low IQ, mental health, are the ones that come to mind quickly, are not relevant and not admissible in a self-defense case because it's a reasonable person standard. So battered spouse syndrome is the carve-out, and the idea by once the defendant has laid the predicate of the overt act, allowing either reputation, and if it's reputation in a relevant community, we've all agreed, well, should agree, the case law says that the defendant doesn't have to know about that. It's just reputation evidence. On the flip side, whenever you want to get into specific acts of violence, threats, intimidation, and I know our net that we've casted here is beyond just prior acts of violence. There's also been issues of threats and intimidation. It's come in, it's in. The case law talks specifically about why that evidence is allowed and why all of that is not hearsay, because it's not offered for the truth. It's offered to show the jury what did the defendant know at the time that the self-defense was used. And unlike the mental ailments I mentioned earlier or other peculiarities of the particular defendant, this is just to show why the defendant would have stayed, and even if there wasn't an imminent violence at the moment, why that person would feel terrified, and all the other battered spouse. I won't go into the whole thing. So the issue is not, did this assistant state attorney believe the defendant? Did this police officer take a report and submit a capias or not issue a capias and send it to the state as a non-arrest? Did this ASA file it or not file it? Did this ASA believe that the defendant was the victim of domestic violence or not? All of those things are completely irrelevant, not to mention prohibited from the witness commenting on ultimate facts or invading the province of the jury. The issue is not the truth or falsity of the violation of injunction or the shooting into the ceiling or any of those issues. That's not the issue. The issue is, was the defendant aware of these prior acts? Example being that the evidence came in regarding domestic violence by Mr. Benefield against his first wife. The way the defendant learned about that was some sort of text message by or between Mr. Benefield and the former Mrs. Benefield. Clearly hearsay. But why does it come in? Because she was aware of it, and it shows some violent tendencies, so she can testify about it, she can talk about it, the jury hears about it to help understand what she knew, and this is in the jury instructions as the attorneys know, what she knew at the moment that this incident was happening. So Ms. Sweet's testimony about whether she believed the defendant or not, whether she was going to file or not, the conversation, whether she thought that the defendant was genuine and legitimately a victim, the testimony that she had some report and she called someone and there were some sort of abnormalities, unspecified abnormalities in some lab test that characteristics of domestic violence victims and so forth is just of no moment. So it's irrelevant. It's commenting on the testimony of and the credibility and veracity of other witnesses. It's commenting on ultimate facts. If you want to talk about the expert portion of it, as the defense said, this is all the same things that Ferris is going to testify to. So in essence, I haven't heard his testimony, but what I understood was everything, I believe it was something along the lines of what she's going to testify to is the same as what Mr. Ferris is, and I only say Mr. because I don't know his professional designation. So Mr. Ferris is going to testify to. Finally, on the issue of 403, Ms. Sweet's testimony, the probative value of that is substantially outweighed by the danger of confusion of the issues and misleading of the jury, because it does not matter whether that particular person believes it was a violation of injunction or not. The point is, the testimony is out. It's been demonstrated that the defendant knew about that. She's alleged it was a violation of injunction. There's a dispute. That'll be a factual issue for the jury to determine. But she's alleged it was a violation, which she took as intimidating. And the smell that caused her headache was some sort of physical ailment that would have been caused by the present that was provided. I understand that's her position. The state may have a different argument on all that. But this is not even a difficult question. Ms. Sweet is not admissible as a witness. I am glad you proffered, though, because now it's all on there. But no, she's not going to be allowed to testify to what I heard today. Do you have another witness we can call?
Yes.
All right.
We have an objection to him as well, Judge.
Oh, now, Mr. Ferris is the expert.
Yes.
And the state wanted to have a...
Judge, I'm sorry. We do have a lay witness that we want to get on. Amy Carlton. She's going to be quick. We need to get her back to work.
Oh, hold on. Amy Carlton. And then I assume, I know that's bad, that Mr. Ferris, tell me, does he have a professional designation? Is he a doctor or?
He's a licensed mental health counselor.
So he's Mr. Ferris.
Former deputy sheriff. His practice and his law enforcement experience has been combined exclusively to domestic violence. He teaches batteries.
I just want to know if he had a professional designation that I should use. All right. So Mr. Ferris, looking at the time, I would think that after we finish with Ms. Carlton, the Daubert hearing is very likely going to take us to the end of the day. So I expect that we would probably start with Mr. Ferris on Monday. Mr. Taylor?
Well, Your Honor, actually, we have some case law that I was hoping would obviate the necessity for a doubt return.
All right, well, do you want to handle Ms. Carlton first?
Please.
All right.
Ms. McDonald just needs to go to the ladies' room, so.
Oh. All right.
Well, if you want to bring her back in, that's fine. If you
So
want.
yeah, we can start working it back up.
Yeah.
I think that would be good. So let me give you guys 5 minutes. If you need to step out, Mr. Taylor, Ms. Benefield, if you need to step out and use the facilities, that'll be fine as well. We're going to start working on getting the jury up. It usually takes about 5-10 minutes. Yeah.
All right, let's skip forward.
My name is, it doesn't move you, just a...
Would you tell us your full name and state your last name, please? Spell your last name.
Spell my last name? Carlton.
And your first name?
Okay.
I'm
sorry?
What is your first name?
Amy with a Y.
Okay, Amy. Or Miss Carlton. Are you presently employed?
I'm presently employed, yes.
Yeah, where?
Where?
Where, for who?
I'm at one of the hotels in the area.
Okay, and what capacity do you serve in at the hotel?
I'm one of the managers.
How long you been doing that?
What was that?
How long you been doing that?
I've been with the ownership for 4 years now, going on 5.
Are you married?
Yes.
What's your husband's name?
Herbert.
Miss Carlton, were you and your husband Herbert living in Bradenton, Manatee County on September 30th, 2020?
Yes.
September 27th, 2020.
Yes, we were.
Do you recall that afternoon if you were outside with your husband?
Yes, we were.
Do you recall the address you lived at back then?
It was on Newport News Street or Drive. We've been renting, so to be honest with you, I don't recall the exact street, the number of the street, but it was Newport News.
Do you recall, Miss Carlton, whether or not, what was the reason why you and your husband were out that afternoon?
I have a mini golden doodle, and we were taking a walk.
Did anything unusual occur while you were out with your husband and the dog?
Reason I'm here, you know it. I mean,
Would you share it with us? What happened?
we were taking a walk, and Newport News is a couple streets over from the incident area, and it was probably 3 houses down where we were, and at the time, my dog was probably just over 1. So I don't know. I'm a big dog lover, and she's my life outside of work with my husband. He and I both heard what I don't know. I didn't know what it to be, and he kind of grabbed my arm, and I kind of got startled because it did sound like gunshots. I don't know. You know, at the time we didn't know what it was, and but we heard one right after the other. And me, because of where I work, I'm trained like the attack or panic mode. I am thinking of myself. Sorry to be selfish, and my dog and my husband. And he's looking ahead too. And I just remember being a little bit terrified myself and thinking of myself, my family. And so I remember looking up and telling him, well, let's go, let's turn around, let's go back behind the house, because at the time we weren't sure what it was. And also being trained, you don't know what is to come next. First of all, you don't know what it is. So as I'm telling my husband, I told him, call 911. As I'm telling him that, I'm sorry, I'm backing back behind the house because you don't know what's coming next.
All right, let me ask you a couple of specific questions if I can.
Yes.
You say you heard some gunshots.
It sounded like gunshots.
All right. Now, after you heard the gunshots, did you observe anybody exit a house?
quickly, as we were trying to make sure of our safety, we saw someone leave the house, a lady leave the house. It was, I mean, I don't know exactly, like timing wise, because it's like I said, my mind was going through a lot of things.
Let me just keep you on the questions, okay? I'll help you. I'll lead you through it. You hear the gunshots. The next thing you see is what?
A lady came from the house and
Describe.
I remember screaming, and that's just the vivid recollection and memory that I have, just the screaming, and I came from the house running to the neighbor's house. I don't remember too much other than the screaming and pounding on the neighbor's front door.
Is it a safe bet for us to say that this lady that you saw exit the house screaming was hysterical?
Yes.
I want you to tell us, Miss Carlton, after the gunshots, approximately how long it took for that woman to come running out of the house.
So I'm not sure I recall. It was within seconds, though. It was, I don't know. It just. I mean, I didn't even have time, like I said, to pursue any hiding. It was so quickly.
Do you remember speaking to the police about the incident?
We had an interview. Yeah, it was probably 30 seconds, a minute. I don't know, 30 seconds.
Okay. So you hear the shots, and within 30 seconds, a screaming, hysterical woman comes running out of the house and goes to the neighbor's house.
Yes.
Did you hear banging on the door at the neighbor's house?
I don't recall if I remember stating that or not, but I remember the hysteria of the screaming.
Okay. That's all I have, Your Honor.
Can the witness be released?
Yes.
Yes.
Thank you, Ms. Carlton.
Ma'am, you've been released from your subpoena, so you're free to go. Thank you.
All right.
All right, go ahead and approach. About Mr. Ferris, I think we've talked about it quite a bit. I'm ready for the hearing. That.
Last name's Ferris.
Mr. Ferris, what type of work do you do?
I'm a licensed mental health counselor. I do individual therapy, and also I do consulting on domestic violence and expert witness testimony.
Let's discuss your education. Would you inform us, please?
Sure. I have a Bachelor of Science degree in civil engineering.
I'm going to skip through this part. Just the
excessive violence has to do with
experience.
Doesn't necessarily mean an intimate relationship. It means there's
your voice in the microphone because it tails
Sure.
off.
Thank you.
Please enlighten us.
If you look at my CV, I've given, I think, over 40-some presentations and teachings. For 8 years, I taught a batter's intervention program class to offenders, uniquely that. And for anyone that doesn't know, batter's intervention program is for offenders. It's usually court-ordered, part of probation or part of a sentence or part of an injunction or a restraining order. It's a 6-month psychoeducational class. I've been training for that and teach that. I also I used to teach Gardner Lightham volunteers about domestic violence.
Is there anything I need to hear about his experience? I'm assuming he's very experienced, or else they wouldn't be bringing him in.
Almost 1,000 individuals.
Let's stay in the past. How about any experience with the Gainesville, Florida Police Department?
Tried status, domestic violence threat effect, and
recipient of various awards and recognitions.
Yes, I have. Gave me recognition for 20 health for that work as a volunteer with University of Florida College Leadership Program. Not all of those did I testify. I did from one family or household member to another family or household member. So now the definition is what's a family or household member, and that's criminal law is acts of like battery and assault, ag battery, ag assault, false imprisonment, sexual battery, all these different person crimes from one family or household member to another family or household member. So now the definition is what's a family or household member, and that's people that are married, living together, maybe had a child together, but have never lived together. People living together as a family in a house. It doesn't include, let's say, cousins that never lived together. So it's unique in that way.
And is there another definition of domestic violence?
Yes, and in my practice and in my training, this is a pretty accepted concept, that domestic violence is actually a pattern of power and control. And the key word here is pattern. That's repetitive. And the criminal definitions, the physical things, those are used by perpetrators or abusers to control their victims. But along with that also is used control tactics. We often think about emotional abuse or those sorts of things, and they're defined in the Duluth Power and Control Wheel.
Would you explain to us what the Duluth Power and Control Wheel is?
So the Duluth Power and Control Wheel was developed up in Duluth, Minnesota by a group of researchers who deal with domestic violence. And what they did is they looked specifically at domestic violence cases that have been criminal cases, that victims who came through shelters, DV shelters, and they were looking for what were the tendencies or the tactics used by abusers against their victims. And they developed this power control wheel. It's used around the country. It's the Duluth Power Control Wheel is the basis for the Batter's Intervention Program class I mentioned. DCF, Department of Children and Families, has accepted that as a reality, a fact, and that was the criteria or the curriculum for the BIP class used statewide and actually used around the country and internationally. So there's these 8 inner items, and on the outside of the depiction, I don't know if...
All right, yeah, let's see if, Judge, with the court's permission, we put the screen down.
Yeah.
I stand over here. It's a little easier to see this way.
Absolutely.
Thank you, Judge.
Oh, you know what though? Microphones.
Okay. Can you hear me okay? Okay. Can you hear me now? Okay. So you can see that.
Yeah, I was going to say,
Sure. Thank you, Judge. Thanks for reminding me. So this is the Duluth, as I said, if you look here, Domestic Abuse Intervention Project. And this was established some, I don't know, maybe 30 some years ago, 30, 40 years ago. And this is the standard used around the country and used for the Batter's Intervention Program class and a lot of counseling I do. And this is part of the counseling along with cognitive behavioral therapy is one of the therapies I've been trained in graduate school and my work. So on the outside here of domestic violence is physical violence and sexual violence. And that's covered in the state statutes, the criminal law statutes. Then there's these 8 items that are part of the power control. And remember I said it's a pattern of power control. So that means it's repetitive, a way to get your it's a way for the abuser to get their victim to comply, to get into a compliance mode. I'll talk about that in a moment. So the first item is using intimidation, making her afraid by using looks, actions, gestures, smashing things, destroying her property, abusing pets, and displaying weapons. Those are I run into this all the time in terms of using intimidation. Using emotional abuse, putting her down, making her feel bad about herself, calling her names, making her think she's crazy. It's very common. Playing mind games, humiliating her, making her feel guilty, using isolation, controlling what she does, where she goes, who she sees, oftentimes spying on their victims, checking their phones, tracking them, etc. Minimizing, denying, and blaming. I find this in almost all the cases I work. They make light of the abuse. It didn't happen. They shift responsibly. It didn't happen. It wasn't that bad. It was your fault. So minimizing, denying, blaming. Using children, sometimes put their victim, the mom, in fear of what he'll do to the child or that he'll report her, etc., that she might lose the child. Male privilege. This has to do with the role that he makes the decisions in the family or in the relationship and gives her a specific role. Economic abuse. And this would maybe be preventing her from having a job or money, or she should have an allowance, etc. And then the last item is using coercion and threats, making, or I'm just having problems reading the fuzz here a little bit, making and carrying out threats against her, threatening her, using coercion and threats. So I'm going to sit here, that can stay up, and I'm going to make a few comments about it. So the main issue here that, as we understand the power control wheel, is these are techniques that the abuser uses to control their victim. And like we say, it's a pattern. So that means it's repetitive. And so what's the purpose of that? It's to get them to comply. And so the victim ends up trying to avoid the perceived danger that they'll experience if the abuser perceives that they're opposing them. That's particularly true for mothers that are, not only are they trying to protect themselves, but they're protecting their children. And I found that there's victims of domestic violence tend to get into what I call equilibrium sort of stasis experience. In other words, they avoid the perceived threat, so they the proverbial, the old phrase of walking on eggshells. So they end up being in this compliance, kind of like they don't want to poke the bear, so to speak. So they find this narrow way of coping by going along with the perpetrator and don't want to make them angry at them, because that's when the violence occurs, or the threats, or the emotional, the hardship. And that's exactly what the perpetrator, the abuser, wants to happen. He wants to keep her in line, so usually to manipulate, to get her to do what he wants to do, that they feel a sense of ownership. And they use these techniques to control. They also, the victim wants to appear to be going along. They don't want to anger him. They'll actively hide that abuse from family and society because if it gets out, he's going to be mad. And I could speak certainly a lot more about that.
Are there, Mr. Ferris, common characteristics that abusers share?
Yes, they could be anyone from any socioeconomic group. I've been involved as a therapist and as a detective enforcing the law with all types of society and sexual orientation, from wealthy, well-known NASA scientists, doctors, as a perpetrator to the homeless person and everyone in between. And in Gainesville, where I worked, we have a great population from all around the world there, and I didn't find a difference other than sometimes attitude, but every socioeconomic group, it's very, and also they tend to be males, but females also. Just yesterday, I took on a new client, spoke to him. His wife's in jail. He has 4 children with her, and he's a victim. So, he's a victim. So there's female abusers and male abusers. Males are predominant. I know when I was working, I ran some statistics on cases, and I found it was about over 2/3 of my cases were males, and less than 1/3 were females. And some of those, and that kind of reflected also when people would, kind of want to debate that issue about men or women. One thing that always struck me is when you look at fatalities, the statistics are about the same. There's usually the murderers are mostly men by about 2/3 over the women. So the actual victimization cases and then the actual fatality cases, kind of the statistics I found ran together.
And what do they have in common?
Usually that they want to control their partners. There's kind of an ownership attitude. They use the power and control techniques I described to do that. I also find that they're missing true empathy. I kind of nicknamed it to myself as they're missing an empathy gene. And empathy has to do with the ability to feel someone else's feelings. And I find many of the perpetrators that I've counseled and also worked with in the BIP class, and certainly in my police career, they tend to be very selfish, a lot of narcissistic sort of ideas. I kind of image it as many of them, not 100%, but a majority. It's kind of like their point of view is I'm here and everyone and everything around me relates to me. I'm the center of the universe, as opposed to a healthy relationship. There's an equality. I'm being thoughtful and considerate of my wife as she is for me, and there's some balance. They don't necessarily adhere to that. They disguise how they treat their victims. Usually they don't want to let other people know about that, much like the isolation element. They want to keep it. And there's reasons for that. And some of it has to do, they don't want to go to jail if it gets out. And then they don't want, I found this a lot, that perpetrators don't want their victims to get the idea that they're not a good deal, that there's something they're doing that's wrong, so they isolate them from society as such. And they'll put on a real front. I have numerous cases like this, how they disguise how they treat their victims. There can be, the perpetrators, can oftentimes be very appealing, and they're very good at convincing people of things. I found a certain finesse amongst those thousands of BIP clients I had, that there's some very good talkers. I'll just leave it like that. But emotional and physical abuse is certainly what we think of. I've certainly worked a lot of cases where there was, broken bones and bruises, et cetera, and emotional abuse and isolation and coercion, threats, et cetera. But many of the cases I see, there isn't acute violence. It's emotional abuse. It's these techniques. The question is, can the abuser convince the victim that and put them in fear so they adhere to what they say? If they can create the fear, like this one lady told me, she was in fear of him so much, they would be in a public place and they're separated and they're across the room. And if he saw her talking to a male, he looked at her and she knew right away, end the conversation, move on. There was a fear, and there was no violence in that relationship, but she was scared of him. Also, as we know, as Judge knows, and Mr. Teller, the ASA knows, battery, in the state of Florida, there's assault and there's battery. Battery is the unwanted touching, that's the hitting, the punching, etc. But assault is also a crime. That's being in proximity to someone, showing a threat, I'm bowing up, I have my fists up, and the victim has a perception that the violence is going to occur. That's a crime, though there's no marks, there's no scar, there's no hitting, but there's fear. And so sometimes there's assaults that are taking place that aren't reported. And if on top of that, if they can create that fear to go along, that's a common technique that I see happening. It's all about keeping control, their victim. And one real common thing that I've seen is obsessive jealousy. And when I worked with batterers, I was surprised, and I came to learn very quickly that they oftentimes equate jealousy with love. And we all know jealousy can be very detrimental to the object of the jealousy, and also to the person having the jealousy, being obsessed and worried, etc. Love, we all know, is something else, completely different. Very kind, considerate, and very empathetic, very different, but they didn't understand that dynamic.
Let me ask you, Mr. Ferris, do they exhibit with respect to these characteristics in common? What is their behavior relative to animals, pets in particular? Domestic pets.
Yeah, I understand.
Cats.
So cats, dogs, etc. So there's above average abuse of pets by domestic violence abusers. So I have two explanations for that. One is what I talked about, their missing empathy, that they don't feel for a dog or a cat like I might feel. I'm very empathetic. I am in love with Rosie, my poodle. So is my wife. So that means a lot to me. But to an abuser who doesn't have empathy, it's not a big deal for them. They see it as an object. That's one thing. The more important item, especially in terms of power and control, has to do with to get back to the controlling of their victim. If that victim is attached to that pet and I abuse that pet, now I'm putting you in fear for what I'm doing because I'm hurting your animal. So I'll attack that pet as a way to control you. You better not oppose me again, or you better not leave, or you better not go out with your girlfriends when I say you shouldn't, or I'm going to hurt your pet. I'm going to kill your pet even. So it becomes part of the continuum of power and control. And the sad part is I've also found that many perpetrators have that same mentality they use against the females, children, in the sense that the women are highly protective of the children. And so he's using the child as a way to gain control over the female.
And what about the abused, Mr. Ferris? Do they have common characteristics as well?
Yes, the majority are female, though, like I say, I treat male victims of domestic violence also. I'm still kind of surprised at times when I meet a new victim for the first time. And remember, for 13 years, I've been getting clients from our local DV shelter as a consultant and a therapist working. So I get kind of a constant feed of them. And then I also have my other sources and attorneys, and just my people know who I am. So they come to me if they're victims. But I'm always amazed at how many don't truly know what domestic violence is. And even I've had I've had clients who don't think they're a victim of domestic violence. They'll know there's a marriage problem, but they haven't been, I'm refraining from being too graphic because I've seen it all in terms of broken bones and types of violence in families. So they haven't been violently attacked and hit with the 2x4 or something. But I go over the power and control wheel, and they say, holy cow, this is my life. This is what's been going on with me. I remember one crime scene I was at, and the woman had been a victim of domestic violence, and she wouldn't talk to us. And I had a moment to speak to her, and I showed her the power control wheel and had a moment. There's a victim advocate there too, and we went over it, and all of a sudden it was like an aha moment. And she goes, darn. And I think it was a strangulation case, and she realized, and I've had some specialty training and some certification about being an expert in strangulation with the state, another subject, but she realized that she came within 4 minutes of dying for lack of oxygen to her brain. And once she realized the power control wheel and how dangerous it was, she opened up and shared information, and that suspect who had left was eventually found. Also, statistics show that domestic violence victims will leave, on the average, about 8 times they'll leave their perpetrator before they finally leave. It often happens. And there's also socioeconomic and ethnic groups that have unique attitudes to domestic violence. This idea of protecting a child for the mother as a characteristic is very, very significant. I guess I'll take a short moment. There was a particular case that comes to mind. This mother was very abused by her husband, and he made her stay.
I'm going to object. We just got into a narrative. I think he's established this match.
It's the same. To the narrative.
Okay.
Okay, so you want me to skip the story?
Yeah.
Sure.
All right. Describe what coercive control in a relationship means.
Coercive control are acts of assault, threats, humiliation, trying to create harm, punishment to frighten the victim, much in the manner that we're talking about a pattern of power and control. By creating fear, it's all working towards controlling the victim. Of course, like I say, the power and control wheel is the tactics, along with physical violence and sexual violence. And then we get into that appeasement or compliance that I've talked about. They want to avoid the pain of the conflict. And pain can be emotional pain. I've had women tell me, I'd rather get slapped upside the head, excuse me for the phrase, but then be told I'm ugly or fat, or my self-esteem totally crumbled. And so don't underestimate how important emotional control is in that sense.
Do these offenders always behave violently, or does abusive behavior happen in cycles?
No, as I've explained, it's not always violence. It's perceived violence in terms of the threats are enough to create fear in a victim that because of some assaults or, like in using intimidation, making her afraid by looks, actions, gestures, smashing things, destroying property, displaying weapons. These are all acts of intimidation that affects them and can create a great fear because of the narrative they project, the reality that they're living as the victim, and they get into this compliance mode, and it's can be very dangerous. There is, in terms of cycles in the industry, I'll call it, we recognize there can be kind of this rain, sunshine sort of a model, that there's acute abuse, and that's kind of symbolic of it raining. And then the sun comes out, and there's like a honeymoon phase with couples, and all the sun, everything's nice, there's no violence or no emotional abuse, and then all that rain with the hot sun, clouds form again, and then the clouds are too heavy to carry the rain, and then it rains again. So there's some relationships, not all, but there's this cycle of violence or emotional abuse, and then a honeymoon. There's also a generational cycle that I'm aware of, that you grow up in a family where roles are very defined. The male is the head of the household. The wife doesn't, oppose him. So sometimes that cycle goes, I see it in my clients, from generation to generation until it can get someone breaks free from that. And maybe that male realizes that's not the best role to have. And a female realizes, I don't deserve this, and they move on. So that's another cycle.
Does the victim, Mr. Ferris, always appear to be afraid or act like they are afraid of the offender?
Definitely not. This gets back to what I've already been talking about. They're hiding that fear from friends, families, and for good reason, in the sense of the consequences of laying it out. And they may not understand all what's going on with domestic violence, but sometimes I've had victims say that they deserved it, that they caused the violence, that they didn't keep the house clean enough. They've got almost a brainwashing going on about what's expected of them as a woman, and they found this, I'll call it a dissociation from the facts, mental health term, kind of an avoidance that allows them to comply because of their fear. And so it becomes, no, they don't always appear to be afraid.
So let me ask you this. How common is it for the victims to smile and act happy?
I think we've got far afield from what needs to be established in our dollar. As far as domestic violence, I'll stipulate he has this knowledge as to domestic violence at this point, but I think we've got far afield from what needs to be established.
Judge, I might recall for the court that they played the video of them all in the restaurant.
I'm not sustaining. This is your proffer, so
yeah.
You tell me what you want me to know about your expert, and I'll decide what he can say and not.
Thank you. Would you elaborate on how common it is for the victim to smile and act happy?
Very common. And it speaks to what I've already been discussing, that they try to hide abuse from others sometimes for personal reasons. They don't want him to get in trouble. I've had mothers that are financially dependent, and they don't want him to go to jail or prison, because how will they take care of their kids? So they sacrifice themselves. They are afraid of what society is going to say, or they're afraid of the abuser. So especially the afraid of the abuser is a really big part, and that they stay in line. And again, speaks to this idea of compliance, or equilibrium, as I call it, find the lowest resistance to survive. And so they get into survival mode, and that walking on eggshells. And as a therapist, when victims come to me, we've got to kind of untangle this stress and trauma and come to terms with that, because they've gotten kind of in this lifestyle of compliance and all the hurt that comes with that, and how their self-esteem's been damaged. I could go on and on with that subject.
All right, so tell us a bit, if you would, Mr. Ferris, the role that appeasement plays in domestic violence.
It plays a huge role. We could say appeasement, we could call it compliance, we could call it walking on eggshells, we could call it don't poke the bear.
Go along, get along.
Go along, get along. It's all about avoiding pain. And that's the very technique, the fear, I'll use fear as equivalent to pain, that is a way to control, hence why this is called the power and control wheel. These are techniques, along with physical violence, that are used to control their victim and get them. And there's an ownership, I've already mentioned, a certain ownership, the jealousy, etc. And also I found some of my abusers become obsessed with their partner, that ownership quality at all costs, and they're just highly obsessed, and it can get very dangerous, actually. I've worked cases where there's been suicide, homicide, that if I can't have you, nobody can have you. And if a victim realizes that their perpetrator is capable of hurting them, they're going to go along, or they're going to get on a jet and fly somewhere real far away.
All right, tell us, if you would, what the impact of a child has on these dynamics.
So the impact to the child, or having a child in the scenario?
Having a child in the mix.
A huge impact. I found women who, certainly want to protect themselves and do this compliance. But when there's a child involved, and if they have a strong maternal instinct, they're going to sacrifice themselves to stay in a relationship. I've worked many cases, to my surprise, where there was no reporting of the violence or domestic abuse occurring. And so the woman, the mother, wouldn't seek a divorce because they knew, typically in our state, if there's no extreme reason, criminal history, drug history, violence, etc., it's going to be a 50-50 custody. So I've had women who have stayed in the relationship, taking the abuse, because she's so concerned that she wouldn't want her child to be alone with that perpetrator. She sees him as a brute or a bad role model, etc.
And might that type of a scenario play out with the woman acting happy in an effort to go along and be in the company of the abuser to protect her child?
Without a doubt, that's the whole scenario, and and there are women that are better at it and more sophisticated at it than others. I'm just finished working a case where her family, as I interviewed, I won't make this long, but there was abuse. He's in prison. She was pregnant. She gave birth while he's in prison. She stayed with him. A couple years later, she was running his business while he's in prison. She finds out he's getting out early in 3 months. She commits suicide. She hangs herself because she was so afraid of him coming back. The grandparents, the maternal grandparents, had the child. I'm working on that custody issue and the criminal case. But the point I'm making is that when I interviewed the parents, the sister, the friends, all these people before the suicide occurred, they didn't know how bad the relationship was. She wouldn't show up at family gatherings, or she'd come and go, or they wouldn't see him. She was totally hiding all that extreme abuse that she was going through. The family didn't know about it till the end, before he was charged and went to jail. So she went to great lengths to hide because she was scared of him. And I believe her going along with him and running the business was all out of fear also. And then she couldn't face it and decided to leave us.
A few questions, if I can, as it relates to domestic violence abusers. What have you found in your experience and education as it relates to their ability to charm and deceive others?
Yes, I found this in a majority of the cases. They want to project an image, again, hide the abuse. Sometimes that's their strategy to deceive others because they don't want to be found out. Also, I might add that the recidivism rate, when I was running the BIP classes, I was always surprised. I'm getting the same guy back again, that there's a personality issue here that hasn't been solved per se with some men, and that there's a tendency to abuse over and over.
Is there a unique pattern of denying, rationalizing, minimizing, or blaming the victim that's typical?
It's not only typical, it's in a majority of the cases that I've ever worked. I see this almost in all the cases, I'll say. And if we look at the Duluth Power and Control wheel, there's actually at 5 o'clock, minimizing, denying, and blaming. It didn't happen. It wasn't that bad. It was her fault, which, as I've explained in the past. So that's very typical. It's also a form of gaslighting. That's been in, I think, the news the last 10 years or something. So it's a form of control and gaslighting a victim.
Does it include suggesting that the problem stems from the victim's mental health problems?
Definitely. That's a very common theme. It's also gaslighting, and also it's in the power and control wheel, using emotional abuse. About the third line down, making her think she's crazy. So it's a destabilizing technique. If you've got so much influence over me that you convince me that I'm crazy, then maybe it didn't happen. Maybe I'm wrong. So it's a self-esteem killer.
Give us an idea, if you would, of the barriers that exist to these women leaving the abusers.
Fear of being harmed, certainly, if they report to victims. Barriers to leaving can be, as I mentioned, cultural upbringings or norms, roles. A lot of victims are financially dependent upon their perpetrators and don't know what else to do, and they don't necessarily have any other resources. Sometimes when I do trainings, I confront my audience, especially when I've got law enforcement or victim advocates, about their expectations of victims leaving that, perpetrator. You expect her to walk out on the street with 4 kids and she doesn't have a credit card and no family. And, and I kind of go into this a little deeper. I'll avoid doing that now. The fear of losing her children. So sometimes victims have experience with DCF. They understand what can be consequences if it's reported to DCF. So they don't want to report because, and I've been party to this in a lot of cases and termination of parental rights cases I've been involved with, that if she's staying with the abuser and a child, and I like I mentioned, I taught a class for DCF to men and fathers and mothers, and also trained on this a lot, that exposure to a child to trauma is trauma to that children. Separate from the traditional child abuse that we think of hitting the child or not changing the child's diaper or not having food, but actually subjecting the child to the yelling, the screaming, the abuse is trauma to that child. So if a female doesn't report and she's found out, then that can be considered a failure to protect. Now all of a sudden, and she's still a bona fide victim. So now she's being held accountable. Her children might be removed. She's got to go see people like Bruce Ferris for counseling. She's got to do all these classes. So there's and many know this, so they don't want that to be out and about. Also, sometimes I've had women, they still love him. They see the good in him. They feel he didn't have a good childhood, or it doesn't happen often, or maybe I created the problem.
So you mean these aren't split-second decisions?
What specifically?
Do they vacillate sometimes when children are involved?
No.
Should I leave? Should I stay?
I like to think it was an evolution to leaving. But what's the motivation? If you're in that isolated situation of just he's the one, he's your world. Where's the education? Where's the involvement? That's what the role of a lot of our domestic violence shelters are in outreach, and is to involve and educate. And yes, here's services you can have. Here's someplace you can safely go. But that denial that violence will happen again is not uncommon. That feeling that it was her fault. Religious reasons. I'm always kind of surprised that, and I mean no ill towards any religious group. I don't mean to say that, but I found sometimes ministers or churches, very concerned about marriages or not getting divorced, and they actually recommend or counsel people to stay together that are hurting each other. And so that's an issue. This idea that he will hurt her if she leaves. In this quote, "I'd rather see you dead than with someone else," is not uncommon. And also the total power and control continuum and the use of that to control their partners.
Is there a particular time in these kinds of abusive relationships when violence is most likely?
Definitely. The most violent time is when she goes to leave and he knows about it, or he's there.
In other words, when he forms the perception that the realization sets in that this is the end?
When she eventually puts her foot down and makes that clear, and I know from my certification is doing fatality reviews with Johns Hopkins University, that's in the danger assessments, there's a high probability of fatalities or extreme bodily harm at that time. It's very dangerous. When we do many shelters and victim advocates that might be affiliated with the state attorney's office or wherever, they try to establish a safety plan with victims, and that plan will include, when you leave, it's when he's not home. Don't do it when he's home. And also have a safe, unknown location to go to. I have many stories I could tell of women being hunted down and actually killed because of he knew where they were. And that just the trauma of that. I don't, even though I work in this field and I've been doing it for 20 years, it's hard for me to conceive that cloud over me of being subjected to being violently hurt. And if I am, who's going to raise my child? And will he hurt my child also? It's overwhelming for those victims. And I certainly see that in my practice, my counseling practice.
So let me ask you this as we close. Given your education and experience as a law enforcement officer, tell me, is there a general bias against females by males?
I think there is. Some of it's different social ethnic groups, different cultures. Like I think I mentioned earlier, ownership of women. I've had, without mentioning the countries, I've been in, like I say, Gainesville is a little stewing pot of people from all over the world. I run into men who actually thought it was okay to abuse their wife because they thought she belonged to him. And I said, sir, this is America. That's not how it works. So this ownership can be cultural. It can be dictated by social norms, what their parents did. Certainly the media and entertainment plays a big part towards women and male roles in our society.
And where can this bias be found?
Everywhere.
Everywhere?
In society.
Including our institutions?
Including institutions.
And would those institutions include law enforcement?
Law enforcement, and of course I worked in law enforcement, and I was always surprised at how I constantly had to, I actually became a little internal affairs detective for my officers who didn't understand domestic violence and had biases. And I was always surprised of the biases and found sometimes they were personal. An officer's going through a divorce, so all of a sudden he's at a crime scene and he treats the female badly because of his own world, not enforcing the law appropriately. But yes, it could be, not, and also not everyone reacts the same way as a victim to domestic violence, and especially with other people. Some people have developed a very fat affect. In other words, they don't show emotion. And that's their coping skill. They actually shut down. They do this dissociative sort of thing. Other people become hysterical and exaggerated in describing. So every person is different. Just because you...
Not responding to the question.
All right. Lastly, do uninformed professionals, in your experience, cops, judges, lawyers, counselors, often fail to recognize the signs of domestic violence?
They do. And sometimes it's because they're not obvious and they're hidden, or they don't understand the dynamic of domestic violence, and they don't necessarily understand that that victim was in fear. And though it may not show, they may be smiling in a photo, or their family or someone doesn't know about it. That doesn't necessarily speak to what was going on.
All right. Now, would you be able to relate these principles to the facts of a domestic violence case with any kind of reliability?
100%.
Have you done that before?
Routinely.
Is that what you in fact do as a professional?
It's one of the major things I do. I might put as a footnote, I'm a therapist. So sometimes clients come to me and I'm helping them with their anxiety and their depression and generalized mental health issues. But many of my clients, because I focus on domestic violence, I'm helping them understand, or the perpetrators, I'm helping them change their attitudes, usually through what I call cognitive behavioral therapy. And I could go on and on.
All right. Could you make that application and its reliability by studying the facts and documents relative to a particular case?
Actually, this is one of my professions. I'm hired by the state for cases doing domestic violence assessments, and sometimes I never get to interview some of the parties. Maybe they're not available, they're in prison, et cetera, in private practice, and also, like I say, through DCF, I've been hired. So I look at the characteristics, what fits, what was there a display of a weapon, was there all these different things. And
would you be able to do the same application with the same reliability through a series of hypothetical questions?
Certainly.
All right.
And if I can, I would admit that I can't.
Yeah. Finally, let's talk about battered spouse syndrome for a moment. Are there any characteristics in traditional battered spouse syndrome that might distinguish it from an otherwise domestic violence abusive situation?
Good question. So basically, the abuse is the same. I think what makes battered spouse syndrome or battered wife syndrome, different terms through the years, different is oftentimes the victim still lives with the abuser, and there can be a history of extreme violence or violence occurring and traumatizing the victim. But the techniques of power and control and compliance and fear and how they hide it and all those things are completely the same.
Thank you very much. I have no further questions.
Cross.
Good afternoon, sir.
Good afternoon.
Have you ever testified as an expert on battered spouse syndrome?
No, I have not.
Do you consider yourself an expert on battered spouse syndrome?
I consider myself an expert on domestic violence, not necessarily the BSS uniquely. I haven't been recognized by a judge in that doing that. So I think that for me, there's really no difference other than that distinguishing fact, whether they live there or not, or whether there's been physical violence or not. It's still the same dynamic. The victims are the same.
But you could recognize the law might make a distinction between those two things, an expertise in those two things.
Well, I think I'm expert enough to understand that. I just haven't testified uniquely in BSS.
And how did you did you speak to Ms. Benefield?
I did speak to her.
And for how long?
I spoke to her multiple times with a Zoom call.
Okay, my question was how long? How much time did you spend speaking to her?
It varied a little bit per hour. Most of the times it was 2 hours.
I need you to add it up. Did you speak to her 1 hour total, 3 hours total?
Oh, total time?
Yes, sir. I'm sorry if my question wasn't clear.
I'm going just by memory. I'd be guessing a little bit here, so I apologize. Could have been. I'm just trying to. Could have been 15 to 20 hours easily.
So you spent 15 to 20 hours speaking to Ms. Benefield?
I did.
Okay. And did you review paperwork in this case?
A lot. That's how I came to my conclusions, uniquely from the paperwork.
When you say uniquely from the paperwork, are you telling this court that you spent 15 to 20 hours with Ms. Benefield, but you didn't base the opinions that you gave previously in a depot on that time?
That's true. I did not get to do an assessment of her. I was not hired to do an assessment. I did not produce an assessment.
Well, what were you doing for 15 to 20 hours?
Some of it was being a counselor, and some of it was I have a reputation to keep, and I wanted to understand was this really a victim? So kind of got into a routine of understanding some timeline with her about what occurred and how did it fit the facts that I was reading about.
Well, wouldn't that say, if what you just said is you needed to determine if she was a real victim, then it must have come into your decision making about this case, with that assessment you made. Is that correct?
Could you restate the question?
Well, you just testified that you spent 15 to 20 hours with Ms. Benefield, and part of that was to make an assessment on whether or not she was a real victim. And
no, not to make an assessment, as I compared the facts that I knew from what I was reading. I wanted some validity, and then some of my time was being empathetic and listening to her. But my conclusions I've come to that I talk about in the deposition were 100% from the discovery. Those are the items, and I could list them for you if you'd like.
Did they include the stand your ground motion filed by Mr. Taylor and the defendant?
At the time, that was one of the items. Certainly, if I subtract that from what the things he quotes in the stand your ground were other discovery items. Doug admitting to shooting the gun into the ceiling, him telling that to his priest, and phone calls and texts. So I didn't need the stand your ground paperwork document to find all those bits of information that I found through looking at discovery.
Well, so the portions of the stand your ground about what happened that night were not in discovery. That Mr. Benefield took a bladed stance and did this.
No, I didn't. Those items were not part of my conclusion. I could tell you I have 13 items I use uniquely in discovery that came to my conclusion on, and it didn't include. And I never spoke to Ms. Benefield about what you just said about bladed stance. I never talked to her about that.
Well, you said you spoke to her to determine if she was a real I guess to determine her veracity. Is that what you're trying to say?
That's one word, but I never spoke to her about the event of the shooting. Never.
Okay. Did you speak to her about the other things that were in the stand your ground hearing and the discovery from things that had occurred in the past?
I think some of the things did. Yes. As I think about as she's going, basically she did I did some timeline understanding, when they met up until before the event, and some of those items were in there.
And did you develop an opinion as to whether or not Ms. Benefield was a battered spouse? Like as far as battered spouse syndrome? If you would say that she suffered from battered spouse syndrome.
Yeah, I did not determine that. I determined that she was a victim of domestic violence, and that Doug was the perpetrator of that.
Based on
all the discovery and how it fits in with the continuum of power and control, and her compliance, her fear, etc.
I don't have anything else, Judge. Thanks. Thank you, sir.
Tell us what you reviewed.
I reviewed a deposition that Doug gave, and I had a written version. He makes admissions. He talks about the gunshot. He talks about punching the dog, throwing the gun, punching holes in the wall. There was a letter to his pastor where Doug admits punching a hole in the wall and shooting the gun in the ceiling. There was a domestic violence injunction in South Carolina prohibiting mutual contact, and the text of that. A really important piece of evidence for me was Ashley wrote a letter on September 18th, 2017, when she separated outlining domestic violence that Doug did to her. I have a copy of that if you want me to go through the items, but she outlines, without necessarily being a domestic violence counselor at all, it all fits very discreetly into what power and control and what abused women experience at the hands of their abusers. And also for me, if I might say, that was a frozen moment in time. That wasn't something that she said after I met her or something like that. This was from 2017.
And were you struck by the terms of basically art that she unwittingly included in that letter as it relates to domestic violence and the power and control continuum?
It was it's a letter that I can use in training other people to counsel domestic violence victims, or if I was to work with a group of batterers, et cetera. It's classic.
Okay, what else did you review?
Deposition of a neighbor who caught Doug at night in the yard. The text of Doug admitting to putting a tracker on Ashley's car. I mean, these are all items that show ownership, that, stalking sort of items. A text from his ex-wife documenting him physically abusing her on her honeymoon. So this gets into his character. And
Jeff is not responsive. The question was, what did you review, not his opinion about them.
That's fine. Go ahead. Overruled.
Thank you, Judge. Go ahead.
So here I have all this experience dealing with perpetrators, being a perpetrator to multiple victims. Sometimes when I was a detective, I would, besides my therapy work, and I see that as I interview victims, but quite often my routine, I work day shift. So I come into the department, I go to a detective briefing, I look at cases where the suspect got away. My job was to review probable cause, go make the arrest, or get the warrant. That's what I did. So the first thing I do is I run that perpetrator's name, and I find out there's an injunction, and I'm looking at the charging document that an officer left, and there's no violation of injunction in there. But then I open it up in the court system, and I found it's a different victim. So I found there's multiple victims. And also, to be fair, I'd open up her, the victim's information, and I would find that there's an injunction, but it was with a different guy. So there's some serial victims, some serial offenders. So basically, the fact that he is very strong, and I know we talked about it in my deposition with the assistant state attorney, this text message from his ex-wife documenting how he abused her on a honeymoon was appalling to me, but it was not an unknown probability. And also it spoke to who am I looking at here? So that was one item. If I could continue. Of course, there was an injunction in Manatee County and some narrative. Dr. Russell, a forensic psychosocial mental health evaluation, I read, I think it was April 30th, 2020. She describes the abuse and domestic violence that Doug did against Ashley quite eloquently. It's quite clear the things she discovered in her she did interview and come to that conclusion. So I found that kind of enlightening. There were telephone calls and documentation between Doug and Ashley. I've got a date of August 16th, 2019, where he was, controlling, intimidating, amidst of being outside her house, following her. He was gaslighting her. He pulled a gun on his ex. There was a threat that he was going to kill himself with a gun, and there was more. There's more in that without pulling out the document. There was a very significant WhatsApp phone messages between Ashley and Doug, and in that, there are statements about being armed. He talks about warfare, rage, exterminating them, murderous mood, anger to take them out. A warrior side would be, the testosterone rage. He talks about killing bad people. So let's say we could say, was this all true? Or was this techniques that to put her in fear of him? Both could be true, actually. I found that very, Dr. Broder, I read his testimony and that he gave, and it was clearly domestic violence was present. There was definitely power and control tactics reviewed by him. The mic blow up, the gun incident was, and I have a quote here, was certainly a frightening experience for Ashley. Doug's temper, yelling, screaming, punching holes in walls, and Mr. Taylor's cross was in that transcript I read. And as you spoke to Dr. Broder, angry temper, very controlling, highly manipulative, very intense. The holes punched in the wall, fired a gun in the ceiling, that, there was an appeasement. That word was even used by Ashley, apparently by Dr. Broder, as a strategy with Doug to protect her child, keep him at bay. This is the very issues I've been talking about. And there was text about him kicking the dog and throwing the cat between Ashley and Doug. So all these elements right here, I got my conclusion from. I didn't need anything else. And this is clearly what I base my determination on.
And would you conclude, based on what you know, that Ashley was an abused woman?
Definitely.
Would you?
And I'm going to interrupt you, Mr. Taylor. Abused woman is to say one thing, but abused woman who was in compliance mode, that didn't want to poke the bear, that was afraid of what might happen if she opposed him. That's what I get here.
And how, if at all, would that explain, for example, Ashley agreeing to go on a parental exchange between Doug Benefield and her daughter Emerson? Ashley, in the week leading up to the shooting, exchanging friendly, lovey-dovey text messages with emojis and things like that. And Ashley at a restaurant with her mother and her child Emerson in the company of Doug, acting happy.
Totally. It's not, doesn't oppose my theory at all, or what I believe was going on. It may be that there's one thing I can say, Ashley did show, from what I've read here and what you're presenting to me, a sophistication to, and maybe that's her performance side for being a ballerina or whatever, I don't know, but she could put up a good front. And this was to keep that warrior side of Doug at bay. She was concerned and afraid, and she was very afraid for her daughter. This is the mother factor. Her getting in that, I guess you referred to the first visitation.
Yes, at the sheriff's office.
Her going along. That's much like I talked about that wife that stays with the abuser to protect the child. The idea of letting him, have custody at that time without, and I don't think, if I remember from documents I read, they didn't have that. He didn't have a lot of exposure to Emerson, and so that was definitely the mother, the maternal instinct, wanting to protect her daughter. And at her own expense, but that's nothing. I'm a parent. I take a bullet for my kid. It's not about me. It's about protecting them. I think that mothers do that. That's what mothers do.
All right. Thank you, Mr. Ferris.
Mr. Ferris, it's always a little bit dangerous when the court has questions, because certainly I'm the neutral party here. But in this kind of situation at Daubert hearing, I'm both the finder of fact and the decider of the law. So there are a couple of questions I have. I have said this multiple times. Mr. Taylor, I probably said it in hearings with you. I know you two have heard it. If you object to one of my questions, object. Please put your objection on the record. I have actually sustained objections against my own questions before. So I try to be intellectually honest, and if it's in retrospect, I realize that's not a good question.
You have been good about that, Joe.
First, I did not receive a copy of your CV in evidence. It may be in the file somewhere. Is it attached to something so I can find it?
I can give you a copy.
Any objection to me receiving a copy? I assume it's filed somewhere, but I don't know where.
Judge, may I make a statement briefly? In my past experience, when my CV is presented to the judge, oftentimes I'm shown a copy of it to verify that that's the complete version.
Sure,
yes.
Absolutely. I'll say, Mr. Taylor, there's markings on it.
Yes, sir.
You don't need it back? Is it in the court file?
I don't know if it's attached to the deposition. Let me take a look.
So here it is.
No, I'm informed we don't believe it's in the court file.
All right. And so, sir, this appears correct?
Yes, it does. Thank you for letting me look at it.
State, the copy that I've been given looks like there's highlighting where someone was making notes to highlight certain things to talk about. There's a couple of pages where there's some red pen markings where something has been circled or underlined. Any objection to me taking this and reviewing it?
If I may. It's a defense's burden. My only concern about your asking questions is that they have rested their witness. And I understand what I have a guess as to what your questions will likely be, but that is my only concern. I don't know what objection that would be, but.
Don't forget there's also the general and proper. So you object away.
Yeah,
You know me, I don't mind.
Yes, sir. Yes, sir.
Oops.
All right, and then you had gone through a list of 13 things that you had reviewed.
Yes, sir.
And I was writing them down as we went, and I'm taking notes. I only got 12.
Okay. So do you want me to briefly?
I don't want the narrative portion. I just want you to tell me.
Or you tell me. Okay, I'll tell you.
It's got to be the other one. You have to say to me.
I'll give you the first 3 or 4 words of each. Number 1, deposition of Doug. Number 2, letter to pasture. Number 3.
A little slower.
Okay, sorry. Number 3, DV injunction from South Carolina. Number 4, 9/18/17 letter from Ashley. Number 5, deposition of neighbor. Number 6, text of Doug admitting. 7, text from ex-wife. 8, the DV injunction. That's Manatee County. Number 9 was Dr. Russell. 10 was the telephone calls between Doug and Ashley. Number 11 was the WhatsApp phone messages between Ashley and Doug. Number 12 was the Broder testimony. And number 13 was the text, kick dog through cat and between Ashley and Doug.
Can I just ask to clarify, you said phone calls between Ashley and Doug, is that what you said?
Yes, from 8/16/2019, I have a transcript of phone calls between them.
Transcript of phone calls?
I believe so.
No. All right, that's all the questions I had, surprisingly. State, do you have any questions based on my questions?
No, sir.
Mr. Taylor, do you have any questions based on my questions?
No, Your Honor.
Right, and is he free to head on back to Gainesville?
Yes, sir.
Okay.
Am I released from my subpoena?
No, this is just a proffer.
Okay.
We're doing a Daubert hearing, so I imagine Mr. Taylor still has you under subpoena.
We have high hopes you will be returning early next week.
Okay.
So stay in touch.
Okay. And so I'm still under my subpoena.
Okay.
Thank you. That's theirs. Yeah.
Yes, sir. Do you have any, State? Do you have any evidence testimony you want to put on? All right, I'm ready for argument.
All right, I think this is the final thing of the day. Which is good, because I have to leave in an hour. Oh no, oh no.
So 702 of the Florida Evidence Code, Your Honor, incorporates the new Daubert standard, as the court knows.
I tried to unpin that and I went to
provides
Dinah's
that
channel.
Scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or in
Trying to
determining
unpin
the
this.
fact and issue. A witness qualified as an expert by knowledge, skill, experience, training, or education may testify about it in the form of an opinion or otherwise if, and the court knows the 3 requirements, sufficient, if the testimony is based upon sufficient facts or data, testimony is a product of reliable principles and methods, and 3, the witness has applied the principles and methods reliably under the facts of the case. The state's theory of prosecution, although it was changed this afternoon from the release of the Broder report to the injunction that was set for the 30th, has as its predicate the specific behavior of Ashley Benefield in the week leading up to the shooting. And included in those text messages, as was the video at the restaurant, as well as the state's focus on how Ashley Benefield behaved in the presence of Douglas Benefield, but behaved differently when she was by herself, and how she led Douglas Benefield to believe that she wanted to reconcile, but in private, she clearly disclosed that she did not want to do that and wanted the relationship over. And finally, the instances where Ashley Benefield, as a result of the parental time sharing, accompanied her daughter, Emerson, and went with Doug, that Stephanie Murphy testified to. They were the picture of tranquility, that Ashley was very pleasant, happy to be in Douglas's presence. So what we know, and what the record reflects based upon Mr. Ferris's testimony and the Duluth Power Wheel, and its model for the evaluation of domestic abuse is that this is a classic sign of an abused woman who is in compliance, who indulges in, as Dr. Broder used the term, appeasement. Go along, get along. It keeps the beast at bay. And now, that element having been injected by the state in their case in chief, we, on behalf of Ms. Benefield, are prepared to meet with expert testimony explaining to the trier of fact, the jury in this case, exactly why the state's evidence of Ms. Benefield's compliance can be dismissed, can be explained, because this is the MO of abused women, women suffering from domestic violence, especially when a child is involved. So here's what, as the court knows, the Oquendo decision said, and it's the second DCA decision, referring to battered woman syndrome. Again, the notice we filed was notice of battered woman syndrome, but I footnoted it because two elements are not present. Those two elements are that Ms. Benefield had left the home and that she had not been physically battered by Mr. Benefield until the day of the homicide. But, as the court heard from Mr. Ferris, it's inconsequential. It is the same syndrome. It is the same abuse. It carries over, and it explains under Duluth power and control wheel why Ms. Benefield would engage in those kind of text messages 1 week before the shooting, why she would appear happy at the restaurant, why she would accompany her child at the parental time sharing with Doug, why she would try
I'm sorry.
why she would try to get along, go along. So here's what the Oquendo court said. Well, actually, before we go there, we should go first to the Supreme Court case of Kathleen Wyand versus the state of Florida. This is the case I cited to the court earlier in a memoranda, 732 Southern 2nd, 1044. It was an appeal from the second DCA.
Oquendo.
Yes. No, this is Wyand.
Wyand.
Kathleen Wyand, the Supreme Court of Florida. I'll get to Oquendo next. And the Wyand decision, Your Honor, was March of 1999. The Supreme Court rejected the second DCA's position in the Wyand case and instead embraced another circuit's decision, and it turned on the following question: whether or not there should be a duty to retreat as it applies to a spouse in the marital home. The Second Circuit had insisted on giving the instruction in a homicide case. The Supreme Court said, hey, look, we've learned quite a lot about domestic violence, and we're uncomfortable having a duty to retreat imposed upon a wife because of domestic violence. And it would render the wife's ability to defend herself in the face of battering and domestic violence ineffective. So we're going to reject that. We're going to retreat from our earlier decision that held there was a duty to retreat. And this is what they said about why. It starts on page 1052. And the topic is Section B, Implications for Victims of Domestic Violence. And they talk about how much of the public policy in this state has changed based upon increased knowledge about the plight of domestic violence victims. It is now widely recognized that domestic violence attacks are often repeated over time, and escape from the home is rarely possible without the threat of great personal violence or death. During repeated instances of past abuse, she has retreated only to be caught, dragged back inside, severely beaten again. If she managed to escape, other hurdles confront her.
While you're taking a breath, how is Wyand help me decide the Daubert question?
The issue is whether or not he has the credentials. I think we're past that. Unless I'm missing it, I think he's eminently qualified. I think the testimony is such that he's identified the syndrome of domestic violence, and he's explained that it is identical to battered spouse, the only difference being that the wife is not in the house and she has not sustained physical beatings. So this case in Wyan goes on for several pages talking about how domestic violence, the evolution of public policy, and the recognition of the plight of victims of domestic violence needs to be addressed and should be addressed by virtue of expert testimony. When you take that into account and you recognize what the Supreme Court is acknowledging, Judge White, about the timeliness of domestic violence, which is the overarching umbrella, battered spouse and those two components coming underneath it, you then go to Oquendo. And in Oquendo, they serve it up perfectly. Under Florida law, battered woman syndrome is not a legal defense, but rather is used to explain the woman's experiences and state of mind to the jury. In the context of self-defense, it is used to show that because of the prior conduct of the batterer, the woman reasonably believed that taking the batterer's life was a real necessity. And then they distinguish post-traumatic stress disorder. And they hold, as such, unlike PTSD, it is possible for battered spouse syndrome to be relevant in a way that is consistent with the objective, reasonable person standard for the justification of self-defense. So we know in a homicide case, based on the law and the jury instructions, Ms. Benefield is entitled to introduce specific instances of conduct of Douglas Benefield that are consistent with violence. We have endeavored to do just that throughout this trial thus far, with considerable resistance, but I think we finally started making some progress once the court felt the predicate had been laid. We cannot, this jury must understand, and both the case law that I cited to Your Honor clearly says that it is a proper subject for expert testimony, domestic violence. These jurors must understand why a woman would do what the state has alleged she did, and as a result, they should find her guilty. That is to say, getting along with Douglas Benefield and the text messages that they put into evidence. So, given the credentials that he's established, given its reliability, given the tests that it's been vindicated with and that DCF employs, the Duluth Power Control Wheel throughout the state of Florida, given the fact that this is a domestic violence matter involving self-defense with specific instances of domestic violence, how can I successfully defend if I cannot explain to the jurors the essence of the state's case as to why Ms. Benefield is a malingerer in effect? That is to say, if she acted happy 1 week before the shooting, if she went ahead and got in a car with Doug when they were exchanging temporary time sharing, if she acts happy at the restaurant, then she obviously wasn't scared of Doug. And that's the whole issue. That's exactly what was at play on September 27, 2020, and why Ms. Benefield's perception of Douglas Benefield was so fraught with fear. Otherwise, I'm left with a case that there is, in fact, a substantial explanation to explain that conduct that the jury doesn't understand, as indicated by the case law in the Florida Supreme Court, and will have no idea why Ms. Benefield would have acted that way. And it's an element that the state introduced. We are trying to meet it. That's our position.
All right, thank you. State?
Thank you, Mayor. Judge, I'm going to try to bring it back to Daubert, but I do want to address Oquendo because it frames my arguments. Sorry. Under the Oquendo case, or Oquendo, however you say it, the court carves out, as we've discussed at length, and I know Your Honor knows, carves out an exception for battered spouse syndrome, where it's talking about that that it's an objective standard. Self-defense is an objective standard, not a subjective standard, and that the one exception for that, and under Oquendo thus far, is battered spouse syndrome. They discuss the definition of battered spouse syndrome, and part of it says, the main part, mental state so that she could not be responsible for her actions. Rather, the testimony would be offered to show that because she suffered from the syndrome, battered spouse syndrome, it was reasonable for her to have remained in the home and at the pertinent time to have believed that her life and the lives of her children were in imminent danger. The Wheeling case also defines battered spouse syndrome. It says,
No, spell it.
sorry, it's the case Mr.
Oh, Wyand?
Well, I'm sorry, Wyand.
However you want to say it. I see
I
another
don't,
one.
W-E-I-A-N-D, 732 Southern 2nd, 1044. It says, I was looking for the page, Your Honor, I'm sorry. I think it's on 1054. It says, as the expert evidence demonstrates, there are many reasons battered women do not feel free to leave the battering relationship. This woman might have been isolated from her family by the abuser. She may not be able to afford to go, and she may realize that leaving is more dangerous than staying. And the reason I cite that is because the state's argument is that despite Mr. Taylor's efforts to make this about battered spouse syndrome, despite his footnote, that is not what this is about. This is them trying to get an expert on domestic violence. This expert, Mr. Ferris, while very educated in domestic violence, is not a battered spouse syndrome expert. He does not say that this defendant, although I find it incredulous that he spent 15 to 20 hours with her and reviewed things that the state doesn't even know what they are, that he only based his opinions on those documents not meeting with her. But nonetheless, if he were evaluating, the reason that's important in the state asked is because if he's evaluating her for battered spouse syndrome, which he clearly wasn't because he admits he does, that's not what he was doing. There's only two options for that, and Your Honor's aware of that. That one, if she's evaluated, then they have filed notice and we're allowed to evaluate her. That's not what we're operating under here. So the other one is that their expert must not have evaluated her. And the state would argue that no matter what Mr. Ferris claims, that's an evaluation. The things he did were an evaluation. I believe the case actually, I think it's Hickson, but I could be misspeaking, even says that they're not supposed to be familiar with the facts of the case. He's clearly familiar and has formed opinions, personal opinions, and professional apparently, about the facts of this case. And the reason that's important is because the state would argue that this defendant has failed to meet her burden under Daubert, that this expert is an expert in battered spouse syndrome, that the testimony is based on sufficient facts or data, and that it's a I don't think he met any of the prongs as to battered spouse. As to domestic violence, I would admit he certainly has the skill and knowledge. But even then, I don't think that the methods were reliably, it says the witness has applied the principles and methods reliably to the facts of this case. The facts he got were incomplete and evidently biased, because some of them include items that were never provided to the state, including transcripts of phone calls that the defense felt were appropriate. So the state's argument is that, one, the only option for them is battered spouse syndrome. They have certainly not met the burden for that. Under Okendo, the domestic violence should not be admitted. And two, that they did not meet their burden under Daubert because they did not satisfy the prongs of Daubert for domestic violence if it were admissible. And I don't know what they expect Mr. Ferris to actually testify to. I think 75 to 90% of what he said today is inadmissible. Stories about other people, those kind of things. The state is of the opinion that his opinions that this defendant is a victim of domestic violence are inadmissible. That's an inappropriate opinion for him to be making. And finally, the main prong that they have not met in the state's opinion is that it says, if the scientific, and I'm citing Booker, but it's from Daubert, the scientific, technical, or other specialized knowledge will assist the trier of fact in understanding the evidence or determining a fact at issue. The state has put forth motive evidence and evidence of how she was acting in the weeks before this murder. And it certainly goes to her depraved mind. But the concept of domestic violence and even the concept of the Duluth power and control wheel are not foreign to the average citizen. That an average juror, and this expert, scientific, technical, or other specialized knowledge would not be necessary to assist the trier of fact in understanding the evidence. The evidence is clear, and the jurors are people who are of normal knowledge, and it's a common domestic violence situations, and the idea of power and control, honeymoon phases, those kind of things are common knowledge. So I know I said a lot of ways in which we object, but I don't think they met their burden under Daubert for battered spouse syndrome, certainly. I don't think they've met it for domestic. But even if Your Honor finds that they have, the state would argue that Okendo would keep that testimony out of this trial, as it's an objective standard, not a subjective standard. Thank you.
Rebuttal?
Yeah. Mr. Ferris was asked directly if he evaluated Ashley Benefield, and his testimony, which is the only testimony that's been brought forth in this hearing, was that at no time did he conduct an evaluation. He was not hired to do an evaluation. With respect to the state's statement about motive evidence, motive is not an element of the offense. However, self-defense is certainly a material element to be considered, and there is, according to the information that is discussed in the Supreme Court opinion, Your Honor, it is not, and decidedly not, a subject for lay testimony. They could not make it more clear that there are many aspects about domestic violence. In fact, the words that they use in the Supreme Court opinion is that judges and juries do not understand and would benefit from expert testimony. I would suggest to the court, drawing a distinction between Daubert and the case law on battered spouse syndrome, I would suggest that given the facts of this case, an expert such as Bruce Ferris, who could educate the jurors on the impact of an abused relationship, domestic violence, in and of itself would be enough to provide expert testimony to counter the state's position and the issue that they raised about the go along, get along. I think it's clearly beyond the scope of lay people to understand that. And I think that expert testimony would help explain it. So Daubert, of course, doesn't apply any less under those circumstances. However, it would not be restricted to the extent the court wanted to draw such a narrow line and say, for example, okay, well, this is not battered spouse syndrome because for it to be battered spouse, you absolutely must have the abused party living with the abuser, having had physical beatings. If the court wanted to draw a line that narrow, rather than include it under the umbrella of domestic violence, I would still submit to Your Honor that the testimony from Bruce Ferris clearly met the Daubert standard for admissibility, and I would call him as an expert witness on domestic violence. And if the court really wanted to narrow it even further, as it relates to a woman who would choose appeasement and go along, get along, coincidentally, like I think we had 4 psychologists testify in this case so far, and every one of them have used the same terms to describe this phenomenon. I think I need and I should be entitled to be able to explain that to the jurors, and I'm not going to be able to do that without expert testimony. So I think the state combines Daubert with the case law, and Daubert is the procedural vehicle for allowing expert testimony.
All right, I do have some questions.
Yes.
I end the week, kind of as I mentioned at the hearing we had regarding Mr. Ferris before the trial started, whether it was last week or the week before. On July 11th, at a hearing, you said this was not a battered spouse case. On July 12th, you filed the notice of intent to rely on battered spouse syndrome. What is this? Are you arguing battered spouse syndrome or not?
Okay, Judge, once again, I filed that notice with a footnote in the title, Notice of Intent to Rely Upon Battered Spouse Syndrome, footnote. And the reason why I told the court this is not a battered spouse case is because technically, Your Honor, battered spouse requires those 2 elements. I shouldn't even say it requires those 2 elements. Those 2 elements are generally present in the battered spouse cases that we've seen. So in my footnote, I said, as it relates to domestic violence. So I wanted to cover both scenarios. I wanted to cover expert testimony to explain this phenomena under battered spouse as it relates to domestic violence, because it's the same syndrome as you've heard. It's the same mentality. Everything about it's identical. But I also felt at the same time entitled, upon meeting the Daubert standard, to just call an expert on that particular issue. And this expert's eminently qualified to explain that kind of behavior. So Daubert is, again, the procedural vehicle that qualifies whether or not the expert is capable of meeting the standard. And that would apply whether it was the battered spouse or just as domestic violence.
All right. So we've got the case law that we've all been discussing for the last couple of weeks regarding battered spouse syndrome, the notice that's required, why it's a carve out, why it's allowed when Okendo doesn't allow PTSD, other cases don't allow significantly impaired intelligence, mental health issues. When I say mental health issues, I'm not talking insanity and so forth. I'm talking about diminished capacity, right? Essentially diminished capacity, because we're looking at a reasonable person. Do you have cases that do not use the word battered spouse syndrome? They use domestic violence victim of domestic violence, and that is allowed in self-defense cases.
Would it be any different, Your Honor, than a criminal case of culpable negligent homicide, the issue being the trigger pull and the weight that it would take in order for the weapon to fire. And you call an expert to testify that the trigger in that particular gun was set to a particular level to try to explain to the jurors why that gun might discharge, and you're not necessarily negligent because of the discharge. Other weapons, if you banged against the wall, might not discharge. This one has a hair trigger. The defendant turned, hit the banister, the weapon discharged, shot and killed somebody else. If that expert met the Daubert standard, why wouldn't that expert's testimony be admissible to explain that? To try and explain to the fact finder who would not have that knowledge that indeed this could be nothing more than an accident that does not rise to culpable negligence, and therefore the charged individual is not guilty. And what I'm saying to the court is that evidence of domestic violence, if it meets the Daubert level, I should be entitled to defend and explain to them why she would engage in this type of go along, get along.
So the answer is no, you don't have a case?
I do not have a specific case on that point, no.
I know, baby. We're almost done. We're almost done.
And so the court knows I instructed Mr. Ferris not to evaluate Ashley Benefield. I had planned, if it came in under battered spouse, to follow the Heenum option, whereby he would be given a series of hypotheticals based upon facts and evidence.
Excellent segue. That was my next question. I didn't keep track on the clock how long Mr. Ferris testified about the general properties of domestic violence, the Duluth wheel, the cycle of violence, his numerous anecdotes, personal anecdotes, and relatable anecdotes. But if I'm understanding correctly, you are going to seek for him to offer an opinion that Ashley Benefield was an abused person and Doug Benefield was an abuser. Is that correct?
No, not necessarily. That was for purposes of the hearing that we had. It would be my plan, if he comes in under the Heenum approach to battered spouse, Your Honor, to just have him educate the jurors about domestic violence and specifically ask him about the compliance aspect that would allow a woman to engage in the type of behaviors that the state has raised the issue about and injected the evidence that they have. I could then give him hypotheticals based on facts that were in evidence under the battered spouse syndrome exception, or alternatively, were he to come in just as an expert on domestic violence, I had him review the discovery materials. As the court knows, he submitted to a deposition by the state under the Heenum approach or under just domestic violence expert. The state, as it says in the case law, would have had the option to get their own domestic violence expert. They haven't done that.
My ultimate question was, at one point you asked, can you relate these concepts to a domestic violence situation? Yes. He can study facts and documents. Can you relate these concepts to a situation where you study the facts and documents of a particular case? Yes. But you're saying you're not doing that way. You're doing hypotheticals. He's not going to render any opinions in this case.
Correct.
Specific to this case.
If it comes in, under battered spouse syndrome. That's correct, Judge. I would follow the Heenum approach.
I think it's Hickson. Are we talking about Hickson?
No, I don't think it's Hickson.
I don't know. I would like to address that when I go out. Let's slow down.
Oops. Paper shuffling.
Yeah, it is in Hickson, but the case is Heenum.
My question is this. He spent so much time on these hornbook issues, and the question was asked, can you apply these principles to hypotheticals? But I didn't hear a single hypothetical that's going to be presented, so I could even hear him and consider him and listen and see if he applied the principles reliably to the scenario. So I have no idea, how am I going to make a ruling when I didn't even hear the hypotheticals?
Well, the hypotheticals would be based on evidence in the record.
I understand.
I took him up to that threshold, and I asked him, could you reliably apply these principles to a series of hypothetical questions if asked? He said yes.
So why didn't you ask the hypotheticals so I could hear them and make a ruling?
Well, I would ask the hypotheticals, Your Honor, based on what we know is record evidence. For example.
Exactly. What's in the record? What's been admitted?
Correct. But
is it your position that all 13 of those items have been admitted into evidence?
No.
So I would need to hear the hypotheticals to know what you're going to ask about.
Okay, so I would ask the hypotheticals, Your Honor, based upon shooting the gun in the ceiling. Actually, I would ask the hypotheticals based upon the evidence that the state has presented to create the issue. For example, I would ask, in a week's worth of text messages were to be exchanged leading up to a shooting that show emojis and friendly banter back and forth, would that be inconsistent with battered spouse syndrome? I would then ask, would a woman who shares a child and the husband has a right to joint custody and the woman agrees to go along with the husband when he is with the child, would that be inconsistent with battered spouse syndrome? And he would explain in response to those types of hypotheticals why it wouldn't be, why this issue of compliance exists and is so prominent in domestic violence cases or in battered spouse syndrome cases. I mean, the hypotheticals, I think, are readily available based on what we have, record evidence. Now, I might also add, Judge, we've only called, I think, 2 witnesses, so there may be more that's in the record. But to the extent that I'm interested in it, it will relate to this issue that the state is teed up about acting friendly and not being fearful being in the company of the individual. It doesn't mean that they're not fearful.
Come on.
Once again, Your Honor, I had him review the discovery documents in the event he came in as an expert on domestic violence and was going to speak to that issue.
Oh my God, with the pen. Yeah, we're on speed up speed.
All right, thanks, sir. All right, Steve.
Judge, I guess based on that line of questioning, I'm still not sure what the answer is to your first question, which is this matter of spouse syndrome case or not. I would argue that it is not, that there's been no showing that battered spouse syndrome applies in this case. And I think that's my first argument. As to the hypotheticals that we did not hear today, the state objects to the hypotheticals being offered to this doctor because under Hickson, if this were battered spouse syndrome, which is really all we have for guidance, it would have hypotheticals are available to someone who has not evaluated her. And I think because I know he said he has not evaluated her, but the fact that he read 13 items in this case, he's wholeheartedly familiar with what the defense believes the facts are in this case. And I think it would then be inappropriate for him to be asked hypotheticals based on what is in the record, because clearly he got a lot of things that are not in the record. That's it, Mark. Thank you for letting me be heard.
The bang bang, per my last email, bang on the keyboard.
Okay, anything else we need to take care of before I let you go? When do you plan on calling Mr. Ferris?
I'd like to call him first out Monday morning, Your Honor.
Okay.
For Monday? Is there anything, I did have a question, is there anything in room Monday morning before us, or can we leave some of the things we've been leaving?
I'm not aware of any hearings Monday morning.
Thank you, sir.
Make sure that one's turned off.
All right, we made it through. We made it through. Barely. Barely. Today was tougher than I thought it would be. That one was tough. I'm sure you can tell because the whole second half of today I've been very quiet. But we've been here for 7.5 hours and we made it through all of day 3 and all of day 4. So we are completely caught up now, which shows you how long they take. Mermaid Mary, thank you so much for the super chat. Thank you, Brandi, for speed trial in this case. Many have been insensitive about this case and other chats and shows. Your coverage and chat are the best. Love it here. Hope you and Lucy have a great weekend. Thank you so much. Thank you, thank you, thank you. Deep breath. It helps that in about 30 minutes, less than 30 minutes, I'm going with my kid to the movies. So that always makes me feel better. Get my heart rate back normal again. He wants to go see Wolverine. I have zero interest. Oh, actually, wait. It's Deadpool and Wolverine. Is that the one with Ryan Reynolds? I can go see Ryan Reynolds. Ryan Reynolds ain't bad to look at. And Deadpool was funny. Isn't it the one where it's both of them? So I was just going to go for my kid and popcorn, but Ryan Reynolds ain't bad either. So. Thank you, thank you. My heart rate is still like, oh, is it good? Oh, he'll be excited. We will be live-ish on Monday. They have so many sidebars and they talk so slow. It would be torture for me to be live. I can't do it on this one. But, we will be live-ish. So instead of starting first thing in the morning, we'll probably start about lunchtime. And then that way, by the end of the day, we'll be caught up. But we don't have to watch it in real time where it's so slow. So slow. I will tell y'all Monday what I think. Either way, quality time with the kiddo and popcorn. Can't go wrong there. I will get the stream set up sometime on Sunday, so y'all can hit notify me. We'll probably plan it for right around lunchtime. Because that way we can skip all these breaks and all of that. And lunch, and we can listen at 1.25 speed. We've been listening at 1.5, other than for Ashley's testimony, we put it 1.25. but that way we can listen at 1.25, just because he talks so slow. So slow. And my ADD just starts wandering. What else? We are, Sunday. Trolls are going to hate this. Sunday, I am going to be on Turtle Boy's channel. He he had mentioned my podcast in when I had I mean, anybody that's seen anything on Twitter, you've seen how it's been for me. I am constantly and one of the big things is the people attacking me, it's mostly been because they're like, oh, you're, working with Turtle Boy. I've never been on his show. He's never been on mine. He knows where I stand on things. He knows that he and I are, have different views on things. He knows where I stand on, a lot of stuff, with the, he knows that there are some things about the defense and some things about him that I don't agree with. And that there are some parts of the defense's theory that to me don't make sense. He knows that. I mean, he didn't care. But I have caught so much crap, for just whatever. So anyway, he said something on his show the other day, and he was, and I appreciate everybody sending me the clip. He was talking about the podcast and how everything that has been going on Twitter with just the constant attacks and using my past against me, just on and on and on. So he asked if I wanted to come on Sunday, so I'm going to go on. Yeah, X is bad. X is real bad. X is the worst out of all of them. I have gotten to where I and every time I block them, they make more accounts to come after me. But I post the things I need to post, and if I have notifications from my friends or something, I might look at them. But other than that, I've been staying off of it lately because it's terrible. It's terrible. Crazy. That's crazy. And you know what? I do appreciate him being supportive, even though he knows that I don't that we have different views on certain things. But see, that's the difference. That's the difference. There are things that I have definitely been open about that go against the defense's theory, and the people who are on the free Karen Reed side are still, for the most part, I'd say 95 to 97%, still very supportive anyway. They just agree to disagree on those things, because even though there are some things I agree on, there are the majority of things, as far as the corruption and the issues with the investigation and issues with the, some of the witnesses and things that don't add up, and Trooper Paul being a disaster. A lot of the big things, the important things, I think I agree on. There are some things that I don't, but I don't get attacked by them the way that I do. I don't believe in a huge conspiracy where, a ton of people are involved. I don't. And I don't know. I get it's like if you don't, with the free Karen Reed side, I can still have my own opinions and still, like, my conclusion on what happened is, you know, I don't know what happened. And if there, and that's reasonable doubt. Nothing makes sense to me. And if nothing makes sense to me, that's reasonable doubt. And I cannot imagine voting guilty on someone if I can't tell you beyond a reasonable doubt that she's guilty of what they're saying that she did, and their evidence didn't support it. You know, when you look at Trooper Paul and what he presented, it just doesn't make sense to me. So I'm still arriving at the same, you know, verdict, even though a lot of the stuff that I have questions on or don't necessarily believe are different. But like 95 to 97% are still supportive and cool. But then you have the Karen Reed is guilty group, and it is vicious. It is vicious. It is nonstop attacks. They don't listen to anything you say. It doesn't matter what you say. It doesn't matter if I try to have different points of view on here and, you know, like bringing different, like none of that matters. It's like if you don't say exactly what they want you to say, then they're going to attack your character and attack your business and attack your, you know, family and everything. It's disgusting, which is ironic too, because the whole reason that they hate Turtle Boy is because they say that he does that, but then they're doing it. So it's crazy. It's crazy. So it's finally just pushed me to the point where F them. Terry, this is something I've been saying a lot too. I don't think that anything that the police did, like as far as Proctor and all that, I don't think that any of that was necessarily, and I'm not saying that it's not. I'm just saying that I understand that there still could be a chance or whatever, and that's fine. My personal belief is that anything that happened like that was to beef up their case, not to protect Brian Albert or Colin Albert or whoever. I fully believe that, you know, they had decided she was guilty, and anything that could have been done was done to beef up the case to ensure prosecution. Yeah, Terry's been getting it bad. I woke up from a nap the other day and saw my Twitter blowing up. I don't know that I can do that. I think it's supposed to be 9 Eastern is when I'm going on. Agreeing to disagree and still remaining respectful has sadly been lost in our country over the last decade. It's just getting worse. I agree. It's disgusting. The way that people attack other people for seeing things differently. It's disgusting. Yeah, he asked me if I wanted to come on Sunday and talk about my research on it and my podcast, and so I said sure. Zach, thank you for the super chat. Brady, it's very simple. Lexi the Lexus chewed on O'Keefe's arm, then she spit him out 30 feet away. Hop to a, I mean, you know, even Trooper Paul had like that could, be more believable than Trooper Paul's theory. I'm pretty sure he said Sunday. Yeah, Sunday at 9 Eastern. Yeah, Jen, it's really sad we can't even agree on the facts anymore. That's the thing. Like you are entitled to your own opinions, but you are not entitled to a whole new set of facts. Oh yeah, they're gonna hate it. It's gonna be all, it'll light the fire under them again. And I'm gonna sit back and watch them. I'm not even gonna watch them. That's a lie. I'm gonna sit back and let them yap like they always do. So they're gonna do it anyway. Give them something to talk about. Thank you, Magnolia Gypsy. You are a juror. You're here with us. You are. They Yeah, I took a little bit of time off because it was a lot for a long time. And you know, not just the hours of working, but the hours were a big part of it. Let's be honest. Streaming all day and then working on the podcast. You know, it takes a lot of time. And when you have that on top of the emotional turmoil from the constant viciousness from certain people, like some certain people who were mentioned in the, you know, last jurors filing and stuff like that. Like when you have that group who are just constantly spreading hate, it gets exhausting. So I had to take a couple weeks off from the streaming and stuff because it got to be too much. Too much. Yeah, well, the whole reason that I've kept my distance from Turtle Boy is because he is very aggressive. And he has, he's been an asshole. I told him this. This is not this is not like something that I'm whatever. This is not breaking news. He knows how he is. Like, that's his style. And I've said it before. It is effective. It gets attention, but it is totally opposite of how I am. And because of his aggressive nature, it is effective, but it makes people hate him. So a lot of people, if you start questioning things with the case, they will automatically lump you in and not want to hear anything you had to say. So I have specifically kept my distance from a lot of the chaos because it's, first of all, because it's not what I'm doing. It's not what I'm reporting on. I'm not reporting on the chaos. I'm reporting on the, the court documents and the hearings and what the attorneys are saying and what the, timeline is and all that stuff. Like, that's been my focus. So I've kept my distance to try to have my own research and my own conclusions and not be swayed by anybody else's stuff. And and to try to present the information in a way as to what I see it. And a lot of people, if you question anything, the first time you say anything about questioning anything, it's like automatically like, oh, you're a cult member. I don't want to listen to you. You know, you worship Turtle Boy and whatever. And people who had never heard of him were getting, you know, called cult members and stuff when, you know, so many of the people that think Karen Reed is guilty really just, more than anything, I think hate Turtle Boy. So I think that it has been one of those things where questioning her guilt has, like with a lot of people, has become synonymous with him. So people will automatically dismiss you and not want to hear anything you have to say, not respect anything you say, which sucks because it's like dismissing this whole population of people who can think on their own and don't need somebody to tell them what to think. So it's just crazy. It's crazy. I've never seen a case like this. I thought Melly was bad. I thought that was bad, but no. I've joked about that before. Like the Melly trolls wanted to ruin your day and the Karen Reed trolls want to ruin your life. It's disgusting. It's disgusting. See, exactly true. I never saw anything by Turtle Boy and realized the Karen Reed case was a fraud. See, that's what I'm saying. Like there are tons of people who have come to the same conclusion without having drank the Kool-Aid or whatever you get accused of doing as soon as you say something about it. It's wild to me. It's wild. All right, I am going to get out of here. I have to leave in about 10, 15 minutes, and I want to take Lucy Girl OUT. She's going to hear me and freak out. I'm going to take her OUT. I hope that y'all have the best weekend ever. I appreciate you hanging out and watching with me. Oh, I said hanging OUT and she just... I know. Okay, hold on. I'm coming. Even just saying hanging out, she started doing like this. She's a smart dog. She's a very smart dog. The best part was when they accused many of us of being paid by the defense. Reminds me of my parents with differing political beliefs and myself saying I'm paid by an elitist still waiting on checks. Yeah, I am apparently paid PR. People are morons. All right, y'all. I love each and every one of you. Thank you so much. I know that this was a weird week and we got way behind because it's been such a weird week. But I appreciate y'all speed trialing with me and watching with me. I love you very much. I hope you have great weekends and I will see you. If I don't see you on Sunday, then I will see you on Monday.
Yeah, I gotta go. I can't stick around here forever.
Everybody was wonderful. Everybody behaved. Everybody's always so nice to me.
Just love your channel and
Goodbye, good people. Now, how the heck do I get out of here?